everyone. Welcome to the Wednesday, July 7th meeting of the City Council of Evanston's Rules Committee. We have a quorum, so I can call the meeting to order. Would someone make a motion with respect to suspending the rules?
So moved. I move that we suspend the rules to allow for remote participation due to an executive order issued by Governor J.B. Pritzker.
I will second.
All right. Ms. Franchella, would you call the roll?
Councilmember Kelly? Oh, sorry. Councilmember Kelly? Here. Councilmember Braithwaite?
Here.
Councilmember Wynn?
Here.
Councilmember Nusma?
Aye.
Councilmember Burns?
Aye.
Councilmember Sufferton?
Aye.
Councilmember Ravel?
Aye.
Councilmember Reed?
Okay.
Aye.
Councilmember Fleming? Mayor Biss?
Aye.
All right. The first item on our agenda is public comment.
We have Ray Friedman, who is here in person.
Welcome, Mr. Friedman.
Good evening. Thank you very much. Before I read the public comment, I just wanted to give you a quick FYI that it took me 30 minutes to sign up for Rules Committee today. No notice was given for this meeting and couldn't sign up through the login page. I gave Dar a copy of the sheet that says you couldn't sign in. So you have to call or send an email to sign up to even make public comment. So I don't know why this problem is going on. It's been going on for several months, that we are not noticed of meetings, whether it's city council, ward meetings, whatever. Please do not vote on any issues listed on tonight's agenda until there's been discussions and input from and with residents. Okay, so for my public comment, good evening, everyone. Hope everyone had a good holiday weekend. Would like to start by saying it looks like we have a failure to communicate. My first question is, why is the last Rules Committee 2 weeks ago not properly noticed? The only reason I knew about it is somebody told me. Maybe that's why I was the only person here, and again today. Someone also told Mary Brzezinski, who was on the Zoom meeting 2 weeks ago, and somebody told her. That's the only reason she knew about it. So only 2 residents for an important Rules Committee meeting. Why is this? It appears Rules Committee is the most important aside from City Council. And last Rules Committee 2 weeks ago had a bunch of changes with new committees, new rules, no proper notice to residents. Shouldn't all of the proposed changes be brought to the residents for discussion before any changes are voted on? I know you've heard me and others talk about public comment and the purpose and intent behind it. It's clearly written in every public comment description. It is intended to create a dialogue. You know what a dialogue is. The law mandates public comment. Unfortunately, it does not mandate that we get a response or a conversation with council members. We keep hearing about you're wanting to get resident feedback, but we really need to get feedback from all council members concerning our public comments from all meetings. At last Rules Committee, my alderman, Peter, pointed out the discussion starts at committees, and I guess for the members of those committees that's true. But my question was, and still is, when, where, and how do the residents, when are the residents included? So we're not trying to create a problem, only trying to resolve the issue of leaving the residents out of the discussion and decision-making process. I want to thank all of you who are talking about transparency and accountability, and would like to repeat a quote from a public comment that I read on 5/24 at City Council. On that date, I said, "Thank you, Mayor Biss, for starting your new ad hoc committee. Your, excuse me, your words are very encouraging. When you spoke of public input, that this work cannot be successful without meaningful and significant public input beyond what's achievable through state-mandated public comment sessions at our meetings, and that you would be open to anything, be it public town hall meetings, smaller roundtables, distribution of surveys, or whatever would work. So after 5 ad hoc meetings, what is the plan for public input,
Mr. Friedman,
as you have referred to?
could you wrap it up, please?
Yes, absolutely. Thank you. Lastly, thank you for all the new and improved and lively ward meetings. Still disappointed that some ward meetings are held on the same day as others, same day and time. Can we please have all ward meetings recorded so that residents can at least hear what they've missed in all wards? I don't understand why residents are consistently being left out of these important discussions and decision-making processes. Thank you to all of you for your time and effort in trying to make Evanston a better, safer, more economically diverse place to live and work. And please, let's put the mayor's words into good use. And the
Thank
public
you.
participation ordinance would be a great place to start.
Thank you, Mr. Friedman.
Thank you.
Next, we have Mike Vasilko on Zoom.
Mr. Vasilko, are you here?
Can you hear me?
Yes.
So hopefully I can get through all of my comments. I sent some of them in advance, but I'm going to touch on them. R1 on the Code of Ethics and the Board of Ethics. I'm not comfortable. I hope there's a couple of board member or council members that are going to ask, as Mr. Freeman just said, ask that this be tabled because I think it's just too big of an issue. I'm not comfortable with eliminating the Board of Ethics as it's proposed, substituting a special counsel. It just seems not independent enough. If the mayor appoints, the city manager more or less oversees because of the law department and everything. That's a bad idea. It should be revisited. I'm also asking that a rule be added to the rules of the Board of Ethics or the Code of Ethics, that every alderman or every council member who oversees a ward has to have ward meetings every month. As Mr. Friedman just said, there's some members are actually doing their work, inviting their constituents to meetings. The 6th Ward hasn't had a ward meeting in 6 months, and there's nothing on the calendar for month 7 next month. I think it's reprehensible. I wish there was some process to recall an alderman for not conducting ward meetings. On R4, a couple of suggestions. I would amend paragraph 6.5 to add a rule that city council members and the mayor must respond to questions posed during the city council by members of the community during citizen comment. Everyone who ran for office this year said they were going to improve on this, and it's been a failing grade from day one. I'm also asking that the city council members add a rule that requires every council member to regularly inform their constituents on all pending actions. It would be nice if they did that before the council meeting at a ward meeting. For these Zoom meetings, the chat function should be activated, not deactivated. Signs for those who attend the city council in person should be the restriction to an 8.5 by 11 or postage size stamp size sign should be recalled so that we can bring any size sign we want to bring to a council meeting.
Mr. Vasilko,
On R2,
Mr. Vasilko,
R3,
please
the city
wrap up your
clerk is
remarks.
supposed to be an independently elected office, not overseen by the city council, not overseen by the city manager or anybody else. That office should have all of its FOIA responsibilities returned to it as they were before the previous council
Mr. Vasilko.
stole all of those.
Mr. Vasilko,
I'm not quite done yet.
I'm sorry, your time is up.
the budget for the city clerk's office to a proper funding and staffing. Again, return all FOIA activities. I'm not sure why the city clerk is
Thank you,
not
Mr. Vasilko.
in the new list, why the city clerk is not called out to be the FOIA officer. The city clerk should have all FOIA responsibilities.
Mr.
I just want to jump
No, Mr.
ahead to
Vasilko,
the
I've
powers
given
and
you
duties
extra time.
of the Rules
And
Committee.
we've all received your
where-
email today. Mr. Vasilko, your time is up. Thank you very much. We're going to move on. We're going to move on to the next public speaker. Thank you.
Next, we have Tricia Connolly.
Hello. I want to speak about R1. And I really am looking for some leadership from our city council to vote to keep some independence with our ethics board and do that on behalf of the citizens of this city. I think this is a great time for some reflection on the last 4 years. And I would encourage staff as well as our city council members to actually reflect on the culture of the last 4 years and why there were so many complaints and what the nature was of those complaints. Having an independent body to hear complaints is important on behalf of all of us. And rather than saying it didn't work well, we need to strengthen it. Thank you for your time.
Thank you. I believe that concludes our public comment. So our first item tonight is, well, first we need to approve the minutes. Would someone make,
Chair Wen, I'm sorry, this is Alderman Fleming. I'm down here, not on the
Sorry.
screen.
Oh, I see.
I'm sorry, can I just make one comment in response to public comment? I know we don't usually do that. And I've said this before, but I think it's really important, particularly to Mr. Freeman's comment. So ward meetings are held, you know, a combination of the convenience of the alder people and their constituents. And as you know, this is not a full-time living wage job, and people frequently have lots of meetings just for this job alone. And so, you know, I hold it at a time when I hope is convenient for the Ninth Ward residents who I'm elected to represent and hear from. And so I appreciate that other people do want to come, but my oath and obligation is to the Ninth Ward first and foremost. And so I know you continue to mention about conflicting times and dates, and I just can't live my life and schedule based on the other people up here. And so I have to make the ward meeting that fits, first of all, into my own life schedule and then that of my residents. And so if it conflicts with other council members, I really can't do much about that because I also have a life that I have to manage. And then the point about the recordings, I've also said this before, I do not record my ward meetings because it's really a time for me to hear from my constituents. And if they have a complaint or concern or comment, for me, while it's not totally private because it is a public meeting, it is also not something that I think they're coming to my meeting expecting to then be on YouTube or wherever else these public meetings might be broadcasted. So there is a piece of privacy, for lack of a better term, that I owe to them. And so, I don't take minutes. I'm happy to talk to a constituent who can't make the meeting to tell them what we discussed. But, people who come to my ward meeting to voice whatever concern they have a right to do that in the space of the people who are there and to not have that broadcast and take out of context on some other medium. So I just think it's really important that the narrative, at least for the Ninth Ward, and I'll take liberty to speak for other people, is not that we are not trying to be available when we have ward meetings. It's that we kind of plan and host ward meetings at a time that works for a multitude of things, and that might conflict with many other meetings in the city. It is not to exclude people, but it is simply kind of based on the schedule that we have as individuals. So hopefully that can be respected and understood. And if you have a question about something happening in Ninth Ward, you can't make the meeting, you're happy to email me and I can fill you in, but I'm not going to ask a staff to record or ask a staff to stay and take minutes for the benefit of folks, particularly who don't live in my ward, but when I can do that myself, because our staff are also working a lot in the evening hours. So I'm sorry, I've repeated this several times, but I do want to continue to say it. If there's another communication problem with, our staff not getting out minutes or notifications, that is another thing that is definitely valid. But in terms of the Ninth Ward meetings, they'll continue to be for me and my ward primarily. Anyone else who comes can speak, but my oath and dedication is to the Ninth Ward.
Thank you. Councilmember Braithwaite.
And thank you, Chairwoman. And I also want to take a moment of privilege and a point of information, not for everyone behind the dais, but anyone that's listening. And so, Mr. Friedman, we've had this conversation before, and that is any public meeting, you or anyone else who's paying attention can find it on our city calendar. And we vote on these meetings like our very first rules meeting. Anyone can go to the City of Evanston calendar, pull up August. So there's a meeting date right here. I'm looking at it. August 2nd is going to be our next rules meeting. It's right here, www.cityofevans.org. And I mean, write this down, because the next time you say it, I'm going to talk about it in public. City of Evanston Rules Committee, it's right here on our city calendar. Just like all the other meetings that we have, you can click on that meeting and download it to your personal calendar, then that way you don't forget. So for those of you who are paying attention, if you don't want to go to our city calendar, you can go to our city website, Mr. Friedman, and go to email and text updates. So you put that in the search engine for any meeting, any topic. You can get email and text updates as well as sign up for the newsletters. And you probably don't want to approach the dais right now, but thank you.
30 minutes to sign in.
I understand. So again, for our public, City of Evanston's calendar, in order to get meeting dates, you can download that to your personal calendar, and you can also go to our website to sign up for email and text messages. In addition to that, for those of you that are interested in items, we have two places that you can get notifications for. One is newsy items that are put out by our city manager before every city council meeting. And then you also can look at our city manager's, can you correct me, Kelly, it's our city manager's report, correct? That you can find on our city website that will project out all of our referrals as a way of paying attention. So I don't mind meeting with you, Ray, after this meeting to go over that again in person. But for anyone listening, I just want to make it clear to them that we don't meet without proper notification. Madam Chair, thank you very much.
Thank you, Councilmember Braithwaite. Councilmember Kelly.
Why did it take 30 minutes to sign up? Yeah, what was the?
I think, I think if we could, hold on, Mr.
First of
Friedman.
all,
Hold
okay,
on,
go ahead.
please.
Go ahead. I'm sorry.
I think we should ask either the city clerk or Luke Stowe to look into this and contact Mr. Friedman and find out if there was a glitch tonight, because that has not been the case. We have not heard this from any other person. So if you could perhaps meet with Clerk Mendoza right now.
It's a simple answer. I have a very simple answer. I called, I talked to Eduardo. Eduardo said, I'll transfer you over to 311 and they can sign you up for public comment. I talked to a nice gentleman, Don or Dan, and so he signed me up for public comment. I said, was this meeting noticed? No, this meeting was not noticed. I said, why not? He has no idea. Okay, I asked Eduardo the same question. Was this meeting noticed? I said, please, Dan, tell me, am I signed up for notices? He said, yes, you're signed up for all the notices. Okay, so why am I not receiving the notices? Whether it's ward meeting, city council meeting, or I'm supposed to get all the notices. As long as I'm getting...
As long as you're, I'm sorry to interrupt you. You know, you have to check to receive the third ward news and announcements, so.
I checked the calendar, I did first.
No, you have to go, I mean,
I'll
deliberately.
take them. I'll take
Okay,
time and.
Yeah, okay.
I was there.
You have to select all of the ones you'd like to receive.
Oh, I did that. I did that 4 times. I listened to Cicely Fleming, and she said, check,
Okay.
re-sign in. I did. I re-signed in, I checked, and he checked with me. He went
Okay.
through every single one. He said, you're not signed up for fire, whatever. You're not signed up for this. I said, okay, it's fine.
Okay,
But
Mr. Friedman, I
30
think
minutes later-
Clerk Mendoza is very happy to help you and figure out what the glitch was, okay?
The glitch is on your end. The glitch is not on mine.
Okay, if there is a glitch, perhaps she can let Clerk Mendoza to troubleshoot with you to see what the problem is that you're encountering. All right, everyone. Could someone make a motion to approve the minutes of April 12th, of the Rules
move.
Committee of April 12th?
I move approval of the minutes of the April 12th meeting of the Rules Committee.
Is there a second?
I will second.
Ms. Francelno, would you call the roll, please?
Councilmember Kelly?
Here.
No,
Coun-
it's approval of the minutes.
Aye.
Councilmember Braithwaite? Oh, he stepped out. Councilmember Nguyen?
Aye.
Councilmember Nusma?
Aye.
Councilmember Burns?
Aye.
Councilmember Sufferton?
Aye.
Councilmember Ravel?
Aye.
Councilmember Reed?
Aye.
Councilmember Fleming? Mayor Biff?
Aye.
Minutes are approved. Thank you all. All right, so now we're going to move on to items for consideration. I will do my very best to keep an eye on all of your lights here. So our first item of consideration is R1, and we have a public speaker here to speak on this. Why don't we hear from our public speaker first? Councilmember Kelly, would you like to introduce Mr. Berlin?
Sure, thank you. So I'm really happy that this evening we have Mr. Steve Berlin from the Chicago Board of Ethics. He's the executive director of the Chicago Board of Ethics and the immediate past president of the Council on Government Ethics and Laws, and one of the most foremost experts on government ethics. So he's here to talk a little bit about ethics and local government, as well as field some questions from our city council. Thank you.
Thank you. Mr. Berlin, are you with us via Zoom?
I am indeed. Thank you all very much. It's an honor to be with you and with the honorable members of the City of Evanston's Rules Committee. And by way of background, I can say that I grew up in neighboring Wilmette, and I'm a New Trier grad, class of 1976, but that's way in the past, many lifetimes ago. I wanted to make a few comments really about best practices in municipal ethics. And I've been at my job with the Board of Ethics of the city since September of 1993, so that's almost 28 years, which is rather amazing. I've been the executive director since December of 2008, when then Mayor Rich Daley appointed me. And over the years, I've learned that there are basically 4 cornerstones of a good municipal ethics program. The first is, and I would say it's the bread and butter of a good ethics program, is the ability for persons subject to the ethics code, city employees, city officials, both appointed and elected, everybody who's subject to the ethics code. In Chicago, that includes vendors to a certain degree. It includes members of the public if they're involved in a specific situation. But the ability to call and ask for confidential advice before somebody takes action. That's a critical thing. And that's really the bread and butter of what my agency does, because our basic philosophy is that it is better to educate people in advance and have them call us in advance so that we can say, yes, you can go ahead and do that, or no, you can't do that, or you can do that if you do it this way or that way. Our goal really is to keep people out of trouble. So advice and guidance is critical. And I've got a staff here of 3 other lawyers. And that's we spend the bulk of our days answering emails and answering telephone calls. As I say, it's about 4,000 a year. The vast majority come from city officials and city employees, and they can be complicated questions. In which case, if it's a question that requires legal research, or it's a question that applies maybe to all, it's got general application. Then what we will do is we will do a draft opinion and send it to our board. And at the next meeting, or it may not be the next meeting, it may be the meeting after that, we have one opinion that's been going on now for about 2 to 3 months because there was pretty vehement disagreement among the board members. But the board will issue a formal advisory opinion. And we do that probably about 10 to 15 times a year. And that's one of the critical functions that our board provides for citizens and for city employees and city officials, people who want to make campaign contributions, et cetera, advice and guidance. I will add that it is confidential, and this is critical too. In other words, when people call us, we keep the fact that they called us and the nature of their question and the nature of our answer confidential. And we don't disclose to their boss or to Mayor Lightfoot or to the city council or to the press that so-and-so called us for advice. A person can waive their confidentiality, which is rare, but they could. And if they waive their confidentiality, then we will make limited comment about what they asked about. or we can confirm or deny that they came to us for advice and what that advice was. And this is, I would say nationwide, this is probably the most important thing that a Board of Ethics does, is to give it confidential advice and guidance. The second important pillar of a good ethics program is enforcement. Now, the history of Chicago's Board of Ethics ranges a little bit. We were an investigative authority until the second year of Mayor Rahm Emanuel's term, when there were some changes that were moved around. We are no longer technically an investigative agency. What we do have is a working relationship with the city's Office of Inspector General. And the Inspector General is able to receive complaints and investigate them. It is also able to initiate investigations on its own. And when the Inspector General completes an investigation and believes that there have been one or more violations of the city's ethics ordinance, and our sole role in city government is to interpret, administer, and enforce the city's governmental ethics ordinance, which is a specific chapter in Chicago's municipal code, just like it's a specific chapter in the Evanston City Code. The Inspector General will turn over its completed investigation and all of its corroborating evidence to my office. And then I will assign one of my attorneys to do a deep dive into the IG investigation. Usually the evidence is documentary evidence, it's interview transcripts, there may be some other types of evidence that are included, photographic evidence, et cetera. It's usually contained on a CD-ROM. And it usually takes us about 3 to 4 weeks to do a deep dive. And at the end of that, the attorney makes a recommendation to me, and then I make a recommendation to the full board, which meets once a month. And I'll get to who's on our board in a couple of minutes. And the question for the board is there probable cause to believe that the individual who was investigated by the Inspector General may have violated the ethics ordinance? It's a pretty low legal bar. It's really what a reasonable person looking at all the evidence that was adduced conclude that there was a violation, or that there might have been a violation. The answer is yes, which it should be yes. Then the subject of the investigation is entitled to come in and meet with the Board of Ethics with an attorney present. Nobody from the Inspector General is there. Nobody from the city's corporation council is there. It's just the board staff and the board members. And they and their attorney can try to convince the board that they did not violate the law. In other words, board, Inspector General didn't ask us about A, B, and C. Here's an argument why we believe we did not violate the ethics ordinance. And if they can convince the board that there was no violation, then the board will throw out the case and it remains confidential. On the other hand, and this often happens, if they're unable to change the board's mind, then the board will make a formal finding of probable cause and has the authority to enter into settlement negotiations with the individual. And the board has the authority to enter into three-way settlement agreements, which would be, for example, termination or employment sanctions, like having somebody suspended for 15 or 30 days without pay. That's pretty rare. Normally what happens, it's also very complicated because you have to have the department's buy-in and you actually have to have the subject's buy-in. That's why it's a three-way agreement. Normally what happens is that the board just simply issues fines. And in my judgment, the fines in Chicago's ordinance, they've been changed around a little bit. They're still not great. The maximum fine for just about all violations of the governmental ethics ordinance is $5,000 per violation. Our colleagues in New York City, for example, have fines that can go up to $25,000. And I think that would be a much better model. But be that as it may, the board can enter into a settlement agreement where the subject admits the facts. They may or may not admit that there was a violation. We're not really as concerned about it because the agreement becomes public and their fine becomes public. And then we use those as precedent. On the other hand, if the board, wouldn't be the board, if the subject believes, even though they have not rebutted the board's probable cause finding, that they are still, quote, innocent, then they can have their day in court. And this is where an administrative hearings officer comes into effect. This has only happened once in the almost 10 years that we've had this regime. The person can petition, it's an automatic right, actually, but they have to file a formal petition for an administrative hearing, in which case our colleagues in the city's Department of Administrative Hearings will assign an attorney who's under contract with the DAH to hear the case. And that attorney serves as an administrative law judge, an administrative hearings officer. That attorney will conduct, or that judge, effectively ALJ, will conduct the hearing according to relaxed rules of evidence. And at the end of that hearing, will submit back to the board their findings of law and their findings of fact. And then the board can either accept or reject them. The key principle here is that only the Board of Ethics can make a determination that somebody violated the law. Nobody else can. The Inspector General cannot make that determination. The Administrative Hearing Officer cannot make that determination. All both of those agencies can do is make recommendations. In the end, it's up to the board. And this has happened where the board receives the ALJ's final report, and the board can either accept it in part or reject it in part. It can accept it in full, it can reject it in full, which has not happened. But the board is not bound by it's bound by the factual record that was adduced at the administrative hearing, but it is not bound by the ALJ's findings or recommendations. If the board makes a finding that there was a violation of the ordinance, that finding becomes public, as well as the appropriate penalty that the board assesses based on all the equities in the case. That isn't necessarily the end of the matter. It becomes public then, the violation becomes public, but then the subject has the right to file a petition for certiorari with the Cook County Circuit Court. And effectively what they're saying is to the court, hey, we believe the Board of Ethics misinterpreted its own law. We would like you, Chief Judge of the Chancery Division, to assign a judge to hear this so that we can plead our case and get the judge to reverse the Board of Ethics' finding. Well, that's never happened. And frankly, I don't think it's going to happen. One would never know whether it's going to happen because courts generally give great deference to administrative agencies when interpreting their own laws, just a basic tenet of administrative law. So what I would say is that best practice is that you have a board, not an individual, but you have a board that hears all the evidence, whether they hear the evidence from witnesses directly or they hear the evidence in the form of a report that's been compiled by an administrative law judge, which is how they do it in New York City. That's pretty much what our model is based on. And it's not a perfect model, but it's a pretty good model, and it approaches best practice. That's best practice. In other words, you don't want one individual determining that somebody violated the ethics ordinance. I suppose if a case ever went to the circuit court, you would have a judge that would make that determination. But at the administrative municipal level, in my opinion, it is best practice to have a board, a citizen board, that makes these decisions. And our board itself, by statute or by ordinance, has up to 7 members. We have a vacancy right now, so the mayor's office, I'm hoping in the next couple of weeks, will announce that vacancy is being filled. We have, our chair is a fine man named Bill Conlon, who was a retired partner at Sidley and Austin. He was a litigator at Sidley and Austin for about 40 years, I would say. And then before that, he was an assistant, maybe not 40. He was an assistant U.S. attorney in charge of the Civil Prosecutions Division. So he's a very experienced trial lawyer. And we have, right now, we have 5 other members of the board, not all of whom are attorneys. We have a couple of lay members of the board. It's very helpful to have their perspectives as well. Board members, by the way, are as independent as any agency is in the city of Chicago, meaning that the mayor appoints them. And oddly enough, all of our board members right now were Emmanuel appointees. They serve staggered 4-year terms. Obviously, the next board member, or the next 2 board members perhaps, will be Lightfoot appointees, but they serve staggered 4-year terms, and they can be removed only for cause, with the written consent of the other board members. So my position also, by the way, there's a long history to my position that I will not bore you with, but I am also a mayoral appointee with the City Council confirmation. So when I was appointed to my position in December of 2008 by then Mayor Daley, neither subsequent mayor has required me to go through a reconfirmation process, for which I'm obviously very grateful. But my point here, though, is that in my opinion, it is best practice that you have a citizen board I'm not aware of any other boards in the United States at the state level or the municipal level where they're elected, but they are appointed. Obviously, at the state level where you have opposition parties, you may have structures where, each party gets to appoint, let's say, 6 members or 3 members, and then the governor or a blue ribbon panel will appoint the 7th member, so that, in theory, you have a way to break ties and it's not partisan. Obviously, at the city level, partisanship is really not an issue. The third basic function that we have, and the third basic cornerstone of a good ethics enforcement regime, is public disclosure. I'm sure that most of you know that probably most of you have filed statements of economic interests with the Cook County Clerk's Office, Karen Yarbrough. Interestingly enough, I checked their website just a couple hours ago. It's down. We have in the city of Chicago, we have about 3,100 city officials and city employees who filed the form with Cook County. But we also have, and have had since this ordinance was enacted in 1987 when Harold Washington was the mayor, we have our own statement of financial interests, which about 3,700 to 3,800 city officials and city employees file. And it's twice as long and much more detailed. And it's also, in my mind, much clearer to understand than the statement of economic interests, which about 165,000 people, including me, including probably many of you, file with either their local county clerk, if they are a municipal employee, or if they are a state employee or a University of Illinois system employee, then they file it with Jesse White's office, with the Secretary of State's office. It's all based on the same law. But in my opinion, financial disclosure in some form is a necessary component of a good ethics regime. My opinion is that the statement of economic interests, which has been on the books since 1971, it's never been amended. My opinion is that it drastically and badly needs amending. In fact, about 10 years ago, when Sheila Simon was the lieutenant governor, she formed a working committee on which I was privileged to serve along with some of her staff, with some staff from the Secretary of State's office and a couple of law professors, and 1 or 2 people, I think, from the good government community. There was somebody from the BGA and somebody from the Campaign for Political Reform, which is now Reform for Illinois. And we came up with what we thought was a very outstanding form with 8 questions. Now, I know that starting next year, our colleagues in Springfield have revised that form. It's still not, in my mind, anywhere near as good as Chicago's form is. And our form, by the way, is public. You can take a look at what I have filed for the last 7 or 8 years. So I would say that regulation is a critical part of an ethics regime. And I remember several years ago, I came up in person, pre-COVID, obviously. It was actually 2 years ago. It was in July of 2019. I was privileged to be invited up to your city hall. And I spoke with a couple of members of the Board of Ethics about a lobbying ordinance. I'm not going to get into that, except to say that it can get very complicated, and we've been dealing with our not-for-profit community in Chicago for about the last 15 or 16 months on trying to work out something that is acceptable to them, but also includes transparency for the citizens of Chicago. But I lump public disclosure, whether it's ethics statements or lobbying, into that third cornerstone of a good ethics program, which is regulation. And the fourth basic component, which ties in really with all 3 of these, and in some ways one could argue it's the most important function, is education. So that we at the Board of Ethics of Chicago every year put out an online ethics training program, which is required of all 32,000 or so city officials and city employees. Everybody from Mayor Lightfoot to the 50 aldermen to the 650 people who serve typically as volunteers, including my board members who serve on city boards and commissions, as well as the other 30,000 or so city officials and city employees who serve in all the operating departments: fire department, police department, streets and sanitation, Board of Ethics, law department, et cetera. We also, since 1997, have had in-class training. Obviously, we've had to suspend that because of COVID, but we're going to pick that up again over the next couple of months. But to summarize then, as far as best practices go, in my opinion, and I believe in the opinion of my Kogel colleagues, my Council on Governmental Ethics Laws colleagues, best practice is to have a board that actually adjudicates whether people have violated the law. Whether the investigations are conducted by an arm of the Board of Ethics itself, or, which is true in a lot of jurisdictions, it used to be true in Chicago, or it's conducted by an inspector general, which has full subpoena authority, et cetera. That's a different question. I have my own personal opinion on that, but I'm not going to bother you with that. But it's critical to have the ability for the board itself to hear all the evidence and to make a decision, not to rely on a single individual who is an administrative hearings officer. Because the reason is that with a board that serves on a monthly basis, obviously you get institutional knowledge. And board members have heard from enough witnesses and enough subjects that they can usually tell, their meter goes up when they think that somebody is feeding them a line. And certainly the staff helps as well. So, in conclusion, I would say that in my opinion, it is best practice to have a board that at least has some, if not all, of those four basic functions: advice and guidance, enforcement, meaning that only a board of ethics can determine whether somebody is in violation of the law, not the investigator, because the investigator is obviously biased. If an investigator or an investigative agency spends a year and a half, 2 years on an investigation, it's highly unlikely that they're going to make a recommendation that there was no violation. They would have made that conclusion earlier on in the investigation and then stopped the investigation so as to move on to other investigations that are juicier, frankly. The third basic function is regulation, which means public disclosure. And the last basic function is education. So with that, I think I'll open it up to questions from all of the honorable.
Thank you.
Rules Committee members.
Mr. Berlin, thank you very much. I think that there are many aspects of what you just said which have been part of Evanston's ethics code and our Board of Ethics over time. We have run into some problems with getting enough members, citizens to serve on our Board of Ethics, problems with quorum. We have problems with ex parte contact. We've had problems with the board being politically pressured over time. And I'll also say I'm the most senior member of the council at this point. There have been many times where the Board of Ethics has not met for 4 or 5 years in a row because there have been no questions and there have been no complaints filed. So it's many times they don't meet traditionally they have met very infrequently. So I think part of the interest in having a hearing officer hear these cases is, and this is why I'll just say that I'm in favor of our new proposed ethics ordinance, is because we don't have a quorum problem. We'll have timeliness. Anyone who files a complaint will have a hearing date, and anyone who's had the complaint filed against them will know that the complaint will be timely heard. The hearing officer is an administrative hearing officer who hears administrative cases regularly here in Evanston. So actually, they probably have better antenna than a Board of Ethics that meets perhaps once a year, if not that. So that's part of our reason for rewriting this, is because our Board of Ethics was not functioning. And so we needed to find a different system that provided proper due process and in an open, professional, transparent way, because we had problems with our prior Board of Ethics not having professional expertise. But I have one, and we do have financial disclosure documents here within Evanston, and of course we all file with Cook County, as do everyone who's part of the sits on a board or commission here in Evanston. That occurs obviously, and one of the things I did want to ask you is, does Chicago pay for the officials who are brought up before the board of who pays for their attorneys?
They do. The subject pays for it. So in one case that went to a hearing, it was actually against an alderman. And the alderman hired his own attorney.
Okay.
So the city indemnifies and provides defense if the city itself is sued. Example, in 28 and a half years, with almost 28 complete years, we were never sued at the Board of Ethics until about a year ago. And now we have several lawsuits pending against us, one of which is actually, I've been sued in a personal capacity, as an interorum kind of thing, for defamation. And I understand from my colleagues at the Attorney Registration and Disciplinary Commission that you have not lived in this business until you've been sued personally for defamation. The city of Chicago is providing our defense at its expense. So they are. I was allowed to hire an outside attorney that's representing me personally, and the Corporation Council itself is actually representing the board. So So the short answer is people hire their own attorneys. So if they were the subject of an IG investigation, it's likely that they had an attorney during that investigative process, and typically that's the same attorney that would represent the person before us and before an administrative hearing officer if the case goes to a hearing.
Yeah, I'm looking for council members to turn on their lights. I think one of the things that obviously the enormous difference is the difference in size. So Evanston has approximately a little under 800 city employees, and you were saying the city of Chicago has 32,000?
Approximately. It's a moving target, but it's about that.
And that you issue 10 to 15 advisory opinions a year?
Formal advisory
Formal
opinions.
advisory.
We issue more than 4,000 informal advisory opinions. So.
Okay, yes. So clearly the complexity of the city of Chicago's and size of the city of Chicago's government keeps your office very, very busy. And I think that we don't see quite that scale of issues here in Evanston. So what we're trying to do is tailor this tailor an ethics ordinance that fits our size and our budget.
Chair Nguyen, this is Corporation Counsel Cummings
Yes.
joining the Zoom because I am out ill. And I had a couple of questions for Mr. Berlin if no other members of the council have their lights on.
Actually, we do have two members of the council who have turned on their lights, Mr. Cummings. Let me call on Councilmember Fleming first. Okay.
Yeah, so my question has to do with, there were two things. One was, I know you mentioned the 7 people, but kind of what is their background on the committee?
Sure. Sure.
Really, if you can do it really brief, because.
Yes. Let me just take off my wall here, my list of board members, and I can tell you. Our chair, as I mentioned, is Bill Conlon. Bill is he's now retired, which is very good for us because we're his job. He is the chair, and he's actually up for reappointment.
Yeah, if you could just tell me their educational background or professional background.
He's a lawyer.
Okay,
so
perfect.
he's a lawyer who I believe is a graduate of the University of Illinois Law School. We have a fellow named Zaid Abdul Alim, who is an investment banker with Mellis & Company, and I think he's a double Duke person. We have Dr. Stephanie Cox-Batson, who is a practicing OBGYN, and Stephanie, I believe she's a Washington University med school grad. David Daskell, who is an attorney, but not a practicing attorney. He was, but he's been in the software business for years. I believe he's an NYU law grad. We have a Dr. Daisy Lozama, who is, she is the assistant director of the National Youth Advocate Program, or NYAP. I can't remember where her PhD is from, but she has a PhD in not social work, in education, I believe.
We'll forgive you for that.
Pardon?
We'll forgive you for that. If you could just give us.
Yeah, okay, so I get that. That's enough. That's plain. I get the gist.
And then our last member is Barbara McDonald, who is a lawyer, and she was a judge on the in the law division in the Circuit Court of Cook County for about 12 years.
Okay, so we've wrestled with this and kind of the background that people need to have to be able to do this in in a way that makes sense for them and for the residents. But my other question has to do with when you mentioned the internal piece, and so staff can come to the ethics board and ask these different questions. You know, with our size, I could see that being maybe something that our staff want to do, but given that these would be residents, right, and they're volunteering, kind of how does that work? They must come to a staff you all have?
Yes, we've got an 8-person staff.
Okay.
And actually, we have one vacancy that we've just made an offer to somebody. One of our attorney positions was vacant for a few months. We just made an offer to somebody who accepted and will start on August the 2nd. So we have a full-time staff of 8 people. In the glory days of the Board of Ethics, back before 9/11, 1999, 2000, we actually had 12 full-time equivalent positions.
Okay.
And then after 9/11, everybody's budgets got cut. Anyway, so the staff works obviously every day. The board meets once a month. So the board hears questions that are of importance enough so that we want to issue a formal opinion. Either they're factually very complicated, or it may be a very high-profile case, or it's a case that has importance. It's a new question that our board has never addressed before. And we have 925 formal opinions that have been issued by our board since Harold Washington's days that are all on our website.
Okay. I'm going to jump in again here because we've been on this one topic now for an hour, I realize. So I guess my point to that was that if we have a citizen board, which I do believe we need to have citizen voice in this process somewhere, and we don't have a staff, I guess speaking to my colleagues, I do like the piece about having an option for our staff to come and ask someone a question, particularly if it's, you know, a confidential question they don't want to ask their boss or our legal staff. But I guess I'm just not sure how I can't visualize that now, given either one of the options we have, our old board or with this new proposal. But I do think that that's something I would love for us to kind of think through as we refine our board. But to what I have in front of me for tonight, I do. And I've talked to Mr. Cummings about this. I do think that having some citizen piece makes sense. I don't, I know that there was some struggles with the last board. And so before we have any board, I think it makes sense for us as a council to make sure they're equipped to do the job we've asked them to do with the supports that they need. And so, that's one piece. But the other piece is that, that they are not put in a situation where they are being yelled at, which is what happened to the poor gentleman who I put on the board for a couple times, which is a variety of other issues in place there. So this one person kind of prosecutor or special prosecution, or whatever we're calling them, makes sense in my mind for one piece, but they also ultimately work for us. They're paid by us, as does the administrative adjudication. And so I realize for an ethics board, that takes out the piece where people feel like they really have a fair, unbiased chance to have their case heard, by their peers who would be citizens. And so, I would love it if we had some more combination of that. And so somebody who can actually do the investigation, because this 3 or 5 person board we have, probably doesn't have the time or the wherewithal to do a thorough investigation. So they do need that support. And I would like that to not be our, legal team, but to have everything kind of brought in-house, I don't think also really, to me, signifies a clear ethics board, right? Somebody that is totally not biased to the council or to the people who are paying them. So I think I spoke to Mr. Cummings about having some other kind of citizen piece, so this investigator can do their piece and maybe take the case and all that, but then they are reporting to an ethics board, and the ethics board definitely has a role in that final determination once they have all the facts. And I do think we need to have this open so that everyone can kind of come and give their testimony. I am not sure that the administrative adjudication is the best place to do that. I do think that, that is what we have now. And so I'd be happy even using them in the meantime, because I would like us to get something going now so people can actually access the ethics board if they have a complaint. But I do think we are kind of still, I would like for us to work through this a little more to figure out where we can add the resident voice in, and I would love that to be, hearing the facts, working with this, prosecutor, whatever we're calling this person.
Special counsel.
Thank you, too much SVU. Working with a special counsel to hear the facts, make the determination, look at that, if there's going to be a fine or whatever, kind of having a role in that piece, I think makes a lot of sense in my mind. because just too much internal is not an ethics board. It just looks like an extension of city council. And I'm just really not familiar enough with administrative adjudication. I have come a few times, and I will say that no one who I have seen as a citizen come to administration adjudication feels like it's biased. They definitely feel like it is not working for them. And so maybe that is a place that people won't come and feel like, hey, this is biased to the city. But what we have in front of us, I think, is getting us there, but not totally to my satisfaction, I guess. I'll wrap up my comments.
Madam Chair, can I address
Yes.
some of Alderman
Go ahead,
Fleming's
Mr.
comments?
Cummings. Yeah.
So first, previously, before the 2019 update to the ethics ordinance, the law department served as that staff, quote unquote, staff piece. And that served to be problematic when certain residents complained that the law department was biased. So the ethics ordinance was amended to include a special counsel to advise the board. And so that special counsel sort of serves as the staff for the ethics board. And that has raised issues that the special counsel is biased because they weren't actually prosecuting the claims. The residents were prosecuting claims themselves. Insofar as the special counsel or an administrative hearings officer would be considered biased because they're being paid by the city, they are not, and I assume in Chicago's case, because there is a residency requirement, Evanston is not beholden by that. So those individuals don't necessarily have to be Evanston residents. They could be, but they don't necessarily have to be. I know recently we put out an RFP for administrative hearings officers, and I forwarded the posting to an Evanston resident that I knew was a former judge and a former lawyer, or is a lawyer and a former judge. So they could certainly be Evanston residents, but they don't necessarily have to be with respect to the bias question. And the last thing about the bias of administrative hearings is typically administrative hearings officers are adjudicating violations of the city code by residents. In this instance, they would be adjudicating violations of the city code by city employees and elected officials. And so if there's any bias in favor of the city, that means there's likely to be found violations of the ethics code on the part of employees and elected officials, which is what presumably the resident brought the complaint for. So there would actually be in favor of enforcement of the ethics code under the current proposal. But I certainly have continued dialogue with Councilmember Fleming about taking on a citizen panel, which is why, according to the transmittal memo for this particular piece for tonight, there is an indication that this will be temporary until we could actually institute a system that we could have a functioning resident board that isn't necessarily advised by a lawyer, but actually is capable of maintaining those decisions themselves. But Councilmember Fleming's comments have raised more questions for me for Mr. Berlin, so I'll let the rest of the council members ask their questions before I ask those questions of Mr. Berlin.
All right. Thank you, Mr. Cummings. I do want to be mindful of the time, everyone. So we are now entering hour 2, and we're still on R1. And I recognize I don't want to short any of these issues, because clearly this is an issue that we have been wrestling with for quite some time. But if we could all be mindful of the time, I would like us to adjourn the meeting by 9. If we could do that, certainly before midnight. So, Councilmember Reed?
Can I just make a point of order that maybe if we're going to stay on R1, that we read it and then we can discuss it, because I stepped out.
Thank you. That's a very good point. Councilmember Braithwaite, would you read it, and we'll get.
Perfect. Madam Chair.
We're going to read the entire ordinance?
No, he's going to read the item in so that we can move it.
Okay. So no one's moved it yet?
No, we haven't moved yet. We were just listening to Mr. Berlin initially.
All right.
Okay.
Thank you, Madam Chair. I'd like to read item R1, which is ordinance 20-20-21, amending Title I, Chapter 10 of the City of Evanston City Code, City of Evanston Code of Ethics. And it reads, staff recommends the City Council's adoption of ordinance 20-21, amending Title I, Chapter 10 of the City of Evanston Codes of Ethics, and it is for action.
All right. So now the item has been moved and seconded. So Councilmember Reed.
I'm sorry. I would actually like to go, I think, do Alderman Nisman, do you have your light on as well?
I have 4 lights. So.
I'd like to go after if you folks could have a motion that I want to make, but I want to hear some of the discussion before I do.
Okay.
I also wanted to share that we have a number of items on the list, and we're now into our 3rd or 4th rules meeting, just to members of council, and I'll speak on behalf of, or speak to Council Member Flemings. Like, we've run out of time each meeting, and so I've come prepared, ready to vote on items. I don't know about anybody else. There are probably 1 or 2 that I may hear something to change my mind, and if we can be mindful of that, and if we all, having had these conversations over the last 3 months, I just want to support you in having a very timely and deliberate meeting. Thank you.
All right, Councilmember Kelly.
Thank you. So first I want to point out that we did have a Board of Ethics that did work, and but I think there were members that resigned out of frustration because the feeling was that it was not received with much regard by the City Council, to the point where we even had a City Council member voting on a decision by the Board of Ethics to sanction her, and she voted on her own case. So, I mean, there is a clear need to strengthen our Board of Ethics. I think absolutely, you know, ethics in government is so key to a democratic functioning municipality that it's not about now reducing it to a single person who's also hearing other cases. It's very important that we strengthen the Board of Ethics, that we have a board who is focused, who is passionate, whose expertise is ethics in government. So I really hope tonight that we will not take a step backwards in eliminating Board of Ethics, but look as to how we can improve it and strengthen it and let the citizens know that we are holding our elected officials to a very high standard with regard to government ethics. And just because there were problems in the past with the Board of Ethics, that's only an indication that we need to move forward and strengthen it and to show the utmost respect and the need for a panel of multiple citizens who are involved and focused solely on government ethics. Oh, and I did have one question for Mr. Berlin. So I think also we had a question about binding. In Chicago, I assume the decisions are all binding, correct? Is he still with us?
Yes, I am. The decisions are all what?
Binding, correct? Like how does it's advised, the decisions by the Board of Ethics are binding decisions?
Oh, binding. Yes. Yes, they are. I mean, binding to the sense that a person obviously could appeal a determination that they violated the law. They can appeal that to the circuit court, but these are final decisions. In other words, final. Lawyers say final and appealable, which sounds like an oxymoron. But it just means that it's final.
Decision.
It's wrapped up. It's in a bow tie, and now you can appeal it. If there is a legal right, you can appeal it to a higher body. That's never happened. But the bulk of our work, though, is advisory opinions, and nobody has ever challenged the status of a board advisory opinion. But people generally follow our advisory opinions, and when they don't follow our advisory opinions, if we advise somebody not to do something and they go ahead and do it, and then the board finds out that they have disregarded the advice that they were given, then the board will take more serious action, and usually the board will find probable cause that the person has violated the law. No factual investigation is needed, and then the board will make a public finding that the person has violated the law and just impose a fine.
Mr. Berlin,
so yes, they are binding.
On that point, our deputy city manager has a question that I think it relates to our issues here that have happened here in Evanston.
Hi, Steve. Good to see you again.
Hi, Kelly. Good to see you too.
I have a question. So with regard to the decisions of the Board of Ethics, it is the City of Chicago Board of Ethics decision versus whoever the respondent might be. Is that correct?
Yes.
Okay, so one key difference I wanted to ask your opinion on, for the current iteration that the City of Evanston has, it is not that. It is not the Board of Ethics. It could be any resident as a party to the matter. So for instance, it could be, resident X versus official Y. And those are the parties. And the Board of Ethics currently is not even necessarily a party to any appeal decision. And we've had, I think, 3 administrative review decisions in the past 2 years. So while Chicago has had 0, Evanston has had at least 3 that I'm aware of. So I just wanted to ask your opinion on whether or not it should really be the city as a party to those cases and not a resident having standing in those cases.
You know, it's hard for me to answer because we have resident complaints. Residents are, of course, anybody can file a complaint with either us or with the Inspector General's office. People do. But once the complainant makes the complaint, our law does not have, in a sense, a private right of action. So what the citizen complaint does is it gets the ball rolling. And the citizen has no, in a sense, no right to recover from the Board of Ethics, no right to recover from an ethics violation. If the citizen wants to pursue their rights, if they believe they've been wronged by a city official or a city employee, there would be other venues that would be open, such as other administrative agencies. You know, if it's a labor issue, it might go to the state's Department of Labor, EEOC, et cetera. And of course, they can always sue. They can always sue in circuit court for a civil tort. But so, in other words, there's a very basic difference in that a citizen in Chicago is never, all they are complainants. They could be witnesses, but they are never parties to the action. So, and citizens stand to gain nothing in terms of money by filing a complaint. What they can do is if they file a complaint and the complaint is sustained and there's a determination that the person that they filed the complaint against violated the law, then the city will sanction the person who violated the law. But there's no, the citizen is effectively out of it once they file the complaint.
Thank you.
So it's kind of apples and oranges. So it's really hard for me to give an opinion. The colleagues that I've dealt with around the country have similar models. And that may be just true because of the size of the cities that have these large ethics commissions or states. But I've not heard of citizens being parties to ethics actions.
Okay,
So
thank you.
Sure.
Madam Chair, I just wanted to also point out for the members of the committee that the current regime, not the proposal, but the current regime of the ethics ordinance, the determinations of the Board of Ethics are advisory. They are never final. It is up to this body, the Rules Committee, under the current ordinance, to either accept or adopt those findings. And that is also one of the things that have been brought up in circuit court when we've been sued for administrative hearings, that has been problematic as well. So I just wanted to point that out for the members of the committee.
That is a flaw in our current system that needs to be changed. Okay. All right. I don't see any more lights. Wait,
sorry.
okay.
I just have.
Yes, I'm sorry. Go ahead.
Unless we're ready to vote, I'm good.
Did you want to, I think Councilmember Reed said he has a motion, but, so did you have something that you wanted to say before?
No, I think everyone's ready to vote, so I'm ready to vote.
Okay. Councilmember Reed.
So, thank you. I agree that the current regime, as Council Cummings just put it, the fact that this public body is adjudicating whether or not folks are guilty of ethics violations is inappropriate. So I agree that needs to change. I do agree with in the current proposal. I do think it makes sense that a citizen should not be the onus should not be on a resident to litigate or adjudicate or to litigate an ethics complaint. So I think we're making a step in the right direction. What I do think we have to adjust are a number of items within the ordinance. So I will make a motion to do that. So I'll start with the easiest one first, which is I want to make a motion. I do think it's incredibly important that we have a local disclosure. There are items within our local disclosure that are not covered by the state mandated disclosure, and I think we can even strengthen our local disclosure. So I would first like to propose an amendment to to remove the striking of, and my apologies, kind Councilmember Kelly, did you take notes earlier from our discussion?
Let's see.
Yes, page 17. So I would like to remove the strikes. I'd like to make a motion to remove the striking of Chapter 1, Title 10, Section 3, which is the requirements for financial disclosure and affiliation.
I'll second.
And could you state your reasons?
Just did.
Yeah, that's what I opened up with.
Mr. Councilmember Reed, could you state your, hold on. Councilmember Braithwaite, and then I'm going to go back to Councilmember Reed.
I'd actually, I'm going to vote against that. I filled out mine, I was one of the last ones. I think this is a redundancy in what we do at Cook County. The other piece that's valuable is it isn't public. So I'd asked the city clerk, we don't get to see it, so I can't see yours, Councilman Burns, Reed, Fleming,
It's
Ravel.
public.
And so my suggestion is, just to make it more efficiency, I do believe that we should keep it, that we should eliminate it, and then we go with the Cook County one that we can use and that is public for anyone to look up.
Okay. All right, guys, we're going to be here till midnight. Get
Yeah,
ready.
If you go it this way, yeah.
Okay, Councilmember Kelly, and then the mayor, then Councilmember Newsma, and then Councilmember Reed again.
So I seconded, right, the motion? And I think it is important. Ours is somewhat stronger, and also it's much more accessible for in terms of having it provided locally, instead of having to go try and find it on the Cook County clerk's website. So I think as mentioned before, any disclosure regime is better than none. So I think we should absolutely keep ours. And again, ours is stronger. I think it requires disclosure for spouses where Cook County's does not.
Clerk, is it, just a point of information, is it public to residents to look up?
Only for the elected officials and the city.
I'm sorry, Clerk Mendoza, would you come and speak into the microphone for the purposes of recording too?
The public can only FOIA the elected officials and the city managers. All of the employees that have to fill it out currently, which is a lot of employees, it's over 200 people that we're having to keep track of to fill it out.
Plus our committee members as well.
Plus all of the committee members and all the staff who staff committees at any point. So everyone in the city manager's office and any staff, as well as all members of boards, commissions. And the only ones that are public are the ones for the elected officials and the city manager.
Point of order.
Hold on.
Well,
Yes, okay,
there's-
Councilmember Reed.
Yeah, so that is incorrect. The ordinance was updated a year ago, and so it would be a violation of FOIA for these documents not to be publicly available, whether it's an elected official or a committee member. So these are public records. Anyone could FOIA, and in fact, they have been FOIA'd in the past and released.
Well, maybe Nick can weigh in, but I think according to how the code reads now, only the ethics board can.
That was the former code. That was before I think there was a 2019 or 2020 update.
We just rewrote the actual form, and we used the 2019 reference to rewrite it, the form that everyone received on the dais, and that's the one that we used to update it. I may be wrong. Nick can probably weigh in, but.
Okay, let's, yes, go ahead, Mr. Cummings.
I was going to say, based on the last round of having to fill out the disclosure, they were all due July 1st. In the code section that was reviewed, it is only accessible to the Board of Ethics.
There you go.
Yeah.
Redundancy, waste of time.
So-
And that's a violation of FOIA. There's a document of the public body.
Let's have this discussion later to figure out whether there is a problem here. It may very well be, and it needs to be corrected.
Well, it's important because we're voting on whether or not we keep this section, and it's kind of hinging on whether or not these records are public. That's what I'm hearing the discussion saying. So it's important to
I
the
understand.
current discussion.
I'm not sure
that
we can
have
get
that
an
understanding.
answer right now. Mr. Cummings, is there any way you can get an answer for us on this issue?
I can try and find it while you guys are debating.
Okay, let's hold on that issue, and then I have Mayor Biss. Thank you, Clerk Mendoza.
Clerk, if you don't mind staying at the podium, I just wanted to ask a very simple question. This is an amendment to give the clerk a collection of responsibilities. We'll be voting later on other things that may give the clerk additional responsibilities. Do you have a position on whether you think these responsibilities should persist as an obligation of the clerk and the clerk's office?
For this particular
question?
For this particular item, I don't have a position whether or not we should do it. It's taken the clerk's office 3 weeks to be able to send this out to various staff, updating all the boards, commissions, emails, and working with different departments to get that done. We are not staffing all the boards and commissions, so we don't have the emails for all of the members. So it has taken a few weeks. And then on top of that, making sure that people are compliant. There's really no enforcement. Any way that we can make sure people are compliant. We currently have a list of 34 people who have not complied. And there's no enforcement power for the clerk's office. We're simply have the duty of collecting this form. To be honest with you, if we cannot force people to comply, I don't see why the clerk's office is doing it unless we're giving some enforcement power. I will be sending the list of people who have not filled it out over to the Rules Committee, so you guys can figure out what to do with the non-compliant members, which is all the people who haven't complied are community members and only one council person.
Thank you. I mean, that's a very important point. Mayor Biss, does that conclude your question? Okay, Mr. Councilmember Newsma.
Thank you, Chair Nguyen. Just a question so I understand. If we strike section 1-10-3, are we then removing the requirement that board and commission members that have been appointed by the mayor, are we removing the requirement that they file a disclosure?
They would still be obligated to file a disclosure under the state law. They would have to file the county disclosure. They just wouldn't have to file the city disclosure.
Thank you.
And I have an answer with respect to the other issue is 1-10-4, section I, prohibits that any covered person without proper legal authorization disclose this information concerning the property, et cetera, that's covered under the disclosure. So arguably, FOIA would be legal authorization. But again, that is still in the code that's prohibited to disclose that information.
Could you say that again, Mr. Cummings? So you're saying this is FOIA-able or it is not?
I'm saying there's an argument to be made that because the code reads without legal authorization, you can't disclose the form. So there's an argument to be made that FOIA is that legal authorization.
And it's FOIA-able, yes. And point of information, we don't have home rule authority to preempt FOIA. We can't say the state, if they say that something is a public record, we don't have home rule authority to say, oh no, we're not going to release this, police body camera footage. Although, let's say someone, the criteria is met for it to be released under FOIA. We can't make an ordinance that would conflict with FOIA and say that record could not be released, correct?
I would disagree with that because I'm not aware of a specific preemption of home rule authority under FOIA. And our ethics ordinance specifically prohibits the disclosure of certain complaints of ethics violations, even from FOIA. So I would, unless and until I find specific preemption language by the General Assembly of Home Rule Authority, I would say that yes, we do under Home Rule Authority have that power to exempt certain records.
All right, thank you. So at this point, we have a motion on the floor. I believe has it been seconded, Clerk? Pardon me, Councilmember Reed's
Call the
Yes,
vote?
remove the redaction of that section.
If I can make one last point, what is clear, what's different here is that there are, as I pointed out, there are a number of issues that are covered in our ordinance that are not covered in the county ordinance. It's also, for continuity, easier for residents to find the information locally. And also, the clerk's office, while I was clerk, we added a question, I think we should codify this as well, that sought the voluntarily the race and ethnicity of folks who served on our boards, committees, and commissions, so we could have a local understanding of what the racial, and in the future we can add economic, what the diversity of our boards is, and I think that's critically important that we have that information locally, as well as finding conflicts. One of the key questions here is what are the financial interests of you and folks within your household, your spouse, that is not included in the county record, and so you have to disclose your business interests that have dealings with the city. So if your spouse is working for a mental health institution, you serve on the mental health board, and you're giving money to the institution that your spouse works at, and they get a bonus because of that, we would understand that because that would be disclosed under the local ordinance, which it would not be disclosed under the county ordinance. So.
All right, thank you. Ms. Francelno, would you call the roll on Councilmember Reed's amendment?
Councilmember Kelly?
Aye.
Councilmember Braithwaite?
No.
Councilmember Nguyen?
No.
Councilmember Nusma?
Aye.
Councilmember Burns?
Aye.
Councilmember Sefferden? Councilmember Ravel?
Aye.
Councilmember Reed?
Aye.
Councilmember Fleming? Mayor Biss?
Aye.
All right,
2 noes.
thank you. Okay, so that redaction is now, stays in place. All right, so now, Councilmember Braithwaite.
It's clear to me, Councilmember Reed, that you have a number of these edits, and this is just for number 1, and we still have 10 more to go. I have no idea how many more you have. It's my request, my personal request, that clearly you've given these enough thought. I would like to move through the 10 items that I've had an opportunity to review, and our staff has had an opportunity to review. And unless it's just a matter of a wording versus a concept, maybe you can submit these to staff and they can come back. But there's no way that we're going to get through this and the discussion items if we're going to amend every single one of these things that we've had a month to review. So that's my suggestion, that we vote on what we have in front of us, and then you can submit them to staff if we have to come back again at a future meeting.
I have to say, I did not know that this was going to take us an hour and a half. I would have liked to have known that there were a number of amendments that were coming up. I think that since we have other items that have been waiting for action from the Rules Committee for quite some time, that I think we either vote this up or down right now, or we hold it to the next Rules Committee meeting.
Well, so you call the question, but we have to call it on every single vote, then we have to vote before we vote. Or I would support that 100%. If that's your motion, I would second it.
Well, first, Councilmember Kelly has her light on.
So you mentioned unless it's a concept, so I would like to propose an amendment to this that's a concept. So I'd like
As
to.
a
No. I'll clarify that. What I'm.
So unless it was, or maybe you
No,
said
no,
that.
no,
Sure.
no. What I was sharing is what he's asking us to do is a concept that takes us outside of the discussion of what we've had a chance to read. And so we're asking then our corporation counsel to opine on it, give us definition, when if you've had this for a month to think about, then let's get through what we've read through and then just come back with amendments. I don't like thinking on the fly and voting on things that, in terms of transparency, that our residents have not had an opportunity to read. Like, I don't like doing that. I'm not used to doing it. So what he's doing is a concept. If there's a word like shall versus will, or what we've done in the past, alderman versus councilman, those you can get through. But coming up with concepts at 6:30,
okay.
it's going to take us a very long time to
Well, I
get through
think-
this
I mean,
document, is my point that I want to make.
Okay. Well, anyway, I'd like to move that we amend the section that refers to eliminating the Board of Ethics, and then keep everything else. So section 1-10-2, I think that's sort of the key piece that we're talking about tonight. So in order to retain some of the elements proposed here.
What page is that on?
That's on page 13. So to undo the strikes from section 1-10-2 with regard to the removal or the elimination of the Board of Ethics.
Wait, we would still have it?
So point of, I just want to make sure, she said 1-10-2, but I think what you're referring to, Councilmember Kelly, is 1-10-13.
That outlines the possibility of penalty associated with violation of city's ethics code, a fine of not less than $100 and not more than $750 may be issued by hearing officer. That's 1-0-13.
I guess what she's referring to is the definitions, and so.
Right, the
That's
definitions.
1-10-10.
1-10-2.
Okay, everyone, just one person at a time, please,
Well, and then
turn on
going
your
on
lights.
to- yeah.
Okay.
So I guess to maybe clarify what the motion.
Clerk Reed, Councilmember Reed, please don't interrupt. Please, we're going to be here till 1 tonight. So turn on your light and I will call on you. If you don't do that, that we are really going to turn into chaos. Okay.
Okay, please keep that.
Councilmember Kelly?
Alderman, please keep that same energy with everyone. Thank you.
I
If
will,
anyone
but
interrupts
you
anyone,
are the
thank
only
you.
one who keeps interrupting. Councilmember Reed. Councilmember Kelly?
Okay, I don't think he is the only one who's been interrupting, but I'm referring to the definition, advisory panel, so that would still include Board of Ethics, Chair, and Special Counsel, and it would, retain the Board of Ethics Chair.
But Councilmember Kelly,
okay.
we've
everything relating to that.
we've eliminated the procedure that involves the Board of Ethics in the rest of the ordinance. So if you put it back in just as a definition, there's nothing for it to do.
No, there's other elements in here, like the prosecutor, investigator role. There's some other elements that have been added to it, but.
I'm going to move to hold this.
Second.
All right.
I don't think that's
This matter is held until our next Rules Committee meeting.
I don't think that's in order. This motion, this was held and it was moved back to Rules Committee. I think that's out of order.
Yeah.
So if I can, Madam Chair, under the city council rules, an item can only be held by city council one time. There is no rule that says that the committee can't continue to hold an item as long as it needs to in order to complete committee work.
So what point of order, what rules are the committees operating under? Or what, are we just whatever we want to do?
Whatever rules the Rules Committee has established, Councilmember Reed.
What are the rules that the Rules Committee has established?
You are a member of the Rules Committee. I would hope that you would be able to know what those rules are. However, I am not aware of any published rules of the Rules Committee like there are for the rules of City Council.
So okay, so there are no rules.
Just a moment, please. Councilmember Burns.
We just need to get very clear on how we are supposed to make amendments before a meeting. I tried to make amendments with Council Cummings. I was told by Council that he was going to send it out prior to the meeting and not when it was noticed, but days before that, and we didn't get it. So I want to be very clear that if, one second, Council, if we are to make amendments prior to the meeting, then allow us that opportunity to do it, because I have amendments we're on the floor. If I can't make it beforehand, then I'm going to make it on the floor, because I don't want to vote for something, yes or no on something, if I have amendments to it, and I feel like I can get some support from some of my colleagues up here. So I want to make sure that it's not clear right now when we are supposed to, how we get amendments, before a meeting. That's not clear right now.
So if I can address that, Councilmember Nguyen, Chair Nguyen.
Yes.
That was in reference to R4, and that idea that I told you that I would like to have done was not supported elsewhere. Insofar as R1 is concerned, R1 has been on an agenda since April or May. So I know that I have specifically talked to you, Councilmember Newsma, Councilmember Fleming, Councilmember Ravel, Councilmember Suffredin, and amendments have been made. And if you look at the document in the packet, March 30th, May 4th, and May 14th, after all of those conversations, we've actually even updated the memo each time as well. So I'm more than happy to make amendments after talking with, I've also talked to Councilmember Reed, and he informed me that he would not support the ordinance in its current form. But if there are, changes that need to be made, and there have been changes made, again, pursuant to the conversations that I've had with these other council members, I'm happy to make those changes before it's brought before this body again, if it's going to be carried to the committee, if it's going to stay in committee.
I just want to follow to that. So if that's how we're going to do things moving forward, I just want to be clear on that, because I know there's a lot of conversations that happen in between meetings, and I just want to be clear that if an amendment is provided to council before a meeting, that will be included in the meeting. And then I agree, we don't have to make amendments on the fly as long as there is a reasonable time to make amendments prior to the meeting. Thank you.
Thank you. I understand that. I think the concern that I have tonight is that we have 10 items on our Rules Committee. We are now into the 9th hour of discussion of this set of rules. And there are a number of things on this on this agenda that must be addressed in order for our city government to continue working. If I had been aware that there was going to be a long discussion about this ethics ordinance, then we would have had a third meeting scheduled. But I know about the other, as chair, I knew about all of the other issues that are here, but I was not aware we were going to spend 3 hours on R1. So that's why I have moved to hold this, and it's been seconded, and we're going to bring this back up again at the next Rules Committee meeting. And that might be our only topic, if we can get through these other items. But we can't spend 3 hours on this ethics unless we have a special meeting to discuss it.
Just point of information, all of the motions that I'm making, or that I had planned to make today, are things that I specifically discussed with Council Cummings and said that I would like to see in a draft. So are we saying now that it is the expectation that anytime a council member has a difference, wants to see a draft, are we going to have 10 drafts of this ordinance if Alderman Fleming has a motion or something that she'd like to change, he writes up a draft with hers, with mine. So I would just like to understand what.
Councilmember Reed.
Hold on. I just want to understand.
I understand what you're asking.
If I put forward proposals and ask for a particular draft to be created, would Council Cummings put that in the packet?
I don't want to deal with these hypotheticals.
Well, no, it's not. That's what I'm going to do.
Okay.
So I just want to get clarity. So
here's
next
my
time we
clarity
come
right
back,
now, Councilmember Reed. Here's my clarity. You are raising an issue tonight that's substantive to this ethics ordinance. The last council had a subcommittee that studied and rewrote this ethics ordinance, and they met a number of times over a period of months to come up with the last draft. A number of times over a period of months. You're trying to change this at a Rules Committee where we already have 10 other items that are pressing on us right now. If we want to have a subcommittee of the Rules Committee to rewrite our ethics ordinance, we can do that. But we are not going to have a substantive discussion on this tonight and expect to get through even 3 of the other items that we have on here. It's not going to happen. We're going to be here again in 2 weeks. So,
I think that's a fine point. I think we should create a subcommittee to do just that.
But right now, the item is held until the next meeting. Okay, Councilmember Fleming.
I'll be 2 seconds. Just my suggestion, and this is answering Councilmember Burns' question. I think it is hard to make a lot of motions on the floor. I also don't necessarily track well, but what I have found to be helpful for myself, and I wish that there was a very clear way in which we did this, is I do speak to staff, but then if I know I have whatever motions or changes I want to make, I do speak to council members between meetings just to explain what that is and to even see if there's support. That doesn't mean I won't make the motion if there's not support, but I do at least try to explain it to people offline so that we can have a longer dialogue. Now there's no rule about that, but that is what I found to be helpful. But again, at a whole other meeting some other time, it does, and this is part of what we don't teach in city council, unfortunately. I kind of just learned that as I was up here, how we do make these motions, and I think part of that is people do it a variety of different ways, but that is the way that I have found it to be somewhat helpful. And I did speak to Mr. Cummings about some of the changes that I had. That was like a month or so ago. I do think, to fairness of the new council members, it does make sense for us to be clear in terms of protocols, and some things are unwritten, unfortunately, which can be used as a plus or minus to the benefit of the council. I do believe Clerk Reed is right. Having discussion does make a lot of sense, but if there are longer items or items that might have questions, it is helpful to ask council members offline, just so they have at least a high level understanding of what the ask is, and so that the conversation up here is still transparent, but doesn't get us so far down in the weeds that the conversation takes a long time. So that's my 2 cents in terms of how I've done it. But you're right, there is no protocol, and maybe we need to have that, or at least give the new council members the benefit of explaining to them how it has gone, whether it's a rule or not, so that they are not left kind of wondering the protocol of the council, because that is not fair. To their point, that is not fair to them without any direction of how things should be submitted, in terms of amendments.
Thank you. Councilmember Braithwaite.
And I'll be brief. Thank you very much, Chair Nguyen, and thank you very much, Councilman Fleming, for your points. The only thing that I would add, and I did try calling you, Councilmember Reed, right after our AP&W meeting, and I followed up with a text message just to share the same information that we're hearing now.
Point of order. There's no motion on the floor, and this is unrelated to this item.
So my last point.
Excuse me, Councilmember Reed.
I'd like a decision from the chair.
I permitted Councilmember Burns and Councilmember Fleming to speak to this issue. Go ahead, Councilmember Reed.
To my last point, as a follow-up to you, Councilman Nguyen and Fleming, the other important key is notifying the chair that if you have a number of amendments, because it's the chair who speaks directly to staff and sets the agenda. So I would agree, if I knew about it or if you knew about it as a chairperson, you then have the ability to pare down this agenda to make it more manageable to get through it this evening. So I think there's a great teachable moment for all of us, and hopefully now we can move with more efficiency. And I would suggest to you, Chair Nguyen, that if there are other items that seem like there's a lengthier discussion, we can hold them over and then take into consideration the comments that you made, Councilwoman Fleming, and as well as my comments, just to get us through this evening. Thank you.
All right, thank you.
Point of information. It seems out of order. I think there should be a motion to suspend the rules to have Chairman Nguyen be the chair, since it's a violation of our rules that someone would serve as chair twice. So I think it would be appropriate to suspend the rules. Or move directly to that discussion.
We're moving, I ruled that out of order. All right, we're moving on to R2.
Clear violation of the rules.
Would someone like to motion? It's not a violation of our rules, Councilmember Reed.
Madam Chair, if I have the privilege, I'd like to move item R2, ordinance 76-0-21, amending section 1-7-4 of the City Code concerning deputy clerk appointments. Councilmember Cicely Fleming recommends the Rules Committee adoption of this ordinance, amending section 1-7-4 of the City Code concerning deputy clerk appointment. It's for action.
Second.
All right. Do we have discussion on this item? Councilmember Fleming.
I brought this up because, I don't know what happened before I was here, but as I was here when Mr. Reed was the clerk, we had a lot of changes to the office. But in thinking through how everyone else, and I realize city manager hires staff, but thinking through how every other office that I understand operates, if you have a manager and assistant manager, the manager supervisors and manages and gives duties to and does evaluations of the person who is their assistant manager. And so to have the deputy clerk, report to the city manager's office and be evaluated by the city manager's office and so on and so forth seems to be contrary to how we operate in every other department that I'm aware of at the city. Also, the city clerk obviously is elected to do duties that are not under the city manager's purview and that are duties that the citizens have recommended or have elected the clerk to do. And so the idea that they would not have their own staff who they are daily managing and responsible for, and again, providing those performance management reviews for, just doesn't seem to make sense. And I know, or at least I was told, part of the reason for that is that the person then doesn't become a political pawn and so on and so forth. I don't know that that has been proven to be the case. And so in order to have Ms. Mendoza, who is our new clerk, be able to have an office in which she can fully staff and do all the things that the clerk's office used to do, it makes sense to me to have the deputy clerk's position put under her so that when, she is in office, she has a staff that is totally working for her and there's no conflict between them working for the city manager's office or reporting to the city manager's office, but working in her office. And I know that came an issue around FOIA and a lot of other things where the citizens had lots of concerns, again, around bias and who actually they had elected to perform the duties of the clerk. So that is why I'm making this motion that the deputy clerk actually report to and be supervised and everything by the sitting clerk.
Thank you. Any other lights? Okay.
I'll be ready.
Councilmember Braithwaite and Councilmember Ravel.
Thank you. My concern with this is just looking in the past, and I think to Councilmember Fleming, when we look at, if we're going to make a comparison to our staff, obviously anybody who's at the director's or the manager's level, there's an expectation of credentials that is taken into consideration for them to move up. I've seen where people have moved up because of their credentials as well as experience on staff into managers and directors position, just as I've seen very qualified people with experience not be able to advance because they don't have the necessary credentials or experience. So my concern is with our form of government, we don't have any elected supervising a staff person, and I've shared this with the current. That would be my reason for voting no. We've seen in the past where not too long ago we've had 2 people leave a specific office working for an elected, along with other concerns that don't really need to be mentioned, but I like things the way they are now, and I'm going to be voting no against this.
Councilmember Ravel?
Well, I guess I had a question or two. So would this deputy city clerk, with the hiring to fill this position, follow basically the rules and the procedures that our human resources department applies? I mean, how would this employee, how would this position be filled in similar way to the way we fill regular positions in our government, and with the same benefits, et cetera, be given to this deputy city clerk as to our other full-time city employees? I mean, I'm just trying to understand how this a deputy city clerk hired this way would be the same or different from our regular employees, and I don't know who's around to answer that.
Councilmember Fleming, did you?
I mean, I guess I don't know why. Well, to 2 points, I don't know why the hiring would be the same. I mean, the clerk obviously would, be involved in the hiring, just like our water plant managers involved in the hiring of their own staff, right? So they would be on board. I mean, we have an HR department that would do all that stuff to make sure that they are onboarded and they have benefits and all that kind of thing. I mean, they wouldn't be. Just like we have some onboarding in terms of HR stuff. And in terms of Alderman Braithwaite's point, that part is my concern, right? So in terms of I'm not really sure where you're going in terms of education and moving up and down the ladder, but, regardless of what happens in any elected official role, the person coming in after them should not be should not benefit or be penalized. So if I came in behind someone who, whatever, committed some kind of embezzlement, I would hope that my role here, there's not a constant, well, the last Ninth Ward person did this, right? So regardless of what happened or what we perceive to happen with any clerk, I think if people elect a new clerk or people elect a new city council member, that person should be treated as their own individual. They should not, their office or their duty should not be hindered by what happened before they came in. And so, we know that there was a lot of responsibilities taken from the last clerk's office, but that has nothing to do with Ms. Mendoza. And if, and we're asking her to do a job, the citizens have appointed her to do this position, there's no reason why she should not have, particularly, the title is the deputy city clerk, that she can then hire and supervise. And again, I'm not even sure how it works out now that Ms. Mendoza is supervising the current deputy clerk, but then his review is done by someone who doesn't supervise him. I don't know how he is, or whoever this person would be, is expected to manage one direction they get from the clerk, but maybe a conflicting direction they get from the city manager's office. It also seems like not an ideal spot to have a staff member in. And so, again, we don't manage, from my knowledge, any other staff in this way. Everyone manages their own staff, even though the city manager is ultimately responsible, for hiring and firing. They manage their own staff. They're not.
Councilmember
Yeah.
Fleming, in the past, we have had deputy clerks who have been hired with the input, this is my understanding, of whoever was the clerk at the time, but the clerk obviously makes the recommendation. The city manager hires the person that the clerk wants them to hire as deputy clerk. But that deputy clerk is officially hired by the city manager, but just like anybody else in any other division, I would imagine that the clerk would then obviously give the deputy clerk their review, give them job performance, help them develop in their job, but it wouldn't necessarily be hired specifically by the clerk. That's not how we've done it before this. And we've had several people who worked in our clerk's office for 10, 15 years under several different clerks.
Right, but this is an elected official who the people have said that they have chosen to represent them in this light, right?
Right. And those prior clerks were Rodney Green and Mary Morris, who was our clerk for, I think, at least 15 or 20 years. And there were several longtime employees who were deputy clerks in the clerk's office. And when one of them left, then that person was replaced. Obviously, they interviewed with whoever was the current clerk at the time, and they were hired on that person's recommendation.
So if our clerk wants to hire someone and the city manager says you can't hire this person, that leaves our clerk without any autonomy to manage their office. And I don't want to put Ms. Mendoza on the spot, but if this person is reporting to two different people, how do they then decipher?
My point is that they wouldn't report to three different people, but I am concerned, and this has nothing to do with Ms. Mendoza. I think the system that we had before worked very well, and I think that there were irregularities prior to this current council, and I think that what happened before worked very well, and we had a very successful clerk's operation for a very long time.
Okay, well, we can, unless there's more conversation, I don't need to belabor the point. I think that the elected clerk should be able to manage their office without the input of the city manager, aside from, payroll and HR and those things that they don't have the function to do. I think they are elected separately than us, and we should respect them to fulfill the job that the residents have put forward for them to do, including managing the staff and their budget.
Thank you. I have Councilmember Braithwaite, then Councilmember Kelly, and then Councilmember Ravel.
Yeah, thank you very much, Chairman. And I think those are the issues precisely that I'm concerned about, Alderman Fleming, with this recommendation. I think, number one, I'm very sure that the job description has not changed. So the same job description that he was doing, our current employee under the old administration, has the same job description. I don't recall it changing, and again, if that's the case, then maybe we bring it back. But I think more importantly, the line item as it stands is outside of the clerk's budget. So to do that, if that office is going to have control, that would be a question that I would have, that it would no longer be a part of our general fund, but then it would go and would have to be funded under the clerk's office. So I think if this is something that we're looking to do, I don't know if you do it right now in mid-year, but because I'm not going to support it, I am ready to vote right now. So thank you, Madam Chair.
Councilmember Kelly and then Councilmember Ravel.
So I think if it's worked well in the past, that's great, but I think it's happened to have worked well in the past, and I think this is just a measure to ensure that it works well, and it's a way of improving our code. And I don't think wherever the funding comes from precludes the hiring. I mean, whether it comes from general fund, wherever it's from, that shouldn't have any impact at all. And again, I think this formalizing this hiring practice will ensure that it continues to work well.
Councilmember Ravel.
Well, I thought, Chair Wynn, you were going to mention that also in the past, because the deputy city clerk position, the person in that position doesn't necessarily stop being the deputy city clerk once there's a turnover in the city clerk position. So you get that institutional memory and continuity from one term to the next by having a deputy city clerk continue. And I remember way back to like probably 4 city clerks ago, where the deputy city clerks in the office provided wonderful institutional memory and continuity from one city clerk to the next.
Yes, and that's an excellent point, Councilmember Ravel. And prior city clerks added other functions to the office and certainly had control always of what happened in the office. But I think Councilmember Braithwaite's point about the budget is a legitimate one. I think we haven't worked out all the quirks of how this position would be funded. Yes, Clerk
Sorry,
Mendoza.
So the salary for the deputy city clerk does come out of my budget currently. So does insurance and the retirement fund, all of that comes out of my budget.
Thank you.
Yeah.
Okay. Councilmember Newsma?
I was going to make that point. I have a copy of the Excel sheet here. The city clerk department and the city clerk business unit are both under the general fund. So in terms of any impact on rejiggering our budget, it would be minimal.
Okay. I think we've had debate.
I've turned my light on several times.
Councilmember Reed?
Yes, thank you, Councilmember News, for making the point about the clerk's budget and it coming from the general fund, so all of that's clear. I do think to Councilmember Ravel's point about the hiring and what the process would look like, I think if we want it to go through the normal HR process, we'd have to write that into the ordinance, because as it stands today, the clerk's office, if you look at the code, the city manager has responsibility for many departments. The clerk's office is not listed as one of those departments, and thereby currently, no, the clerk would not have to follow the HR policy. So I think if we want the clerk to follow the HR policy, it's up to the council to mandate that here and to make an amendment to say that, we'll do everything that Alderman Fleming is proposing, but just in accordance with the HR policy would be the only addition to it. So I will make that amendment to add that language to this, to the hiring shall be in accordance with the HR policy.
Okay. Ms. Francelno, would you call the roll on that amendment, please?
Councilmember Kelly? Aye. Councilmember Braithwaite? No. Councilmember Wynn?
No.
Councilmember Newsma?
Aye.
Councilmember Burns?
Aye.
Councilmember Sufferton? Aye. Councilmember Ravel?
Aye.
Councilmember Reed?
Aye.
Councilmember Fleming? Aye. Mayor Biss?
Aye.
Okay. The amendment carries. Would you?
Madam Chair?
Yes.
Can I get a point of clarification on the amendment, because the ordinance that's being proposed right now is striking the word city manager and adding the term city clerk. And where would Councilmember Reed want to add in accordance with HR policy?
anywhere that you see fit as the city council, corporation council.
All righty.
All right, Ms. Francelno, would you call the roll for the original motion?
For R2. Councilmember Kelly.
Aye.
Councilmember Braithwaite.
Aye.
Councilmember Wynn.
Aye.
Councilmember Nusma.
Aye.
Councilmember Burns.
Aye.
Councilmember Sufferton. Councilmember Ravel.
Aye.
Councilmember Reed.
Aye.
Councilmember Fleming. Mayor Biz.
Aye.
Clerk Mendoza, I believe you might be safe to go home now.
No.
No, there's one more, sorry. Mhm. Okay, moving on to R3.
I mean, it doesn't matter, best. I thought we were voting on the amendment, not recasting the vote, not that it passed anyway.
Okay,
I thought it was the amendment to,
so we voted on the amendment.
as amended, that.
Okay,
But according to the rules, which may not be in play, a council member can change their vote. So if you want to change it, Dara can make that amendment.
Mr. Cummings, did you have something to say to us?
No.
Okay, thank you. We're going to move on to R3. Would someone like to make a motion with respect to R3?
I'll move R3, Ordinance 77-0-21, amending 1-7-2, general duties of the city clerk to include parliamentarian for city council meetings. Councilmember Reed recommends approval of this ordinance as stated.
I'll second it, and I would have moved it.
All right, Mayor Biss.
Thank you, Madam Chair. I just want to express some discomfort with this suggestion. It seems to me we just got through doing something to help solidify the clerk's role as a truly independently elected official of the city. I think you assign roles to an independently elected entity to act as a check. And I'm not familiar with a legislative body for whom the parliamentarian is a check and a balance rather than an employee to facilitate the functioning. If you look at, we read all the time about the U.S. Senate parliamentarian. That person is appointed by the U.S. Senate, not elected by the people of the United States of America. I'm accustomed to the same kind of thing in Springfield and so forth. And so I'm personally uncomfortable with the idea of a separately, independently elected parliamentarian for the council, and for that reason, I'll be voting no.
I see no more lights.
I flipped my light on.
All right, Councilmember Reed, I don't see it, but go ahead.
So I put forward this proposal. Mayor Biss makes an interesting point there. However, I will say that I do think that having an independent office serve as the parliamentarian, certainly no one, at the end of the day, the mayor does not have to follow, or whoever the chair is does not have to follow the advice of the parliamentarian. But I do think it's important to have someone who's accountable to the public, ensuring that we are operating the meetings in a fair and balanced way. And I think if we were to adopt this, I think we also should provide the funding to the clerk's office to give the clerk training in parliamentary procedure. So we have someone who really focuses on parliamentary procedure. It's one of the, during the meeting, the clerk, is taking notes, but it's not as involved as maybe the law department, and the law department has a whole lot of things on their plate, and I think it makes sense to have an independent office really hunker down on our rules, understand what the rules are, be able to provide fair and balanced advice, and then be held accountable to the public, as well as the chair would still be able to make any determination they see fit.
Councilmember Ravel.
Well, the word that comes to my mind in thinking about this issue is the word impartiality, and I think that having the parliamentarian not be an elected official, potentially subject to political pressures, et cetera, which I'm not thinking is the case in the current situation. I think not having the parliamentarian be an elected official is, would give me a greater feeling about maintaining the impartiality of this position. So I am not in favor of this proposal.
Thank you. Ms. Francelno, would you call the roll?
I didn't make them, I would have made the motion. I'd be happy to withdraw it. What I do think we need to do is we need to name someone as a parliamentarian, whether it's the clerk or someone. Someone has to know that it is their responsibility to have a deep and clear understanding of both Robert's Rules of Order and our council rules. So when we go to that person, we get correct advice the first time. So I would actually, we don't need to discuss, I would withdraw my second or just withdraw the motion. I see that there isn't support for this.
Wait, okay,
I'm sorry.
I'm sorry. Councilmember Reed, are you, what?
I'll withdraw the motion.
Thank you, and we can just keep moving.
All right.
But I do think we should look at naming someone as parliamentarian. Thank you.
I believe we need a second to withdrawing the motion.
A second.
All right, okay, the motion is withdrawn. We're going to move on to R4.
I'll move R4. R4 is review and acceptance of revisions to rules and organization of the City Council, City of Evanston from June 2021 for action.
Thank you. Is there a second?
Second. Oh.
All right. Okay, everyone, we have R4. And Mr. Cummings, do you want to describe a little bit of what we have in front of us in R4 in our packet?
Yes, Chair Nguyen. In the packet for R4, I got smart this time, this being the third time this matter is up before the committee. I listed in the memo specifically items that the committee is should pay attention to or should consider. There was one mistake, which is Rule 6.2 was actually already ratified on June 21st, so I apologize for that. However, everything else is an updated proposal, and there's a date listed in the memo as to when that was proposed, and in some cases it was also added by who it was proposed by. And so because I got a lot of feedback either from previous meetings or in between meetings, I was able to compile all of the different rule changes that were suggested and proposed and put them in the memo up front. They're also redlined in the draft document that's attached to the packet and highlighted with comments that with call outs that say specifically, so for example, on page 9 of 35, I'm sorry, page 8 of 35, which is page 47 of 100 of the packet, there's an item for new business. And there's a comment that was referral by Councilmember Reed to allow the city manager to bring business to the city council as a piece of new business. So that's what you have before you this evening to try and help make this a little easier to identify what it is that's being changed and help direct debate for the members of the committee as to, if they want to wholesale accept the changes or if they want to pick and choose which items require more discussion rather than others. That's what I tried to help facilitate for tonight.
Thank you. Councilmember Sufferton.
Thank you. I just had one question or request for clarification, Nick, if you don't mind. On rule number 24.1, page 70 for those who are watching, it says, council members shall vote simultaneously and by electronic means on motions, resolutions, and appointments, except where a roll call vote is specifically called for by statute, rule of the council, or by a request of any council member. I think that simultaneous electronic voting is still a roll call vote as long as it is your vote is next to your name, rather than a all in favor type thing. Am I wrong? I could be. Is it a term of art?
So admittedly, that was a proposal, and this is why it's not in the memo, that was discussed with between the mayor and I thought that I had taken that out because we did not come to an agreed resolution, and that would be discussed by the committee tonight in terms of electronic voting. I certainly understand, after discussing with the mayor, the point is to try and remove or at least not have voice vote roll call votes. Is that what you're getting at?
Correct. And
So you would like to have more of an electronic system like in Springfield or in Washington DC where you push a button and your name comes up and it says what your vote was.
Yeah, voting is open and then people vote rather than go sequentially.
Okay.
But I think that qualifies as a roll call as opposed to, where you say like all in favor, all opposed. I think as long as your name and your vote are linked, it's a roll call, but.
It's opposed to a voice vote.
Right. But I hear it draws a distinction between the simultaneous electronic means and except where a roll call is requested. And I think that distinction is unnecessary.
So, and I don't have any cause to disagree with you. I have not had an opportunity to research what the state law requires as a quote unquote roll call vote. Okay. In my experience, it's always been a voice vote. So I can look into that in terms of whether, having it done by electronic means. And again, I apologize. I thought that I removed that edit in 24.1, but having it by electronic means, whether that constitutes a roll call vote. All I can tell you is that under Robert's rules, a roll call vote is a voice vote. But and not necessarily like a ballot vote, which is what the electronic means that you've discussed is sort of defined as under Robert's rules. But I can look into that and get you a definitive answer if the committee's wish is to eliminate having the voice vote and actually have to spend the time to go through and call everybody's name.
Thank you, Nick. I appreciate it.
Councilmember Sufferton, may I ask you a question? So so this would mean that, for instance, the mayor would ask the clerk to call the roll, and you'd say voting is open, and then we would have some ability to turn on or off lights.
Right. We would all
And,
vote simultaneously rather than.
So there'd be some way to tell who was aye and who was nay, and then the clerk would announce the 7 ayes, 2 nays.
Correct.
Right. But then the public would not necessarily know who had voted aye or nay?
No, they would. There would be, everyone's vote would be, and without having like the catalog.
So it would be recorded?
Yes, it would absolutely be recorded. And I would presume that there is some catalog that exists where you get government stuff that would have 9 slots
Under
and
government
2
stuff, yeah.
lights.
Okay, so I understand that. But roll calls could still be called. So someone could still request a roll call.
Well, what I'm saying is I don't think there's a distinction between what we're describing with the board. I think that is a roll call vote. A non-roll call vote would be all in favor, say aye, all opposed say nay, in the opinion of the chair, the ayes have it type vote. A roll call in my mind, and Nick may be researching this right now, is your name is attached to your vote, or the way that we've been doing it where you say your vote out loud.
Okay.
And then in the minutes, it will say, these people voted yes, these people voted no.
Okay.
But for those sitting in the room, if we get the correct
So
tally
is-
board, they would also know who
So
voted
is
out.
there an advantage to having electronic versus a vocal roll call?
One is, I think that it's more efficient. And then 2, with the way that we do it, where we rotate who votes first, in a large number of votes, the matter is decided before everyone is voted.
I understand that, but then if we did it, I'm sorry if I'm being.
No,
No, so if it were the electronic roll call, it's roll call because people can see how you voted.
Correct.
I understand, I got it now. Okay, got it, okay. I'm sorry, I'm just a little slow tonight. Councilmember Newsma and then Mayor Biss.
Thank you. I'm prepared to vote in favor of these changes wholesale with the exception of 18.13, which I thought we had agreed to remove from this draft, but I understand there's been some subsequent discussion, so I'd like to hear the reasoning behind that.
Okay.
18.13 is on page 67 of 100, and this is the concept of notes.
So on June 27th, I got an email with suggested new language after the proposal was the old language was denied by the committee. I got a proposal for new language from Councilmember Fleming, and so that's why that language is there as a new proposal for new language in 18.13.
Okay, thank you. And now I'm going to go to Mayor Biss.
Yeah, thank you. I'm just seeking clarification from you about just, I see a couple folks that already jumped in.
Right.
Are you inviting us to jump in, or did you want to go through sequentially?
Well, here, what I wanted to do tonight was to say to everyone that we should actually follow what Councilmember Newsma just did, which is that if we can all take out what it is that we want to discuss and then leave in what it is, if we can do this essentially kind of as a consent agenda, so that if it's here and you like what's there, we're going to leave it that way. And if there are issues that you want to pull off and that we then discuss, just as Councilmember Newsma just did, then we should do that. But otherwise, walking right through every single one of these will really be a very laborious process. So that's what my suggestion is that we do tonight, that we take a minute and for the issues that anyone came with tonight that they wanted to discuss, we'll make a list of those and then and we'll pull those off and then we will vote. That then the agreement is that if you didn't pull it off, you agree to it. Okay? Does everyone understand that? Okay. All right.
Councilmember Nguyen?
Yes.
Just wanted to point out 22.1 and 22.2 probably do need to be pulled off only because there's competing sort of revisions.
Okay. All right. So I'm going to let everyone take a minute. And you know what? I'm going to ask for a 5-minute recess, or recess, whichever one you want. And everyone take a minute to look over the items that you would like to pull off. And remember, we can always revisit these sometime in the future. If things aren't working right, we can always change them in the future. So, but I think we should have a set of rules. So if everyone could take a time, and we're going to take a 5-minute recess. And Councilmember Kelly, you'll be the first person I call on when we come back.
Take out money against the tip.
Okay, everyone, I think we're going to try and get back to work. Careful. Yeah. Okay, everyone, I think we're going to get back. Did you just turn your light on? Okay. Mr. Friedman and Mr. Burns, we're going to get back to work. Thank you. Okay, everyone, we're back. We're going to do our version of a consent agenda with respect to these rules. And first, I'm going to call on Mayor Biss and then Councilmember Kelly.
Thank you, Madam Chair. I'd like to pull off of this version of the consent agenda items 2.1F, 19.11.3.4E.
Could you go a little slower?
You bet.
19.11.3.4E. 19.11.3.4.
Yes, E is an eagle.
Yeah.
Evanston.
Or Evanston.
I think it's 9, but that's okay.
Oh, sorry, 9, not 11. Sorry, 9, not 19. 9.11.3.4E.
We would have been looking hard for that.
Yes.
Okay.
10.7, 12.1, and 24.1.
Okay. Now, Councilmember Kelly? Oh, you had your light on before recess, so. Okay, so next I have Councilmember Revelle. If you could turn on your lights, and then we're just gonna, yes, okay. So then I have Revelle, Reed, Braithwaite, and Newsma. So Revelle first, please.
2.1 and 18.11 And then I have, under chapter or Article 3, the current version is missing a paragraph that we used to have in the old version, and I don't know if that was intentional. It deals with amending and repealing a rule. We used to have a paragraph there. So.
Give me 1 second.
Which section is that, Councilmember?
It's section 3.1. It used to say, any rule may be amended or repealed at any regular meeting of the city council following prior submission thereof in writing by the Rules Committee or 3 or more alderpersons. The requested changes must be distributed to members of city council at least 1 week in advance of the vote thereon. The proposed amendment or repeal must be approved by a majority of the alderpersons currently holding office. So that's in our current rules, and I don't remember us actually deleting that. So I just.
You're correct, and that is one of the changes that I forgot in the memo. I apologize,
Okay.
Councilmember Ravel. And I can tell you that the reason for that being removed is because it's actually in conflict with the jurisdiction of the Rules Committee with respect to the rules of City Council.
What?
So right now, the jurisdiction of the Rules Committee is to do exactly what this body is doing, is to look at and amend the rules of City Council according to the definitions under section, it's under section 9, but, and I can't, it's 9.3. Is 9.3C is revision of council rules. So,
I think, can we just hold that discussion till we get everyone?
Sure.
Thank you, though, both. Okay. So, Councilmember, I lost track, Newsma, and then Braithwaite.
Just for the record, then 18.13, which I had mentioned before. That's all.
Okay, thank you. Councilmember Braithwaite?
Madam Chair, 18.11.
You want that one taken off?
Yeah, just
Okay,
as
that's
Alderman
fine.
Valley.
Okay. All right, so I'm going to read the list. 2.1.f, 9.11.3.4.e, 10.7, 12.1, 24.1, 2.1, 18.11.11, 3.1, to get that clarification, 18.13, and 18.11 again. Okay, so do we want to yes, do we want to, yes, thank you. Do we want to go ahead and pass everything in the rules packet, accept these items, and then go through these items? Yes.
Yes, so I'm going to make a substitute motion of the original motion, which is the.
Hold on.
Oh.
I
Wait.
Chair had my light on.
Councilmember Reed, could you try your light? Because I have not seen it on. Okay, now, okay.
You turn it off.
Go ahead,
Okay.
now I see it.
I'd also not necessarily like to remove, but I have questions about 18.7, 18.8, and then 22.
Wait, I couldn't quite hear you.
18.7 and 18.8, as well as 22.2.
Okay, so 18.7, 18.8, and 22.2. Yes, and Mayor Biss.
Councilmember-
I'm sorry.
Yeah, I was going to say, Councilmember Nguyen, 22.1 and 22.2, because there were competing amendments, those need to be pulled as well.
So we're adding 21?
Oh, yeah, I'm sorry, 22.1, yes, I apologize.
Okay,
And 22.
22.1, not 22.2?
Both of them, because it's connected.
Okay, understood. Okay, thank you. Mayor Biss.
So I'd like to make a substitute motion for the previous motion, which is identical, except the aspects of the previous motion that relate to item sections 2.1, 3.1, 9.11.3.4E, 10.7, 12.1, 18.7, 18.8, 18.11, 18.13, 22.1, 22.2, and 24.1 are removed.
I will second.
Thank you. Okay. Ms. Francelno, would you call the roll?
Councilmember Kelly?
Aye.
Councilmember Braithwaite?
Aye.
Councilmember Wynn?
Aye.
Councilmember Newsma?
Aye.
Councilmember Burns?
Aye.
Councilmember Sufferton? Aye. Councilmember Ravel?
Aye.
Councilmember Reed?
Aye.
Councilmember Fleming? Aye. Mayor Biss?
Aye.
All right, so now we will start with the first one of these items, which is 2.1. All right, who took that one? I have two people who took that off. Councilmember Ravel.
Sorry. It's the item that would add an item called new business onto the council agenda, and at least that's the one I'm looking at.
Oh, shit.
It's on page.
Thank you. That's what I was, thank you.
Yeah. And I think we've already seen a number of times when new issues are presented to the council that we haven't read about in the packet. We have no basis for discussion, that we end up being kind of unhappy with our conversations. And I also think, for the public as well, it's beneficial to have a heads up about what the issues are that we're going to be discussing. So I'm not in favor of adding a new business item.
Councilmember Reed?
Yes. In response to, I didn't realize that we were pulling off 2.1F. So the reason for this is we don't have, everything you said, Alderman, or Councilmember Ravel, the same process would happen. There'd be the same notice for anything that wound up on the agenda, just like anything else. The only difference is currently the only place that we have for items that have not been considered in a committee is a special order of business. And when we place something on the agenda as a special order of business, it precludes members from being able to hold that. So there are plenty of new business items that don't need to be special orders of business. So this would just allow for a space for the city manager to work with the mayor or anyone to get an item on as a new business without limiting the rights of members to hold it for consideration and further thought.
I have a clarifying question.
Councilmember Fleming?
Sorry, I just need a clarifying question. I'm sorry, I keep messing with my lamp. I'm sorry. But the new business would not be like for action, right? It's just a new business, or explain to me, because I mean, that's on the agenda, but it would be a new business item that we are expected to take action on, but it would also come with a memo. Can you explain to me what this would be?
Yeah, so just like if you look at any council agenda, if we just were to go to the last council agenda and we had a special order of business about whatever the case may be. For example, when we changed the FOIA statute and who had the FOIA abilities, that was put on the agenda as a special order of business. It could have been put on the agenda as a new order of business, and that would have allowed it to go through the same process, only that if two members wanted to hold that item for further deliberation, they could do that. Currently, we don't have a spot on the agenda where if we want to if the city manager or the mayor or anyone wants to put forward an order of business that has not gone through committees, which we do all the time, that's what special orders of business are, that's why they're in here, we can still do that just without limiting the rights of members to hold it. So it just gives us another tool for further deliberation and even more transparency, which this body has started to reference a lot. So it allows for that further discussion.
All right, so then I have another question, because I don't even like special orders of business. So what would be the reason for having something go straight to the council versus having it just go through a committee?
I mean, the city manager's office can answer that. There are plenty of items that are placed on the agenda as special orders of business.
Right, but again, I don't like special orders of business. So that aside, from the council standpoint. I guess I won't get into the city manager standpoint.
What would be, say it again?
From the council standpoint, so as a council member, why would I need to have a special order of business that I couldn't just make a referral to go to AP&W or wherever else for the conversation versus just having it come straight to council?
So for example, on the last agenda, we had SP1, which is Planning for City of Evanston Strategic Plan and Comprehensive Planning Process. That was placed on the agenda as a special order of business. It could have just been placed on the agenda as new business, and it would have gone through the same process. And not that that's something that needs to be held, but because of the way it was presented as a special order of business, if you thought we needed a bit more time to think about it, you wouldn't be able to hold it with a motion and second the same way you could if it was just a new order of business.
Councilmember Reed, couldn't we achieve the same goal by changing the rules with respect to special orders of business and just permit them to be held?
But why wouldn't we have, yes, we potentially could, but the question is, why wouldn't we just have a section that's new business? Why would something be a special order of business and not just new business? A special order of business should be something that is a special order of business. There's something spectacular about it. The council has
generally, that's what it has been. Frequently, it's been the budget, in my memory, or something that we take on as a committee of the whole. Harley Clark was something that I think we had on as special orders of business. I'm trying to remember all of them, but the one I remember, the one that comes to mind is the budget. We don't have special orders of business very often, and partly because they short circuit the process. So I think to achieve that goal, if the concern is special orders of business can't be held, I think we should just make the smallest change necessary, which be to change the rule with respect to special orders of business and not introduce a new concept like new business.
So my thought there is that adding the new business is the smallest step, because there are things that raise to the level of needing immediate action, and that there should be a higher threshold for delaying action on an item. And so I think those items, go through a process, which is the mayor would get to determine that something raises to that level. The council as a whole can vote in a majority to say that this certain item is raising to the level of special order of business and thereby cannot be held. So we can still keep that mechanism, which I think is important, to have that higher holding threshold, and still allow for things that are important to move forward. So here's an example that you might like. Instead of having the SP2 from one of our previous meetings, which was the ordinance creating workers' rights, instead of having that as a special order of business, it could have just been new business. It still go through the same process, and it would have been easier to hold that without having to go through the override process, the overruling process, because it was just new business and not a special order of business.
All right. Well, I agree with Councilmember Fleming. I think that the right thing to do would be to send it to a committee and have it go through that process rather than have it suddenly be plunked onto.
Sure, which you could have done easier if it wasn't a special order of business, as opposed to, if it was new business, it could easily be held and sent back to committee. If it's special order, it cannot.
No, I think it should have originated in a committee and never been plunked onto the city council agenda as new business or a special order of business.
Which would, if it's new business, you can hold it because you have that thought.
Okay. All right. I see no more lights. Ms. Francelno, would you call the roll on? Have we had a motion with respect to this? No. No, we have not.
I move approval of the change to Rule 2.1F. Allowing for new business.
Second.
All right, Ms. Francelno, would you call the roll, please?
Councilmember Kelly?
Aye.
Councilmember Braithwaite?
No.
Councilmember Nguyen?
No.
Councilmember Nusma?
Aye.
Councilmember Burns?
Aye.
Councilmember Sufferton? No. Councilmember Ravel?
No.
Councilmember Reed?
Aye.
Councilmember Fleming? Mayor Biss?
No.
6
All right.
noes.
All right, thank you very much. The motion fails, six noes, 4 ayes. Yes, thank you very much. Now we're going to move on to the next item, which is 2.1 point, oh, that was 2.1.f. Thank you very much. And what is our? 3.1. 3.1. Thank you.
So that Nick had removed that. That was
Right.
Councilmember Ravel's question.
Yes, Nick, we're going to discuss this a little bit more now. 3.1, this was the issue that Councilmember Ravel had the question about, that there was a paragraph here before this.
Correct.
And what did
So-
what did the paragraph before, again, can you refresh our memories? What did the paragraph 3.1?
Well, basically, it was a paragraph that provided for a mechanism for amending or repealing a rule at any regular meeting of the city council if we did various things. And so I guess Council Cummings is saying that that would have been, that only the Rules Committee can change the rule, and so I'm not clear.
The idea is that it should be in one place or the other, right? So the jurisdiction of the Rules Committee is under Rule number 9 is to amend the city council rules, which is what we're doing here and what we've done last couple meetings. So having the ability to just amend the rules at any regular city council meeting sort of
It obviates the need for a Rules Committee.
correct. So perfectly understanding that the Rules Committee is made up of the members of City Council. But at some point there's conflicting language, so it should be in one place or the other. And so I apologize that I had neglected to point out that that was one of the amendments.
So what you have done, Nick, just for clarification, is you've kept it in the Rules Committee and removed it from the council?
Correct.
Yeah, we've removed the paragraph under 3.1. And, you know,
Right.
I'm very comfortable with that because I do think that if we're going to be amending our rules, that we should be doing it in a very thoughtful way, yeah.
Okay. So, Councilmember Ravel, are you satisfied with that explanation?
Yes, I am.
Okay, thank you. Thank you, Mr. Cummings. So now we're going to move on to our next item, which is,
I'm sorry, 9.11.3.
okay, it's 9.11.3.4, subsection E. Mayor Biss.
Yeah, I'm sorry, I keep harping on this. I'm really excited that we're going to have a Finance and Budget Committee, but the language about recommend funding for city pensions, I still haven't gotten an answer that I feel comfortable with regarding the interaction between this responsibility and the responsibility of the pension boards, which have fiduciary responsibilities that are really serious. And I do think that having anybody who's looking at the city's finances think about pensions is really makes sense, but the specific task of recommending funding seems like it's pursuant to statute and fiduciary duty, somebody else's job, and this makes me a little uneasy with respect to that.
Before I call on you, Councilmember Kelly, could I put on my gray beard and explain what we've done before, which might provide some light on this? So we do get a report from our pension boards with respect to what their recommendation is, what they would like to see the city, how they would like to see the city fund, and at what levels. And we take that into consideration during our budget process. We haven't always followed their recommendation. And so that I think it's acceptable for the Finance and Budget Committee to obviously consult with them and take their recommendations under advisement, but then to make the decision, the recommendation on pension funding with the totality of circumstances of the budget. So, for instance, we decided probably 12 years ago that we would increase our pension funding significantly above. That's when we did a special task force and discovered that the auditors had not accurately been predicting what we should fund. And so then we significantly increased that with the idea of a plan to keep our pension funding higher than what the state recommended, certainly, but also what our prior auditor had recommended. That our pension boards were very happy about that. Obviously, they would like us to fund even more, but that was the best that we felt we could do, and we've maintained it for all of those years. Okay. Now, Councilmember Kelly.
Yes, I concur with Chairperson Nguyen. I think it's just replaces the liaison aspect of AP&W. It's now takes up that role. I agree. So Daniel, it's more of a liaison. It's not determining funding.
And Chair Nguyen, I just wanted to point out to Councilmember Kelly's point on the last provision on June 21st, the committee voted to amend 9.4 to remove the liaisons for the pension boards to APW. And so that was the purpose behind the proposed amendment for 91134E as presented to me by Councilmember Kelly.
Daniel, would you be more comfortable if it said review rather than recommend?
So right now, E reads that the Finance and Budget Committee shall perform the following functions. E, recommend funding for city pensions, including debt issuance and the capital plan.
So to Councilmember Newsom's point, I'm sorry, Chair Nguyen, to Councilmember Newsom's point, the original proposal that came to this committee was review and recommend. And then now it's being revised to recommend funding, and it eliminates the terms long-term funding. So I think what Councilmember Newsom was asking is if we take away the recommend and leave it as review.
I'm just one of 10 people up here. I'm happy to just vote. And, it's not the end of the world.
But Mayor Biss, could you restate what your concerns are?
I mean, Councilmember Newsom did really hit the crux of it. The recommend funding strikes me as precisely the job of the pension boards. And so I walk away, I sort of look at this and I ask myself, well, okay, if we've got this board and then this other committee, both of whose jobs are to recommend funding, why? And how are we supposed to take those advice seriously? How am I, as a person expected to make appointments to both boards, supposed to figure out, well, this type of person is well suited for that recommendation about pension funding and this other person is suited for this other one? It's not the end of the world. It's late. I'm happy to vote. And I think this will pass, and that's fine. It just made me a little uncomfortable, so I wanted to pull it off the agenda and see how people reacted to that.
I understand. Okay. Next, I have Councilmember Fleming, then Councilmember Reed, and then Councilmember Braithwaite.
I was just going to reiterate what Newsma said in terms of if it said, because I do think we don't want to have two boards. I think we have a ton of boards now, and some of them have some overlap, people might say. So review long-term funding. I think any board or commission we put forward, I think they understand that they are giving some suggested recommendations to council, which we can or cannot approve, right? And so I think if we say review funding for city pensions, that's not a total conflict with the pension board. And each board knows that they can bring forward whatever they want, and we have the authority, and we are being charged with approving what we think is best, regardless of what their recommendations are.
Councilmember Reed.
So I was going to just make that motion. I don't know if Alderman Braithwaite had a statement to the original motion, but I was just going to make the amendment to review. So I'll make the motion to. Is there even a motion on the floor? So first, so I will move that we approve rule. What is it? I'm sorry. 9.11.3.4 F, or is it E? F. And
excuse me,
it is E. It is E. Thank you.
It's E.
So E, 9.11.3.4 E, and my motion is that read that the committee review the finances as opposed to recommend.
So you propose retaining review and striking recommend.
Yes.
All right.
I,
Okay. Ms. Francelno, could you call the roll on that?
Councilmember Kelly?
No.
Councilmember Braithwaite?
aye.
Councilmember Wynn?
Aye.
Councilmember Nusma?
Aye.
Councilmember Burns?
Aye.
Councilmember Sufferton? Councilmember Ravel?
Aye.
Councilmember Reed?
Aye.
Councilmember Fleming? Mayor Biss?
Aye.
So by a vote of 9-1, that amendment passes. So now can we take up the entire 9.11.3.4?
But I.
Okay, thank you. All right. Oh, just the E. Thank you. Thank you very much. Okay.
Okey-dokey. We're done with it. I'm good with it.
So next, we are going to 10.7.
So in light of what happened as we addressed R2, I would recommend that we simply bypass 10.7.
We want to strike it.
We'll simply take no action, make no motion, move on.
So I would move. Madam Chair, I would move that we strike 10.7.
There's no
from the
striking
rules.
it. We're just.
There's
keep
no
going.
motion on the floor, and I'm
Yeah.
suggesting we not make one and just move on.
We move
Well-
on. Well, wait. Okay.
Is it then removed?
Yes, because we already voted on the rules.
Okay,
Okay. All right. So
Got it.
10.7 is moot.
got it.
Okay. So the next item is 12.1. Mayor Biss, I believe you took this one off?
I would like,
Oh, all right.
I didn't take it off, but I'll move that we approve item 12.1. Yes, as written in this document.
So this
okay.
one is, 12.1 is no council member shall speak for longer than
10 minutes.
10 minutes, that's the proposal, on the same subjects except by consent of a majority of the council. Council consent shall be assumed in the absence of objections by any council member or the mayor.
Right.
So it's been moved, and has it been seconded?
No.
I'd like to make amendment then.
Well, there's no second, but I would seek
So
a second
wait.
for discussion.
I'm sorry, one at a time. It hasn't been seconded.
So since it hasn't been
So-
seconded, I
Seek
wanted
a
to make an
second for
amendment.
discussion.
It fails, the motion fails for lack of a second.
So then are we going to revert back to the
So then.
5?
There is no motion then.
So since there's no motion to change it, so then it remains at 5 minutes.
Okay, just so that's clear.
Yeah, so then it remains at 5 minutes.
So that means that each council member only has 5 minutes, or they can be ruled out of order if they speak for more than 5 minutes on any single subject. And that's a rule that should be enforced.
That's correct. That's what we're saying.
No more than 5 minutes. No matter how many motions are made, you get 5 minutes to speak on a single subject, on a single agenda item. All right. Let's enforce the rules. Let's make sure we enforce these rules then. You can't speak for more than 5
That's
minutes on
fine.
a single item.
So next, the next item that I see is it 18 point?
We're on the 18. so
18.7?
Yes, 18.7, I'm sorry.
All right, so 18.7. Mayor Biss.
So these were recommendations made by me for both 18.7 and 18.8. They're in parallel. They basically say that if you're going to make a substantive amendment, you got to do it in writing. I'm sorry, Councilmember, yes, page 66. My view, having seen now for a couple of months what happens when we make motions on the fly, even when the person in the chair makes a good faith effort, as I have when I've been in the chair, to read everything carefully out loud. It's just, it allows for mistakes. It facilitates confusion. I've seen a lot of Monday morning quarterbacking emails asking, wait, what do we exactly vote on? And so we're all up here with devices. I think it's absolutely possible for us to stand at ease for a minute or 2 minutes while someone drafts a motion and emails it to the chair or emails it to the whole council who can read it. I will say, though, that if folks aren't comfortable with this, I did realize that as mayor, I have the ability to enforce this without it being in the rules. And so I would say, I think this is a good idea, but just for information, moving forward, in council, I am going to request that substantive amendments and substitute motions be made in writing, just to make sure we don't make mistakes.
All right, Councilmember Reed?
Yeah, the reason I pulled this is I do think it's a generally good idea, but what I think of is there is no motion on the floor until someone has been recognized by the chair and made a motion. So, let's say use a random, Alderman Fleming often uses the example of painting the sky purple. So let's just say that there's in the agenda it says we're going to paint the sky purple. If the chair, if Mayor Biss recognizes me, that's Alderman Fleming's proposal, recognizes me first, and I say we're going to paint the sky blue, which is completely different from what was in the agenda, that's the substantive motion that's on the floor, and thereby that supersedes what was in the agenda, because that's the motion. And so in order for even to go back to the original thing, it would have to be, or whatever, we'd have to go and put it in writing. So I think we should say, not the motion, but if you want to make a substantive change to what's in the agenda to be more clear, or if the mayor just makes it a practice that whoever recommended the item, he recognizes that person to make the motion, and we do that with all chairs, I think that solves it as well. But just to be clear, this could be, thank you.
May I ask a question, though? I guess maybe I'm reading this rule differently. So my reading of what's being proposed, and please correct me if I have it wrong, is that it's an amendment to an original motion that's already been made.
Yeah, I think that's Councilmember Reed's point. I think he's right? What's in my head is, oh, hey, the original motion is something in the agenda, so we don't need to make that in writing. And it's the amendments that we're making on the fly where there could be confusion. Councilmember Reed rightly says, listen, the original motion could also be a thing on the fly, and maybe this rule ought to cover that as well. So I think that's the point that he's making, and I think he's correct about that.
Okay. All right, okay. Councilmember Fleming.
Yeah, quick clarifying question. So are you saying if I want to make an amendment, I'm able to do that if I, like right now, would text or email the clerk something as I'm sitting here, and then I can make it? Or do I need to do this like I would do it, and then I'd have to get some kind of approval, and then I'm just trying to think of, like, to Councilmember Burns' point earlier, like if I want to make a change, can I both say it right now and type the clerk real quick, and that's covered?
Absolutely. Yeah, what I have in mind is you say, okay, I want to make a motion to do blah, 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 and then the person in the chair, instead of trying to say it out loud in a way that's super clear that everyone agrees on and hoping that it all gets transcribed properly into everyone's mind, the chair says, okay, we're all going to stand at ease while Councilmember Fleming takes 30 seconds to write it down and then emails it to the council. It's no secret we're all sitting up here with our laptops open. We could all even probably read it, but if not, the person in the chair could read out loud the thing that you sent, and it just diminishes the risk of confusion. But yeah, this is not meant to curtail the ability to do things in the moment on the fly. It's just meant to make sure that we really all know what one another are talking about before anybody votes.
Okay.
Okay, thank you. Thank you for the clarification. All right, so did we move this?
We didn't, and we're in this sort of MC Escher situation where there's now an amendment to this being proposed, but it's not in effect yet, so we don't have to make that amendment in writing. But I think Councilmember Reed is proposing a slight modification of the language, and I agree with what he's getting at, but I'm not sure exactly how to say it.
Councilmember Newsma.
Okay.
It's my understanding, though, that it's my understanding, Mayor Biss, that whether or not we approve these amendments as drafted, it's your intention to enforce the practice anyway. So perhaps rendering this discussion moot.
Yeah, that's an absolutely fair point. We can just move on if that's...
Yeah. Currently, a council member or the mayor or the clerk, in fact, also has the right to just request that a motion be reduced to writing.
Yeah.
But the only difference is this says it wouldn't be in order unless it's reduced to writing, whereas you couldn't necessarily enforce that it's not in order if it's not reduced to writing.
Correct. That's right. So theoretically, as the rule currently stands, I could say, no, I want that motion to be in writing, and someone could say no, and then there would be this sort of weird kind of constitutional crisis up
Right.
here.
So so if we take, I'm sorry. go
Also,
ahead.
just as a point of clarification, is substantive motion a thing, or, I hate to be this
That's
pedantic
actually-
with
no,
English,
that's
but
a-
would it make more sense if it said a substantive amendment to a motion?
No, substantive motion means that is the main motion, essentially, that it's the original motion that was on the floor. So this wouldn't apply. So let's say there's a main motion, someone makes an amendment, and then someone wants to amend the amendment. This would not apply to that, and you couldn't enforce that on that. It would only be enforced on the main motion.
Well, I think that's probably true, but I also think that in many instances, the council, when we are dealing with complex language, we have taken a pause till someone can write it and then submit it to all of us. That has happened a number of times during prior councils, just to make sure that we have the language correct. But I'm sorry.
What if we just say this is best practice and then we don't have to even make a rule, right? Councilman Burns already brought it up. I think we all kind of agree it's good to have things in writing if there are big changes, and then we can move on. Or do we need a rule?
So, well, I think the mayor would, the mayor would like to have this in our rules, correct, Mayor?
I guess, if everyone is ready for me to be kind of a pain in the rear about it and not make exceptions in the moment on Monday nights, then I'm happy to just move on.
Well, I actually think this is helpful for all of us, because then we all know what we're voting on. It's actually been, because it's been transcribed into writing, whoever is writing it has to work it out in their head. Whenever you write something down, you have to work it out in your head to figure out how it's formulated and how it will operate. So I think that this will be helpful to us, and it'd be helpful to the public as well, to understand clearly what we're doing. So I think this is a good idea.
So if I can interject just a second, Chair Nguyen.
Go ahead.
The language as proposed, as Councilmember Reed pointed out, is that the amendment cannot be considered in order for it unless it is reduced to writing. The 18.1 is mandatory language if there's a request by a council member, clerk, or the mayor for it to be reduced to writing. And it will be up to the chair to recognize if the amendment should go forward if that request is not fulfilled. But the rules do require it to be mandatory to be reduced to writing. So I'm not advocating either way. I just wanted to point that out for the committee so that they understand that if the mayor or the council member or the clerk asks for it to be in writing, it's mandatory that it be reduced to writing. And it'll be up to the chair to consider whether that amendment is actually appropriate.
And you would be the chair, right, in the council situation, so we could just leave it at that.
Yeah, we could. All right. Mayor Biss, it's up to you. It's whatever,
If
what
I
would you
can,
like us to
just
do?
clarity, the chair couldn't say, there's nothing that would give the chair authority to say that the motion is out of order if it hasn't been reduced to writing. There's no rule that says it, unless we adopt this, there is no rule that says it has to be reduced to writing. So theoretically, you can request that it's reduced to writing, and that could be done after the meeting or later.
But 18.1 says a motion is not before the council until it's been seconded. A motion shall be reduced to writing if requested by a council member, the clerk, or the mayor.
But it doesn't say it's not in order if it's not reduced to writing. I think there's a period between.
But it says, it says a motion shall. So if one of the members of the council, the clerk or the mayor, requests it, then it's not in order because it's a shall, not a may.
Okay.
I'm very content leaving it be, trying to effectuate what I have in mind under the current rules, which I expect will be possible. If it turns out to be problematic, we know where to come back to.
All right, so then we are not changing 18.7. We're not adding the red line. Is that correct?
Correct, for both 18.7 and 18.8.
Okay, so we are leaving those as is. We're not making changes. That's right. All right, okay, so now we're at 18.11. This is, I'll just read it. Special order of business refers to a docket item which will be considered by council at a specified date that did not originate from any council committee or subcommittee and may be placed on the agenda of a council meeting with 5 days prior notice sent to the city council via electronic mail. A special order of business can be placed on the agenda at the request of the mayor or a majority of the city council in open session of the city council. And
So moved.
wait, hold on, I haven't finished reading, and then or city manager. So or city manager has been stricken in this. Okay, the proposal is to strike or the city manager. So now, would someone make a, I
sorry.
read this, so I haven't made the motion, though. Could someone make a motion?
That's what I'm doing, making the motion.
What's the motion?
What is in the packet, as it was written, as it was drafted, as you just read it.
Okay, thank you. Councilmember Braithwaite?
So
but be-
I flip on my light.
It's not on, Clerk Reed. Now it is, okay. So.
I'll
but-
second.
Okay, thank you. All right. Deputy City Manager Ganderski would like to.
Oh, I'm
have-
sorry, as the maker of the motion,
I'm sorry, I can't hear you very clearly. So let's hear from Ms. Ganderski because she has something to raise about this point.
So just a point of clarification, since the provision, I think it was 2.1F, did not pass for new business. I think this was supposed to go in tandem. If I recall correctly, Councilmember Reed had proposed 2.1F as new business for the city manager to put on items and to strike 18.11, disallowing the city manager from putting on items of special order of business. So I just, as a point of clarification, I just want the committee to be aware that this would leave the city manager without an avenue to put on special orders of business.
Yeah.
Okay, thank you. Now.
Or urgent items, I guess.
Okay.
Yeah.
So the motion has been made to, could you restate the motion, Councilmember Reed?
The motion is to adopt Rule 18.11 as it is presented in our packet.
All right, so striking or the city manager?
Correct.
Okay.
So,
Is there a second? Okay, all right.
As the
Councilmember
maker of the
Braithwaite?
motion, I get to speak first.
I can't hear you.
As the maker of the motion, I get to speak
Yes,
first.
go right ahead, Councilmember Reed, then Councilmember Braithwaite.
So it is unfortunate that we voted down the new business, and I would appreciate if we looked at that again, because what this does is if we have the city manager who's unilaterally able to put items on the agenda as a special order of business, that to me is stepping into the legislative realm and limits the rights of members, of the voting members, to be able to hold something for further deliberation. I think if we are going to limit the rights of voting members, only voting members and only the mayor and voting members, only council members should be able to limit the rights of members through either a legislative action, which is a majority vote of the council to limit the rights of other members, which is kind of, akin to a suspension of the rules, or items that raise to, high importance. The mayor has the ability to put it on the agenda unilaterally as a special order of business, again, limiting the rights of members to hold an item for deliberation because of its importance. And so that's why I think it made sense to also have a place for new business where the city manager could put something on without limiting the rights of members to hold an item. But, here we are.
Thank you. Councilmember Braithwaite, and then Mayor Biss.
No, thank you, Madam Chair. I think this is an important one, and sometimes when we refer to the city manager, I feel like we're not talking about a professional who runs the city, but a popularity contest. I think in looking at previous councils that I've served on, special order of businesses have only come up typically when we're talking about liquor licenses or things that are critical to the operations of our business operations, which the city manager is specifically held responsible for. I think we've addressed this previously, and the mayor spoke to this, within the last 3 months, special business has sort of fast-tracked, and I think that is the source of some complaints of council members, that there are some things that just take time. And looking at an ordinance in another city and how it pertains to the city of Evanston based on a number of different factors, it isn't always a cookie approach. So the one part, Madam Chair, that I was just seeking a little bit of clarification on is it may be placed on the meeting with 5 days prior notice, just to unpack that a bit, because I've read it a couple of times, and I think what helps me to get through it is it may be placed on the agenda, and if we're talking about the may be placed, that's where I'm going to go back to. It's either mayor, council, or city manager, why I think that it's important to leave that in the rules as it was originally stated, if that makes sense.
Yes, that makes sense to me.
Okay.
Mayor Biss, then Councilmember Nusma, and then Councilmember Ravel.
So I'll just say from the jump, I intend to support this. It seems to me that the nub of the issue is, well, a nub of the issue. There's three ways in the current rule to get a special order of business on the agenda. One is a majority of the council in an open session, which I'll put aside for the moment. One is the mayor, and one is the city manager. So the heart of the question is, what do we want to have happen should the mayor and the city manager have a fundamental disagreement about whether something ought to appear on the agenda as a special order of business, right? Because we all know if this passes, then on a regular basis, the city manager will ask me to put, or whoever the mayor is, to put special orders of business on the agenda, and 99 times out of 100, the mayor will say yes. The question is, what do we as a council want to occur in the one time out of 100 that there's a fundamental disagreement? My method of resolving that is to go back to the question of, what were we elected to do? It seems to me that we were elected to run the legislative function of the city government, and that includes obviously every vote that we take up here, but at its root, I think it also includes what winds up on this agenda. And so I don't imagine the distinction between this passing and not being practically very important based on how the current city manager and the current mayor work well together. I think we'll agree probably 99 times out of 100, maybe more. But should there be a fundamental disagreement, I think it makes sense for the elected official to be the person who ultimately determines whether or not that controversial item that some want on the agenda and some don't want on the agenda, in fact, winds up there. That's why I'm going to vote yes.
Councilmember Nusma.
Let's refer to Rule 2.7, which is a relatively new rule, which I assume we have approved some point along the line. That rule states the mayor must approve the agenda before it's published. So by my reading, that kind of makes 18.11 somewhat moot. The city manager may request a special order of business, but if the mayor, as the mayor just said, has a disagreement, the mayor, per Rule 2.7, does not have to allow it on the agenda.
So let's just clear it up and remove it.
Hold on. We have Councilmember Ravel.
Well, Councilmember Nusma raises an interesting point. I guess what I was going to say is we have a council manager form of government, and so the city manager does have an important role to play in the business of the council. So I don't know what to do about the conflict with that Councilmember Nusma just mentioned.
Chair Nguyen, if I can.
Yes. Go ahead, Mr.
This
Cummings.
actually goes into what's raised in R9 in the memo under a bunch of different things that I mentioned in that memo for R9, whether it be state law or case law. It's arguable that the agenda and what goes on the agenda is an administrative function of the city, and that would fall under the office of the city manager. So to, notwithstanding Rule 2.7, the mayor can decline to publish an agenda because of he doesn't agree with what's on it. But I think, if there does need to be an avenue to bring something to council that does not naturally flow to a committee, there should be some avenue in which to get that there. And I would hope that the mayor, to his point, if the city manager comes to the mayor and says, hey, the council needs to know this and understand this, that it would appear on the agenda, even with 2.7 and even if it's removed from 1811. But I just wanted to point out that this goes into some of the stuff that's discussed in R9 when we talk about the referrals committee.
Thank you. I'm just going to step in here for 1 second and say, if we're thinking of hypotheticals, Mayor Biss, about what could possibly happen, 99, and I recognize, and I hope it's actually 999 times out of 1,000. But at the same time, what if there is a mayor who is really not acting in the best interests of Evanston, or is deciding unilaterally, I don't want this on the agenda, I don't want that on the agenda, I don't want this. But these are things that have to be on the agenda in order for the city to function. Now, I know I'm just playing hypothetical. So we need to have the city manager be able to continue, as Councilmember Braithwaite said, the function of city government. And so I have never heard of this being a problem and being 24 years on the council, this has never been a problem. So I think we're trying to solve a problem that doesn't exist. And actually, in some ways, this is a fail-safe so that in case we have a rogue mayor who decides, nope, not going to have things on the council agenda, that we have a city manager who is our chief executive officer who actually gets things on the council agenda and the council addresses them.
I'm happy to respond to that if you
Go ahead.
would have that.
Yeah.
I think we have a fundamental difference here, respectfully. Look around. This country is full of bad elected officials, right? There's terrible elected officials all over the place, and bad things happen as a result of that. I think that our system of government protects us from a rogue mayor doing all kinds of bad things. It protects us from a rogue mayor making politically motivated hires and fires. It protects us from a rogue mayor interfering with the provision of city services in a way that's motivated by concerns other than the best interest of the public. It prevents all kinds of stuff related to the management of city government. I don't think that our form of government exists to protect us from bad elected officials making bad choices in the context of the legislative function of the city council. And I think the residents are stuck with that bad outcome if they elect bad people to sit up here, just as the city staff shouldn't be empowered to overrule poor decisions made by the council if 5 or more members vote for that. And I think the question of what goes on the agenda is a legislative question that we are, if we have bad elected officials and make bad choices, that's what you get. And I think that, analogously, we might have a bad rogue mayor who makes terrible appointments to boards and commissions. And everyone knows it. And everyone knows that rotten mayor is doing political favors to donors and appointing corrupt people. And there's nothing anyone can do about it because that's the thing that we elect a mayor to do. And I would argue we elect the 10 of us to run what happens up here, and this to me is of a piece with that.
Yeah, and you and I could go back and forth because when we hire a chief executive officer to make sure that things go out to bid appropriately and that we know when our licenses and our leases need to be renewed, and that we hire professional engineers and that we make sure we have people in our water plant who are all doing the right thing. And a number of those functions of our city government pass through the council in order to keep things, that we decide to renew a lease on one of our computer licenses. And so I see your point on this, but if there's a failure to get something on an agenda and we don't renew the parking system, then, some people will be very happy about that. But all right, I'll pick something else. We don't renew the water testing system at the water plant. But this is a way that the city manager makes sure that the water plant keeps running. And you and I just have a fundamental difference on this. So I'll stop playing law professor and just say I think we do need this other avenue. Councilmember, Reed.
Yeah, I will say that the avenue was proposed earlier, which was new business. The city manager would be able to put something on as new business. We just voted that down almost unanimously, and that would have been the avenue for the city manager to get an item on the agenda without limiting the rights of members to hold something for deliberation. That's why those two came together and why I proposed them. And we decided that we didn't want to do that. And so now we're going to just say that, the sky is falling. The city manager, a rogue mayor, can stop the city manager from getting something on the agenda. And the mayor, some rogue mayor. And the idea of good or bad is really subjective. So who knows what's good or, but that avenue was new business. And the city manager would have still been able to put something on the agenda as new business, like I said, without limiting the rights of members. And so I agree with Mayor Biss, that's why I put this forward, that the legislative function should be the responsibility of this elected body, and the city manager should not be able to unilaterally restrict the rights of voting members.
Thank you. Councilmember Fleming.
Yeah, real quick. So one, I want to mention that we just voted for 5 minutes, and I think people are getting over their 5 minutes, so just be mindful. And then two, I think the issue for me, I don't mind, the manager, the mayor, and the council having access to special order business. I think my experience here is that I question what we consider special order business, because I've sat here where there's been many things brought before us as special order business that just sometimes seem like either poor planning on people's parts or things that I think are, just not special in my mind, right? So I think of special being something that's really, we have to talk about it as a council, budget, whatever. And there's been many things that have been brought forward that I think, in my opinion, don't qualify. So, not that we're going to do that tonight, but I think it probably makes sense in my mind to clarify what special order business is. But also for me, part of the legislative part is why I supported the referrals committee, because I think that everything needs to go through the same process before it comes to the council, so that no one feels like they're having more access, whether it's council, mayor, manager, whoever, having more access to the agenda, because really, obviously, we're talking about and voting on things that are only on the agenda. And so if someone has more access to the agenda than someone else, that leaves, the citizens at a disadvantage. And so, again, I don't love special orders of business because I think they're not really clear in terms of what qualifies as special order business. But if we are going to have access to them, I just think that there should be a little more of a checks and balances to that. And people need to be able to justify why this needs to come before a special order of business versus either through the committees or, just a city manager's report or some kind of special presentation, whatever. So that is really my concern. We don't really clarify what special order business, what constitutes a special order business.
Thank you. I see no more lights. Sorry.
Just the last thing, because I was going to be ready to hold this, and I feel like I want to make the statement, can't we all just get along? As it relates to this, we have 3 entities that can bring a special order to business that ultimately we all would vote on. And the 2 people who don't have a vote is the city manager and the mayor. And that's what we spent like the last, I have no idea talking about. So I think if everybody's ready to vote, let's vote. But I want you to keep in mind, particularly council, the 2 people who do not have a vote, unless there's a unforeseen tie or something crazy, the mayor nor the city manager vote on any piece of legislation that we pass, unless there's a tie for the mayor. So I think we leave it the way it is, keeping in mind that there are critical parts of our function of our role, critical parts of the role of the city manager that I can't even go back and pass, that will have to come before us, that is critical to our operations, that we want to leave this in there. And if we can't make the decision now, then we should just hold it and we can argue about it, just given the time.
All right, Councilmember Reed.
This has been held a few times, but I will note, again, someone can make a motion to reconsider the new business. That is a perfectly reasonable avenue for the city manager to be able to put an item on the agenda without limiting the rights of the voting members. And there's a reason the city manager doesn't vote, because the city manager is not elected democratically. Yeah.
So, okay, I have Councilmember Newsma, have you spoken already?
Not on this one.
Okay,
I
and
just
then
like, again, to refer to Rule 2.7, which says the mayor must approve the agenda before it is published. Presumably, that would include new business, had we chosen to adopt a new business rule. So I don't think that would serve the purpose that Councilmember Reed is suggesting it would. I'd also like to add that
That's
should
the
we
case still.
choose to strike the city manager language from 18.11, as is on the table right now, in the case of a rogue mayor, we still have a check and balance in the form of the city council. And the city manager could, when confronted with a rogue mayor, unwilling to put an item on the agenda, appeal to a majority of the city council and override the future hypothetical rogue mayor.
Okay.
So I'm comfortable striking this language. I'm comfortable keeping it. I think we're splitting hairs.
Okay. Councilmember Burns.
I'm fine with that right there. That makes sense to me. I was just going to say, having the city manager have to get city council approval to place a special order on the business sounds about right as well. I mean, I'm fine with what you just said, but if in order for an individual council member to get something as a special order of business, it requires a majority vote. I think the city manager should have to do the same thing. So that's another option, is my point. But I think what you're saying makes some sense too. The other thing about what was the other point about the has to approve the agenda? The mayor having to approve the agenda. I don't know if that's the same as council approving committee members. Like we can approve it as like wholesale, the whole thing, but can we strike things from it? I don't know if that's clear in the language, if that makes sense. So, but I just wanted to add those two things.
Okay. All right, I think we should vote. Ms. Francelno, would you take the vote on striking, so this is 18.11, and this is the motion to strike the ability of the city manager to put special orders of business on the agenda.
Councilmember Kelly?
Aye.
Councilmember Braithwaite? Councilmember Nguyen?
No.
Councilmember Newsma?
Aye.
Councilmember Burns?
Aye.
Councilmember Sefferden?
Aye.
Councilmember Ravel?
No.
Councilmember Reed?
Aye.
Councilmember Fleming? Mayor Biss?
Aye.
We're at 3 noes.
So 7-3, the motion carries. All right, we're moving on next to, I believe it's 18.13. Yes. Yes, Councilmember Newsma.
Yeah, so it was my understanding we had pulled 18.13 in a previous Rules Committee meeting, but there has been some subsequent discussion, and here it is again for discussion, so I'd just like to hear what the reasoning is, and if that's Councilmember Fleming or...
Yeah.
Okay.
All right, Councilmember Fleming?
Yeah, so, supported the notes idea. I did like your idea in terms of, each memo having a piece of this, which I think this language does not forbid, that from happening. But I do think there are going to be times where we want more information. And I would like, if we go forward with this referrals committee or however we move forward in that direction, I would like that to be something that people can, notate or request that, their memo also come with not only kind of, if the memos contain everything here, so this A through F, and it's just kind of a one sentence, that they might say, hey, I want a more clear explanation to how my proposal is going to impact property taxes or, whatever it is. Because again, I think us having more information in the packet before we sit here allows us to have not only a better discussion, but also an efficient discussion. And so I thought about this some more and went back and asked for this language to be added. I think it captures what you mentioned before. It just allows people to go further in saying that they would like to have even more information on one particular item. So my goal was not to replace kind of your previous motion that each memo include 1 or 2 sentences on these things, if that's what we want to do as a council or city manager wants to do. But I do think it makes sense if we're going in, again, in this idea of a more kind of streamlined or structured referral process, that people can then say, hey, I want, a better explanation on equity or how this affects legally, because I don't think it, for me, is helpful for our legal department to be trying to make a very long explanation necessarily on the floor without a lot of forethought. So anyway, that's my rationale.
Is there any difference to this language than what we had looked at earlier?
I think the difference is if they would like the staff note, then it needs to go in when they make their referral or a couple weeks before the item is going to appear on the agenda, right? And so, again, back to my sky painting blue, that would cost, or purple, that would cost them money and maybe would be a legal ramification. And instead of asking, Dave Stoneback or somebody to just tell me on the fly how much is this going to cost, I actually can would be my responsibility to ask for that in a memo. And so staff is prepared and I'm prepared to make a vote based on accurate information.
And that request would be made at the time of the referral. So just providing some more guidance as to what a council member expects of staff when it comes to their analysis of the referral.
Exactly. It can come at the time of referral, or maybe you've had some time to think about it and you're like, you know what, hey, I want to add this to a referral I put in before, but, didn't think of it at the time. So either or, but I think it's on us to make sure staff is clear what we want in the referral. And this just provides, for these topics we have listed here, a deeper analysis than we might get in a general referral.
Right. So by the time it appears in our packet, this process already would have taken place.
Yes, this would be part of what comes in the memo. So maybe instead of a 1-page memo, it would be a 2-page memo because it has an additional, fiscal note that's an actual page.
So this wouldn't turn into a parliamentary delay procedure.
Well, as written, you would make that request when you request a referral. If you don't, then you have the option to come back, make the request, giving staff, I have in here 2 weeks, maybe it didn't take that long, but giving staff some time to produce that before it comes in the memo. Now, you don't have to request these things, but I think then if you don't request it, when we have a conversation, if we ask legal or whoever else for something, I think we have to know that they might not know the answer on the fly.
So, Councilmember Fleming, do you mind? So, it's just so I have. So this actually, as you're describing it here, to me, in some ways helps the referral committee because this will allow the referral committee to understand better what the referral is and the depth of information that is being requested with the referral.
Yes, but I think it also allows us to get more information if we're looking, it allows us to request more detailed information on a particular topic. It also ideally gives staff more direction what we're looking for in our memos. And then again, allows us to have a better, I think, more thorough conversation here on the dais with the information we're presented instead of trying to pull that information out of staff when they might not be prepared to answer. Okay. So I think it does all of those things. It's really, in my opinion, not for the benefit of the referral committee. I just mentioned that because I said, whatever the referral committee comes up with in terms of the process of you putting in the referrals, I think everyone agreed they should be in writing, maybe submitted to the clerk. That would be on there. You would say, I want this additional information as part of my memo.
We don't necessarily need this rule to ask for information to be included in the memo, but more information is certainly when we ask for it, I would expect it to be delivered. And with that rationale, I don't have a problem including this.
Yeah, I don't think we need this rule to ask for more information. I think having this gives our staff, again, we haven't had that, so it gives our staff a little more information in terms of what we are looking for. So if I say I want a financial explanation, this gives them at least, obviously it's on me to elaborate, but this gives them an idea because if you look at the memos now, that might be 3 sentences, and you might be looking for something more.
Okay, so next I have Councilmember Reed, then Mayor Biss, and then Councilmember Ravel. Councilmember Reed?
I will note that I've been keeping track of time, and there's some council members who would be precluded from speaking again under our current rules. So, that's just as a note. So I think this new revision cleared up some stuff, as Alderman Newsom mentioned. This new version will not cause a hold, or delay action on items, which was a concern in the original version. But what I don't see here is for example, a special order of business gets placed on the agenda and does not go through the referral committee, because seemingly a special order of business, the council could vote directly to place it on the agenda at a certain date, and it would not go through the referral committee, I suppose. And given that, also there's the 2 weeks. So it says, any council member may request that staff fulfill a note in writing to the city clerk with the original referral, or at least 2 weeks before an item whose first appearance on an agenda of any board, commission, or committee on which that council member serves will be for final action. So this could be after the referral committee made. It could be, it could be when it was at any point. So it could be after the referral committee referred it to a committee, and so it doesn't seem like it would truly necessarily help guide the referral committee. So I just did want to make that note because it's not required before it goes to referral committee.
No, but before action.
It is required before it.
Well, it reads, any council member may request that staff fulfill a note in writing to the city clerk with their original referral, or at least 2 weeks before an item whose first appearance on an agenda.
I think that's best practice, but, it could just be after. All right. It could be after there's an introduction, and maybe I, as the person who's sponsoring it or whatever we're calling it nowadays, says, you know what, hey, I would like a fiscal note before this comes for action for better clarification or whatever. But again, this is all just an option. It is not a requirement that I'm putting on people.
And also to clarify, if a council member is making a referral, they can include that request with that referral. But for other items, any council member can make that request. It doesn't have to be the original referring council member.
Yes, it says any council member.
Right.
At least. Okay. Mayor Biss.
No, I was just making the same point Councilmember Newsom just made, which is that that's a pretty big difference. I'm happy either way, I don't care, but it's a pretty big difference between what's written down and what I think we've been discussing. Where what's written down, it's not just for the person whose idea this was. The person referring it can include a request with a referral, and then any of the 9 later on in the process can do so.
Right, but you can't do it on Friday when the packet comes out and the items are for action on Monday, right? So you would not be able to stall the item.
Yep.
And we all know our process. So if it's up for introduction 1 week, we know in 2 weeks it should be back for action. So you have right, but you have the responsibility, and if you want the note, to keeping track of where that is and making the referral. You can't hold up someone else's item saying, I want a referral the night of, a note the night of. Does that make sense?
Okay, I have Alderman Ravel and then Councilmember Reed.
I guess I had thought we were sort of independent of this, tying this request for the note to a referral or not. I thought we'd also been talking about wanting to have kind of as a regular practice that memos, certain kinds of memos would talk, for example, about how this particular ordinance is going to advance our CARP goals or something. I thought we wanted to be kind of moving in the direction of highlighting some of our goals and making sure that the memos showed how we were advancing those goals. So this is that's a whole different discussion that doesn't have to be in the rules, but I don't want this to preclude our coming back to that bigger discussion about CARP goals, for example.
Right, and I think at our last meeting, we discussed what our policy would be in terms of what we would expect in a memo from the staff, that it would look at all of those, it would include all of those goals, that whoever was drafting it would then get the sustainability officer to comment on those goals. And Sarah Flax to talk about affordable housing, all of those things would be included. So I agree with you on that, Councilmember Rubel.
So can I provide a clarifying point? And maybe we should change the rule to 10 minutes because we're all going over. But can I provide a clarifying point, which is in a conversation I had with City Manager Storley about the memos. I think she's planning, if my memory is correct, to make some changes to the memos, but that is not something, that is administrative function, I guess. And so that's part of the reason I changed the language for myself in here, is that we don't usually give direction on what is in the memo. And so I think that's an administrative function that Erica Storley is working on, with her team in the city manager's office, where those changes, I would think, or we can all communicate to her if we want those changes in there. But that would not be something we would then put in our council rules, like what is in the memo, if I'm correct.
All right, I have Councilmember Reed, and then I think we're ready to vote.
I'm sorry, kind of lost track. I did just want to note that sometimes we have a council meeting the very next week. There's some meetings where we have it on a Monday, and then the very next Monday we're coming back. And so there would not be a 2-week window in those cases. It would come up for introduction, and then the very next week it'd be for action. And so it wouldn't even be in order to request a note at that point, because it's not at least 2 weeks before action. We have three meetings a month, and so just by the nature of 3 meetings a month, typically, not every month.
Well, maybe they do.
Yeah.
Well, we could decide that it has to come in with, you could just delete the "or at least" and just say that these notes have to come in with the original referral. But I think that actually leaving this language in is helpful, because I think leaving in the language in is helpful. Go ahead, Councilmember Fleming.
No, and I'm sorry, I have to actually leave soon, but I'm not wed to the language. I want to just give staff time. I mean, I don't think I don't want to ask staff on Wednesday to produce something that's going to come out on Friday. I want to give people time to give me something that makes sense as a council member. So I'm not wed to the 2 weeks. I guess I always assume that everything that comes up will not come back for 2 weeks in most cases. Most things don't get turned around that quick in a week. If it is a week, then maybe we just can be flexible with each other. I mean, it's, not the end of the world, but.
Yeah, I agree. We do want to make sure we're getting a good product out of staff. Okay. Ms. Francelno, would you call the roll on, has this been voted? No. Would someone make a motion with respect to 18.3?
I'll move, or go ahead.
Go ahead, because I
I have an amendment to make, which is that instead of 2 weeks, it would just be at the point of introduction, which solves the.
I don't think we've moved this item.
Right, which is
okay. So I will
I'm
move
stating,
18.
Yeah.
You could do your amendment after. I'll move 18.13, which is any council member request that staff fulfill a note in writing to the city clerk with their original referral or 2 weeks before an item whose first appearance on the agenda, board, commission, or committee in which the council member serves will be for final action.
I will second that.
So one problem is with this, is that Deputy City Manager Ganderski just pointed out resolutions are not ordinances, and resolutions we don't require the 2 weeks. The 2 week, the 2 week between introduction and action. Yeah.
But then why would you wouldn't ask for a note for a resolution? Well,
or could
I guess you could ask for a note. So what are you suggesting that I do here? Would it take out the 2 weeks? Is that what we're getting to?
My thought would be, at the time of referral, I would do longer than 2 weeks then at that point. I mean, well, if it's a resolution, it's going to come on for a vote that particular time. It would have to be moved to be held or tabled.
But if you do it with the referral, then only the person putting the referral link is going to do it, right? Because Clerk Reed might not know what referral I'm putting in if we're going to a different system that's not called the wards.
I guess I would argue at that point, the referral committee might take a look at the item and vet to see if there would be questions ahead of time. So for a particular item that's going to require some substance and analysis, my thought would be the referral committee would look at those items and say, you know, while a note didn't come in with this referral, might this be something we should contact that council member about and see if he or she wants a note? Because this looks like something that could require more analysis.
Right, which could happen, but then that also doesn't give my peers an opportunity to ask for a note on something that I made a referral for. Because everybody's not on the referral committee.
Right. So, but if, okay.
So I'm happy to hold, I mean, this is, again, it's not in the rules yet. We can hold it, we can flush it out. I'm happy to talk to people offline. I'm flexible. I just wanted a mechanism where we could get the memos that we want, the memos that we need to make thorough decision. And I think already there's been a little, concern, frustration over what is or is not in a memo. So this was just my attempt at trying to make sure we can get what we need in the memo. So why don't we not vote on this one tonight? It's just one item. We can come back to it. I can work with people who have concerns and we can come up with something that makes sense.
Okay. Are you moving?
So I will stop. I will take it back my motion.
Right. So, okay. So it drops out, but it'll remain an item that we.
Yeah, we can come back to it another time.
Well,
then
revisit.
motion to hold. Yeah, motion to hold would be in order then.
Oh,
so
okay.
it is held. To the next
Okay,
meeting,
so I move that we hold 18.3.
Second.
All right. Okay. So 18.13 is held. Okay.
Whatever.
And then we're now at 22.1 and 22.2.
Right, those are conflicting, I believe.
So these two are conflicting?
Isn't that what Nick
Yeah.
said?
Right. I'm sorry.
There were competing amendments to these.
Oh, competing amendments to these. Okay, so this is items for reconsideration.
So
Nick, can you-
22.1, there was new language proposed by Mayor Biss to actually just rewrite 22.1. If that amendment is accepted, 22.2 becomes sort of obsolete.
Can you describe,
22.2.
can you just help us understand this a little bit better, Nick? Describe
I mean,
it a little bit.
I can, if you want,
Or
I can.
Mayor Biss, why don't you do that?
The current rules say that certain types of really critical things can be reconsidered day of. Everything else can be reconsidered at the next meeting.
Yes.
What this does is just say, and then a few things can't be reconsidered at all. What this says is everything can be reconsidered, but only at the same meeting. And the point is, as the mayor, a couple days after a meeting, I got an email asking me to sign a bunch of ordinances and resolutions, and yet it's still in order to reconsider the votes 2 weeks after that. Doesn't make any sense to me. So I just feel like motions to reconsider, they're a normal thing. They're on Robert's rules. We can do them, but let's not do them after the ordinance or resolution has been signed into law. Let's do them. This would harmonize our rules with Robert's rules that just make a motion to reconsider in order the same meeting that the initial thing had passed.
And the changes that are here in 22.1 make that change?
Correct.
Okay. All right. Would you
And so
want
to his point, Mayor Biss's suggested change to 22.1 is more efficient than what was proposed on June 7th, which was an amendment to 22.2, which said that motions to reconsider are only in order during the same meeting as the original motion.
So I move that we adopt all of the changes to section 22 that are represented in the packet.
Second.
All right. Ms. Francelno, could you call the roll?
Councilmember Kelly?
Aye.
Councilmember Braithwaite?
Say aye, say aye.
Councilmember Wynn.
Aye.
Councilmember Nusma.
Aye.
Councilmember Burns.
Aye.
Councilmember Sufferton. Councilmember Ravel.
Aye.
Councilmember Reed.
Aye.
Councilmember Fleming. Oh, she stepped out. Mayor Biss.
Aye.
Thank you, Mayor Biss. That saves all of us a lot of grief. 24.1, which reads, council members shall vote, this is the simultaneously and by electronic means.
Yeah, I pulled this off. I just didn't feel like we were ready to create this rule. There's a whole procurement process. I think we probably want to hear from staff about what it would cost. I think it's an intriguing idea, but I don't know we're ready to act.
Okay.
Motion to hold? Sorry.
Yeah.
That's a good one.
Second, I'll second it.
Well, I don't think we should hold it. We should maybe table it, because then it'll just come up at the next meeting, and I don't think we're going to be ready for it at the next
And he
meeting.
can always contact the chair and tell her not to add
You
it
know
on.
what, though,
When you hold
Councilmember
some.
Braithwaite, I think that Mayor Biss is correct. We should just drop this off.
Okay.
And at some point down the line, maybe we'll have found out about that city council stuff. And if it's priced right, then we can possibly think about it. So if we,
We'll leave it benched if I remove the hold, is that what you're saying?
I think actually if we don't act on it, then it drops away.
Perfect. I will remove or
Okay.
recant.
So if no one makes a motion with respect to 24.1, that's what we want to do.
Perfect. Thank
Okay.
you.
Then now we are going to vote on the entire packet. No, we don't need to unpack.
Done
Thank
it.
you
We're
all.
done.
Okay, it's been a really long day.
And now we're on
Okay.
to the third item.
Yes. So then this goes on to the city council agenda.
Fourth
as
item.
as amended.
Fourth item.
So now we're moving on to R5. Wait, we do actually, there is something that is on our items for discussion, and we have Community Development Director Nyden here to discuss this, and this has some urgency to it. So R7, which is discussion of current City of Evanston boards, committees, commissions, including realignment of Plan Commission and ZBA. Councilmember Burns, I'm happy to address the issue of looking at all our boards, commissions, and committees, and what is being proposed here tonight is the beginning of that. Okay, all right. So first, could someone,
Move R9.
yes, no, R7, it's
R7, Madam Chair, I'd like to move item R7, discussion of the current City of Evanston boards, committees, and commissions, including realignment of the Plan Commission and Zoning Board of Appeals. Councilmember Bobby Burns recommend that the Rules Committee discuss the existing city, we're here today to hear the commission, or on the Plan Commission and the Zoning Board of Appeals to provide direction to prepare an ordinance for City Council.
Is there a second?
Second.
Second, okay. Ms. Nyden? Good afternoon.
Good morning. Johanna Nyden, Community Development Director. Thank you for taking up this item. We've worked over the past few years to think about how we engage with our communities, how we create better, transparent, more clear processes. I think many of you, particularly newer members, might be not even sure how what a zoning board of appeals versus a plan commission does, and how those items are different. Our zoning code dictates the different duties, and that's enumerated in the memo, in the staff memo. But from face value and how we appear to our broader community, reviewing land use and zoning decisions really should be under one body. And increasingly, communities around Illinois are looking at how you bring those together. I think staff was just reviewing some of this. There's communities, I think Des Plaines, Darien may have already made those combinations. There's a couple others that I know are starting to consider this. We think it makes sense for Evanston to come under one body. Plan Commission generally meets twice a month. ZBA used to meet twice a month. It now meets once a month. So it's 3 meetings. That's a lot to follow. That's a lot of staff time. We publish notices. This streamlines a process for staff. It makes it easier for the public to understand why that land use decisions are under one body. It also gives us a chance to think about working groups or task forces that can focus on specific things that then can relate to zoning and planning decisions. So something like our comprehensive planning process might be undertaken by a plan commission, but it can be maybe a task force of people who have 6 months or 9 months or a year of availability, but aren't ready to commit to a 4 or 5 year term on a commission that meets every second Wednesday of the month. So this is just gives us some greater flexibility and maybe helps us bring in new members of our community to participate in these bodies.
My understanding is there have been some quorum issues lately as well.
There have been quorum issues. We have had, we will have some quorum issues. We've had fewer members of Zoning Board of Appeals, and we've had some resignations. The pandemic has resulted in people not necessarily wanting to come into an in-person meeting. They have childcare responsibilities, so we have people that we anticipate resigning in the short term. So there's a list, I think it made it into the packet, of members who are prepared to continue to serve under a combined committee structure. We had individual conversations with each member to apprise them that we were looking towards moving in this direction, and some had indicated that they wouldn't be interested in serving once the meetings were resumed to in-person, and we were left with 11 people. Ideally, we would get to a 9-member board, but 11 seemed like a good number that then we could reduce in a couple years as those members peeled off, not wanting to lose people who, particularly ones who've been on the committees for longer periods of time.
So Councilmember Braithwaite, did you have your light on?
I think she answered my question in terms of shrinking I was looking through the numbers, like what's the ideal number, and if we do combine it tonight, would we be able to function without cutting somebody out? So thank you.
Definitely we would want to do that.
That's a huge, good.
And I think there's at least one member who has indicated that there may be interest in serving in like a short-term working group kind of environment, but just can't do the.
Yeah. Thank you.
Councilmember Revelle.
Well, I do think this sounds like a good way to bring together all of our land use and zoning issues in one commission. Just real quickly about these task forces or working groups, would these be made up of non-commission members or potentially a mix, or what is your thinking about them?
Well, I think it would be, I'm envisioning that this is something that planning, for example, if Planning and Development wants to work on a specific issue, and their direction is to send this to the Planning Commission. Maybe the Planning Commission and P&D, or if the Planning and Land Use Commission now, they're working together. We decide, okay, this is something that needs special task force. We create working groups and task force and subcommittees all the time. When we did the update of the inclusionary housing ordinance a couple years ago, we had some folks that didn't necessarily want to participate in the Housing Commission, but were happy to lend a couple months of their time. So I guess I'm imagining it's a hybrid. Maybe it's a few people, maybe it's the council members, maybe it's members from other commissions and boards that have some particular land use ideas or concerns that we can merge those up. It's similar to what Sarah Flax had presented, I think, at the last Rules Committee about the realignment of those committees and how you think about some of the task forces, because people just can't commit to long-term activities.
I think this is a good idea because it is hard for people now to commit to these commissions and the ZBA. They're both significant commitments of time, and this way we are pooling the people who are interested in this topic into one committee rather than having to fill 2 committees. And it is confusing to the public about why ZBA versus Plan Commission, and why then do you have to go to both even. So I think this is creating efficiencies, and it's also using our pool of talent more efficiently too. And if there is a special task force, we find that people really are willing to serve on task forces because it's not, as you said, a 4-year commitment or a 5-year commitment, but that they can see, like, in the next year, they will have time to serve on something and they want to serve. Any other questions? Do we have a sense that this should go forward? All right. Okay. Mayor Biss?
Yeah, I think this is great. I just would say that this is a small piece of what I envision Councilmember Burns' initial referral to be, and I don't want that other discussion that, difficult, but I think important discussion to get lost either.
No.
So, yeah, certainly thumbs up to this, but I hope we maintain a commitment to really going through that project.
Well, I think, I will say, that with this consolidation and the one that we did just several weeks ago, we're significantly reducing the work of separate committees, and we're getting a lot of streamlining and efficiency from this. But certainly, we should keep moving forward on that. Councilmember Fleming.
Yeah, several years ago, you brought forward, with much community attention, realignment of the boards and committees, commissions. So maybe when we have the discussion to meet Councilmember Burns' question, you can bring that back forward to be in the packet for us to start thinking about. I don't know, I don't remember how relevant it is now, but you could bring that back for a conversation starter.
It was we had proposed the realignment of BCCs based on the STAR community goals,
right,
which I think this came up in regards to how memos were written and accomplishing goals. STAR Communities is now part of the U.S. GBC's lead for cities. So that has effectively gone away, that metric. But yeah,
some of those realignments still might
yeah.
make sense.
And I think there was some work done to think about how some of those would already come together anyway.
Yeah. Mm-hmm. Councilmember Newsma.
Star Communities has disappeared, but we are going to be doing an internal strategic planning process. And so it might be appropriate to reconsider our structure of BCCs in light of the outcome of that process, whatever it might be, to align BCCs with our strategic goals.
Mm-hmm.
Just throwing that out there for future consideration.
Yeah. So I think you have our direction, that you have our support on this.
We'll prepare an ordinance for the City Council to review.
All right. Okay.
Thank you.
Thank you. All right. Okay, so let's take up R5, which is yes, Alderman Sufferton.
Just real quick, R5 should be non-controversial and very fast. This would be me replacing Councilmember Fleming on the Planning and Development Committee with her consent.
Would you like to make a motion?
I move approval.
All right. Councilmember Reed.
I'm sorry, continue on with this.
Okay.
And then I'll just make one note. We would also have to amend the chair rotation and replace all of Alderman Fleming's chair times with mine.
Already done.
So should we deal with R6 first?
Right. No, and that can be done.
Oh, I'm just talking on the list where it says Alderman Fleming. It should say,
You're going to take her.
I'll take her spot, and I'll take her
because
chair spots.
You have the same senior.
Yeah.
Right. Okay. Okay. All right. Ms. Francelno, would you take the roll on R5?
Councilmember Kelly? Aye. Councilmember Braithwaite? Councilmember Nguyen?
Yes.
Councilmember Newsma?
Aye.
Councilmember Burns?
Aye.
Councilmember Sufferton?
Aye.
Councilmember Ravel?
Aye.
Councilmember Reed?
Aye.
Councilmember Fleming? Mayor Biss?
Aye.
All right. Next, Councilmember Reed. Or yes.
I move that we review the committee schedule to ensure that, I think to make edits that Councilmember Sufferton just suggested, as well as ensure that we're not violating a council rule by having someone serve as chair of two standing committees. And just a point of information, if I am asking a question of staff, does that count toward my 5-minute time and their response? Is that all packaged in my 5 minutes that I'm allotted?
Not their response.
No, I don't know. But I mean, I think it's when you're asking questions or talking.
So even their response would be included in my 5 minutes?
No.
Also,
their
staff
response
can
is
speak
not-
as long as they want, but
No,
as a
if
council member, I can
if
only
it
speak for 5
requires a
minutes.
long response, no, I don't think why that would be the case.
Okay.
Yeah. Wait, I'm sorry, Councilmember Fleming, I don't think your mic is on.
I'm sorry, I'm just seconding R6 so we can.
Yes.
Okay, and so my motion for R6 is that we, I wouldn't motion that we adopt this particular schedule. So if someone else wants to make that amendment, my motion was for a discussion of it and to take into account what staff has recommended here. I don't, go
I
ahead.
did a second so that we can have the discussion on it, right?
Sure.
Okay, so so on May 24th, we established a membership of all the standing committees, and we have switched on the fly 1 or 2 members, and we've just switched another one, and so we have this attached here, the rotation of the chairmanships, which Dar carefully prepared for us. So I guess I'm not understanding why we're revisiting this.
Well, I guess, so we're revisiting it because Chair, you serve as chair of 2 standing committees, which is against our rules.
According to my understanding of the rules, when we set this up, the Rules Committee was not a standing committee, and it has never been before this.
Well, according to the Rules Committee is a standing committee.
Can you read the rule, please?
I'm sorry.
I just was saying, can we read the rule so I'm not looking at
So
the rule?
it's Rule 9.7.
Mr. Cummings, are you on the line? Okay. Can you enlighten us on this? Is the Rules Committee a standing committee?
It is listed in the city council rules as a standing committee.
In the rules we just amended, or was it listed that way on May 24th?
It's been that way through all of the various revisions that I've been working on. The Rules Committee is one of the 5 standing committees listed in the City Council rules. It used to be 4, which included the Rules Committee, but now with the Referrals Committee, there are 5 standing committees, including the Rules Committee. Rule 9.2 specifically.
Okay.
And so that's why at the beginning of the meeting, I called for a suspension of the rules for you to be chair because we're violating the rules.
I'll just comment on this. Over time, we have not really viewed the Rules Committee as a standing committee, and there's been a regular rotation. I don't mind rotating and serving later when I'm not chair of P&D, but I don't mind doing this right now. So if we have established a set of rotations right now, if we want to change it, we can change it. Otherwise, I think we've already established it, but that's fine. Yeah, Councilmember Braithwaite?
No, I think I agree. I mean, you've brought this up multiple times, so clearly, if I was to read your mind, there's an urge to chair something. I don't hear anyone else complaining about our system, and if there needs to be a change, I think people have already done it. So I would say to the committee, unless there are at least 5 people who have a very strong desire to see this whole thing reworked, that we just move forward with the schedule at hand with the notes that, moving forward will be more mindful. But this conversation has kind of exhausted me.
If I can,
to be quite honest, at this late time.
Councilmember Reed?
Well, I understand that, then we should change the rule. I mean, the idea is that we have a rule on the books that has been adopted by some city council somewhere at some time. In fact, it was just adopted just today by this council unanimously, yet again. So because we have that rule and no one changed it, either we have to amend the rule or we have to follow the rule. But we're not above, especially the rules that we set for ourselves and that previous councils have set. There's I'm sure there is a reason that this rule was instituted, that no single member can chair 2 committees, and I would look to, in alignment with our rules, amend the committee schedule to align with our rules, or someone should make a motion to change the rule.
Hold on. Go ahead, Mr. Cummings, and then I have Councilmember Ravel.
I just wanted to point out to the committee that according to the schedule, you have one more meeting as chair of the Rules Committee before it rotates. According to the schedule, there's 3 that you're supposed to chair. And also with the switch of Councilmember Suffredin onto the Planning and Development Committee, he could slot into your spot as chair of Planning and Development if that would solve the issue. But I just wanted to point that out to the committee.
Well, I think, it looks as though on this that I'm serving until, just that 3 there just indicates that it would be 3 meetings if we hadn't added all the extras. On this Rules Committee, it looks as though I serve on Rules as chair until October, and I am chair of P&D until September. And if we switched, if I stepped away from Rules, then the next person who would serve is Councilmember Braithwaite, because he is the next most senior. And then I could come back and do the next rules from December to April, because I would no longer be the chair of Planning and Development.
Making Councilmember Braithwaite the chair of Rules, however, would make him chair of both APW and Rules. So I think probably the easiest or most efficient would be to flop the P&D chairmanship,
right,
which would be for, which used to be Councilmember Fleming, but it would be Councilmember Suffredin.
Okay. One other thing we could do is we could just say that we could change the rule and say that Rules is not a standing committee. And then we could just keep the schedule that we have.
Yep.
So I have Councilmember Reed, Councilmember Fleming, and then Mayor Biss.
So I'll say, just changing whether Rules Committee is a standing committee. As Councilmember Cummings has pointed out previously, standing committee is a term of art. It is a standing committee. It is a committee of council members. It is the most standing of all standing committees because every single council member, including the mayor, serves on it and votes on this committee. So that would seem a little silly to make it not a standing committee when it very quite obviously is. I think,
or you could just change it to be except for Rules that you. I don't care.
Yeah, that's one way to get through it.
Sure, that is a possibility. I think that we should honor, the intent of the rule here, which is that no member should serve as chair of 2 standing committees, because that is an immense amount of influence consolidated into one person. And that's why the rule is in place, to make sure that there is an even distribution of the council's ability to handle these, take on these big issues. And as we've seen, the Rules Committee is a very busy committee. The Rules Committee is a very busy committee, and I think that we should amend the schedule here and ensure that we're complying with the rules. I will also note one other amendment is that. It is listed here that I am the most junior member of the council, and as someone who served on this body as clerk for the last 4 years, I don't know if I should be listed as the most junior member of the council, while I am the youngest member.
I think we should take that issue up another way. I don't know how to answer that right now. I have Councilmember Ravel, Fleming, and Braithwaite.
So my question is, and I'm having a hard time finding it, where exactly in it is the rule that says that we're talking about?
In the current iteration that Nick provided is 9.8, page 13.
Okay.
Um, 9.8 is the rule that bans serving as committee chair, a chair of 2 standing committees. And then 9.2 is the rule that identifies the Rules Committee as a standing committee.
So where's the one that talks about the appointment, about the chair part?
It's 9.8.
Okay, there we go.
Okay.
Yeah, thank you.
Councilmember Fleming? And then Councilmember Ravel, if you'd like me to come back to you, I can come back to you. Okay, Councilmember
Just,
Fleming?
I mean, if this is the rule, it seems like it's easier just to change a chair of one of the committees than changing the rule and changing the standing committee rule. And I mean, again, Clerk Reed has brought this up a bazillion times, and I could really care less about who's the chair of what committee, if I'm being honest. But if it's a rule we have, then, I mean, I think we should stick to whatever rules we have. We've now spent an exorbitant amount of time changing rules. And, I don't think we need to change another rule just so Alderman Nguyen can be chair of two committees at the same time. It's probably easier just to change the committee. If Councilmember Reed is, desperate to be the chair, or not desperate, but really wants to be the chair of the Rules Committee, we have one more meeting, let the man be the chair for one more meeting. It seems much easier than changing 3 chairs for all other committees, just for the sake of this rule. And I don't think we should be changing the rules about what's the standing committee and what's not, and just to avoid, someone not being chair for one more meeting. It's
Right. Councilmember Braithwaite?
I want to move that we hold this with the direction to our corporation council to harmonize it. I'm basically saying what you're saying, Councilman Fleming, that we have a schedule that we've approved months ago, and I feel like we're bringing this up because of one person. So I'm going to hold it. I'm going to move to hold
point of information,
and kick it to our legal department to harmonize it and bring it back so we can just move forward to the next item. Is there a second for the hold?
I'll second that hold.
Point of information.
That wasn't what I was saying.
Yeah.
Okay, slow down, everyone. Councilmember, it's been moved to hold, and it's been seconded.
My point of information was in order before his.
Go ahead, Councilmember.
So my point of information is that we can't just hold this. We are currently violating a rule that we have, and that conflict needs to be resolved. So we should have resolved the conflict a while ago. I very clearly stated what the conflict was at the last meeting. I don't know why this wasn't harmonized in the last couple weeks. I was very clear that this was a violation of our rules, and we needed to come and fix this, and that should have been done. So I'm unclear why it wasn't already harmonized. So to hold it while we're still violating the rule is inappropriate and out of order.
Okay. I think the question is, it's, what do you want to do, Councilmember?
I'm going to hold my hold. That's it.
Okay.
And
It's been seconded by
Yep.
Councilmember Newsome. Okay,
A
it's been moved.
motion to overrule the hold. We can't just violate our rules. We're not above.
I'm not
And that
saying-
means this council can just do whatever the hell we want, whenever the hell we want, because we can just do what we have rules. We either have to follow the rules that we set, just like everyone else has to follow the rules, or we.
So did you move to overrule the hold?
I am moving to overrule the hold.
Okay, is there a second? Okay. We're
confused.
holding this.
We're holding it to do what?
hold it
That's what I'm
over.
not-
Just there's no other person making
I know, but
making
that's.
claims. So I'm just saying that rather than continue to rehash this meeting, just have Nick work to harmonize it based on the current existing fashion, because there's nothing in front of us to vote on.
I understand.
So if
but
it was
what is Nick doing? He's changing the rotation schedule of the.
Well, I'm
person who
leaving it
puts the
to him
rotation schedule
to. I'm
together
sorry.
is Dar. I'm sorry.
Right,
Go
the
ahead.
rotation schedule is DAR, so that's I'm confused as to
Correct.
what legal is doing.
Correct. I'm going to leave it to both Nick and Dar, who are staff, and also Kelly, to come up with a very simple solution. But no one else is talking about this. It's now 9:20, and there's nothing in front of us to vote on to change it other than what you all just did. So if this isn't going to hurt us, right? It's your personal preference, and no one else is making a big thing out of it. So in a matter of efficiency, if we can move forward, I think that would be the courteous thing to do. And everyone hears what you're saying. And guess what? In the next couple of months, it's going to be mute. You'll have your turn.
I don't
That's
think
not
that's the
We
point, though. I
we
don't.
just adopted rules. It's not. We all just unanimously adopted rules, and this was a rule. I'm not by you voting to adopt the rules, you said that you want an alderman to serve as chair of only one standing committee. You just voted for that. Every single person here just voted for that. I'm not raising this because I'm raising it because I think that we, as elected officials, should hold ourselves to the rules that we just adopted for ourselves. It only makes sense. And so to just arbitrarily hold it because, someone who's been, for whatever reason, does not, the public should be aware of this, and we should realize, folks, that we hold ourselves, if we just hold this to a different standard, then we hold you.
Okay, thank you, Councilmember Reed. Councilmember Newsma.
I'm holding this because I do think Councilmember Reed has a point. I think the rules as written and as we approved are clear. If I was going to rewrite the rules from the beginning, I would have characterized the Rules Committee as a committee of the whole rather than a standing committee.
Right.
That's moot. That's not the case. So let's live with the rules that we have. And I think by putting a hold on this, the reason I seconded that motion was to allow DAR, in consultation with the legal department, to revise the chairmanship rotation to be in compliance with the rules as written. Not something we're going to do in the next 3 minutes. So let's allow staff the time to sort it out, and moving forward, we'll be in compliance.
Point of information. I'd like to know why it was very clear what the reference was several weeks ago when I raised this issue. I'm curious why why staff didn't take it up. That's why it's on the agenda, because I specifically raised this conflict. So why was there zero effort to fix the conflict?
I think, I don't know. I think because we had,
Well, I'm looking for someone who does know.
I don't know.
And by holding it, you can have that conversation and just.
I would like us to move on because it's 9:30. This item has been held. Councilmember Newsma has made his suggestion to the staff. I think they're going to act on it. And then when we come back, we'll see what the rotation is. So let's move on to the next item.
Madam Chair, could I just say, can I just take one more whack at that poor dead horse? I just want to echo Councilmember Reed and Newsman's point that I personally don't care about this rule at all, but we should follow our rules. So I think it's great that this is going to get resolved. The one thing I would just flag for staff as they're working through this is my best guess, eyeballing all of this, is that the issue is not a simple mistake, but rather that I think these chairs were designed with the impression that rules did not count as a standing committee. So I would ask that when folks go over it, they go over everything to ensure that not only do we snap ourselves into compliance for the next meeting, but then remain in compliance for the full 4 years so we don't have a repeat of this dispute.
And that's what Ms. Francelno has done over all of the years in terms of making sure that there isn't a conflict. Yes.
Great.
So that has happened every council, that Ms. Francelno figures out where the potential conflicts are and then rearranges it.
Can I say 2 words? And it's not even about rules. It's just about, I think, if we can move forward as a new council in the way in which we hear each other. Because, again, I don't agree with everything that everybody says, but I do appreciate that Councilmember Reed brought this up last time. He said we were violating the rule. I think there was some dismissiveness last time in which we just said, this isn't a rule, that's not right, and we moved on. And so now we are being corrected by Cummings to tell us, yes, this is the rule, so yes, we are in violation, and now it's now moving on to another meeting where we'll have to, change the chairs again. And so I think if, even in our frustration and even in our tiredness and whatever else, if we can just try to do a better job of hearing each other and not saying this is just one person's issue, but if someone brings up something that is potential rule violation or whatever the issue is, that we just take a few minutes and read the rule or investigate whatever the claim is before we pass it off as just one person's issue, or before we just say that, you're wrong. That's not the case, because this is now several times where Councilmember Reed has brought up something, whether I agree with it or not, where in fact he has been right and we've realized that after the fact, but we still don't act on the matter. And so just as a general practice of adults, if we can just listen to each other a little bit more, that would be helpful.
And not to further beat the dead horse, but I just wanted to say this was not an oversight by staff. This had to come in tandem with the item switching out Councilmembers Fleming and Suffredin, because if Councilmember Suffredin, who wasn't on any other committees before becomes chair, that could potentially solve the conflict for P&D. So if he becomes chair of P&D, that resolves the conflict, but we didn't know that until tonight, till this item was passed. So staff was looking into the rules and all the history behind it, because DAR has institutional knowledge, which also suggested that prior iterations did not count rules as a standing committee. But also I want to point out too, this is the only committee where all 10 council members serve. So there would be a conflict somewhere down the road because all 10 members serve on this committee at the same time anyway.
I didn't address that rules is a standing committee per our rules that we have in front of us. So regardless of what we thought, we have it written down somewhere that rules is a standing
Right,
committee.
and I was specifically told to bring this back as an action item, which I did. I made sure it got to the agenda. So I just want to make sure that everyone understands this was not an oversight by staff. I specifically outlined this issue because it also created an issue with regard to the chair schedule, given the switch of 2 council members on P&D.
If I may.
Yeah,
I'm sorry, but
Councilmember Reed,
there's no reason for.
we're going to move on.
Well, no, I have to
please.
correct.
No, we're going to move on. The item has been held. Councilmember Newsma has provided direction to staff. We will be following our rules.
I provided directions.
And we're going to move on. Okay.
I have something to staff, right, it's just something quick. Could that have been in the packet? Oh, sorry, wrong button. Can that have been, all of that, what you just said, is it appropriate that next time we can have that in the packet, that explanation that you just provided?
Sure. This was brought to me last I heard, and I'm sorry because we've had so many meetings, is, the conflict was pointed out by Councilmember Reed. He wanted it on the agenda. I made sure it got on the agenda for action. At the same time, there was a referral to switch out Councilmember Suffredin and Fleming, which also could tonight potentially resolve this whole issue if Councilmember Suffredin becomes the chair of P&D. But I didn't know that until tonight.
Point of information, because
No,
there have been.
Councilmember Reed, could we please move on? I really would like us to move on. It's now 9:30, and we have resolved this issue. We will be following the rules. I don't need to be chair. DAR will figure out the correct rotation, and we will not have a conflict like this going forward. The Rules Committee will remain as a standing committee, even though it's never been treated that way by any council that I have sat on. All right, we're going to move on now. So the next item is R3, discussion regarding the date selection for the city manager's annual review.
All right.
R8, sorry, just took my glasses off. Councilmember Suffredin recommends that the Rules Committee discuss a date for the annual review of the city manager. This is for discussion. In the city manager's contract, it does require that we have an annual review. The process.
Are we not doing the other portion of R7?
The other portion of R7.
Yeah, because that wasn't what Director Knighton presented was not my referral.
Okay, I apologize then. We're going, so R7 is discussion of current City of Evanston boards, committees, and commissions. Councilmember Bobby Burns recommends that the Rules Committee discuss all existing City of Evanston boards, committees, and commissions. This is for discussion. Councilmember Burns, do you want to address this?
Yes, thank you. I think it is best practice to do a rolling review of our local agencies, boards, corporations, and commissions to ensure that the operations are aligned with the city's strategic priorities. We can also take a look at, are there issues that need to be addressed in the BCCs that are not currently covered under our BCC structure? Are there unnecessary or redundant BCs that can be dissolved, or consolidated? Do BCCs have clear goals and missions? Are those goals aligned with the City of Evanston goals? The amount of members, are we reaching a quorum? When is the last time some of these committees met? So I think all this should be, I think it's good practice to do an annual review. We've also heard a lot about the need to make sure that we're centering lived experience in our communities, especially the committees related to housing. We do have, as Councilmember Reed mentioned, there was a kind of self-reporting question on race that we added to what is it again? the statement of economic interest that,
disclosure and
because
affiliation.
again, how are we going to have a conversation about racial equity if we're not collecting information about race? And so those are just some of the things that I think that we can consider in this process. I don't expect, we're not going to solve this all today. And so I think to get started, what I would like to see is in the BCC handbook, which you can find on the boards, committees, and commission page, it says, one, that there should be an annual self-assessment by every single BCC. And so I would like for my colleagues here, the full council, to receive that. The BCCs, the annual self-assessment going back is, maybe 4 years, but certainly in 2020, if we can see that self-assessment, that will be helpful to start the discussion. And if it hasn't been done, I think they need to do them for 2020. And the reason why is that this self-assessment is, it's a self-evaluation by each individual regarding her or his participation and contribution, an evaluation of the challenges the BCC faced over the year, an evaluation of the accomplishments of the BCC as a whole, a comparison of the BCC's accomplishments compared to ordinance requirements, and recommendations for the coming year. Really good information. So I'd like to see that going 4 years back, but certainly for 2020, we should have it for all our BCCs. It also talks about for NWEB that they're supposed to develop a program to address established needs of NWEB. I know program might be considered a loose term, but I'm just curious if there is a solidified program. For Plan Commission, it talks about they need to prepare an annual report on the adequacy of the comprehensive plan, the zoning ordinance, and the capital improvement plan as instruments of long-term development policy. Again, I'd like to see that annual report going back 4 years, but certainly for 2020 we should have one. And that is just to cut it short. I think if we can get those three things, that would help us start the discussion.
Okay, we'll direct staff to request those of the BCCs. I think one thing to just keep in mind is a number of these, for a period of time last year during the beginning of the pandemic, a number of the boards and commissions stopped meeting because we hadn't figured out how to meet virtually at that point. So there may be 2020 may not be the most ideal year to assess. I mean, it's going to be a slightly different year.
Yeah, I mean, I think going back 4 years, because again, we were supposed to have these every year. Mm-hmm. And this is some pretty important stuff that could help us get through this process. So yeah, 4 years, but I think we still should have one for 2020, and we'll, understanding that it was a COVID year.
Yeah. Okay. All right. Staff, do you have that?
I'm going to send Councilmember Burns an email right now asking for a list. Thank you.
Okay. All right. Thank you, Councilmember Burns. That's really important. I'll just say we did re-examine our boards, committees, and commissions, I think 4 years ago, and maybe a little bit longer ago, we pared some of them down. And since then, I think we've done some more consolidation. But it's always important to look and to see if, I think Evanston has an extraordinary number. I think we're better than we were, but I think in the past, Evanston created a board or commission every time there was a significant issue. And it's always good to go back and figure out whether it's still relevant.
To that point, we may even have some now. We'll work this out through the process that should be more of a task force or a planning committee than a committee. Sometimes I feel like we establish a committee and then they're sitting there saying, all right, we're not really quite sure what we're here for. So that's a good point, though. Yeah.
Mm-hmm. Okay. All right. Thank you for bringing that up. All right. So now we're going to move to R8, discussion regarding the date selection for the city manager's annual review. This is a recommendation from Councilmember Suffredin. Within the city manager's contract is a requirement that we have, that she has an annual review. And Councilmember Suffredin, did you want to speak to this?
Sure. most relevant portion of the contract is that the evaluation shall be in accordance with specific criteria developed jointly by the city and Storley. Said criteria may be added or deleted as may be determined by the city in consultation with Storley. So I think we need to get the ball rolling on figuring out what the criteria will be, who will represent the city in those discussions. In the past, we've done it with groups of aldermen. I don't know if it's appropriate to have a discussion about who would do that. I mean, we just need to get the ball rolling because this takes a little while to come together.
So in the past, for those of you here, remind me if I'm getting this wrong. In the past, what we did was we circulated among the council members a sample questionnaire for the council to use as an evaluation tool, and determined whether to add questions or delete questions that we felt weren't relevant, and then refined that had everyone's contributions added to add to this questionnaire. And then when we were settled on what the questionnaire how it should read, it also it provides wide variety of questions with a 1 to 5 scale in terms of kinds of performance, and every question has room for comments on it. Then what we've done is we have a committee of 3 members of the council who then that questionnaire is sent out to every member of the council, including the mayor, with a deadline for everyone to return it. And then then there are 3 members of the council who serve on a committee who collate the responses and put them into a single document. And then that document is circulated to all of the members of the council, including the mayor and the city manager. And then by then we've set a time for a meeting for the annual review. And I don't remember whether it was usually on a Saturday or
There were some evenings.
some evening meetings.
Executive
So, and it's an executive session. That's been what we've done in the past. We've changed that. We've changed the questionnaire a number of times. And we've had different members of it's usually 3 members of the council, and their job is really to collate the answers so that it's kept within the membership of the council. So what we
Yeah. Well, I guess it seems like the appropriate first step would be to ask the city manager to provide the template by which she would like to be evaluated, which I'd assume would be some sort of ICMA standard
And I
thing.
think that's what we started with last time.
But the question, I guess, is to whom would she present that? Would it be the mayor or would it be, do we want to name a group now? How do we want to initiate this process so that it's moving forward?
I think what it is that DAR sends out the questionnaire to all of us, and then we can comment on it, and then it comes back to us to determine whether we're satisfied with the questions. I think another point is that we should, in working with the city manager, we should pick a date, probably in October, because that's her annual month, and this will take probably 6 weeks from when we start to when we get to the evaluation, because we have to examine the questionnaire, figure out whether it's still relevant, then talk to each other, then circulate the questionnaire. I think DAR's recommendation is always to have a short turnaround for all of us, because if we have a long turnaround, we don't get it in. And then it's sent to the city manager. So
Then, if I may, so should we ask the city manager to present the template that she would like within a week, 2 weeks? What do you think is an appropriate time frame?
Councilmember Braithwaite?
I'm going to respectfully ask, the folks sitting back here, just how many people have participated in an annual review, whether it's yourself or performing it?
An annual review of the city manager?
Of an employee. We're talking about an employee.
Oh.
And so the point I'm making to, Councilmember Suffredin is, for number one, I don't think she should come up with her template, number one, or a city manager or the employee. I think the process that we've used in the past, I've liked where DAR has put out the questionnaire, and then it gives everyone an equal opportunity to make whatever edits or add things that they seem fit. I do think it's important, and the reason that I've asked is, I think the word annual is the important buzzword, and typically for an employee, I would hope that you would want to have some experience working with whomever that employee may be. So I see value in it. It gives, and I will say, the person feedback, whether it was a director, whomever. But I would hope that we would all take into consider just how long you've worked with that individual to make sure that it's something that's good, comprehensive feedback. So I think it will be important that we do get this document out, and I just want to also keep in mind that in waiting with October, we're right in the middle of our budget season as well. So
right. She has I'm sorry. It's in her contract that she gets to work on the form. So the template, it protects her contractual rights.
Yes, it's her, but we have the opportunity of molding the questions is all the only point that I'm saying.
But you would have to agree to that.
Well,
I mean, we
that
should get that process started is what I'm saying.
So I think we should, I agree. And I believe the ICMA form that we're currently using is one that Wally presented to the council.
Right.
At some point, as an updated version of what was currently being used in many other communities. So I think we should ask City Manager Storley for the template that she would like to use. I think we should ask her for a date in October that works for us as well as her, and then we should decide whether we want to appoint 3 members of our council to be the co-leaders. Councilmember Ravel. And Councilmember Fleming after that.
The only thing is, I don't think last time we did this, we also did a 360 evaluation where, and so I would like to bring that piece back as well.
Yes.
Which would add to our time to be efficient.
Yeah.
And that was my point as well.
Yes. Oh, excellent point. So we should do that as well. So let's have the city manager give us the template that she would like to use, and then we should figure out and give us several dates in October, and then at the next Rules Committee, which will be the first Monday in August, unless it's sooner, then we can select, usually it's 3 members of the council who, I think, Councilmember Fleming, I think you were on the last one, perhaps?
I was, but also as you're making your timeline, can you just, the 360 piece came from HR last time because they already had a tool they used.
Okay, so then, yes, and that's then we should get the 360 piece from HR. And then at the next Rules Committee meeting, we should select 3 of us or 3 volunteers to be the collating team. I know. I've done it a number of times, and it doesn't take that much. And we can also look at the form. That's a very good point. Adar is pointing out that we also sometimes have looked at prior forms as well. So if you could circulate that form to us, if we can request that those things of the city manager, and then the city manager can come back to us with potential dates. And I think as soon as we can get it on the calendar, the better, because our agendas are a little bit more open right now. Mayor Biss.
I just want to make sure, just for clarification, so I understand the end point of the process is a date we're going to put on the calendar shortly. I understand the beginning of the process is we're going to get 2 different documents. One will be the city manager's proposed evaluation template, and one will be something that DAR will send that's been used in the past. So it seems like the next step then is for us to give feedback on those 2 documents. We want that to happen pretty fast too. So who should that feedback go to? Who will that also be collated by the 3 people we pick at the next Rules Committee meeting?
Usually goes to
The feedback from the form, like I'll send the forms that we use, you all use for Wiley. And once the form comes back, and if there's any changes, then the committee will review that. And then after that, I will make all the corrections, and then once you all have a date, excuse me, I will send out the confidential form to the council. And then it comes back, and then the committee correlates it again.
Great. So then we'll send feedback to DAR to sort of produce a hopefully consensus second draft.
Right, and then the committee of three, if they want to decide what, resolve any consensus questions, usually it's very straightforward. Okay. So does staff have direction of that? Do we all have an understanding so that at the next Rules Committee, we'll get 3 members to serve as a collating committee, and then we'll have a date, we'll get a date on the calendar with the city manager and all of us for sometime in October. Okay, all right. Okay, so that concludes R8. So the next item is R9, which is discussion of duties and powers of the Referrals Committee. This is Councilmember Burns and others wish to discuss further detail the duties and powers of the new Referrals Committee. And Mr. Cummings, I see you're back. We have a memo in the packet that discusses this, and I wanted to just open the floor for discussion if there are questions, and we can talk about this.
Yes, Cliff Notes version.
Go ahead.
I was going to say Cliff Notes version because of the time of the hour. The legislative, what goes on the agenda is up to the city council. The issue of when is very complex based upon city council rules, state law, et cetera. And so the city manager's office is greatly involved in that. And one of the suggestions that I make in the memorandum is that the city manager's office staff the referrals committee. So that way the city manager's office is present when the referrals committee is trying to divvy out the referrals.
Okay, Councilmember Burns had some questions.
Yeah, so my main point with this is Councilmember Nusma had similar concerns. So
I think that he's just.
I know. I think he left, but
he's
basically,
on the Zoom.
To be clear, this referrals committee doesn't currently have the authority or the direction to determine when something gets on an agenda. The only thing that they will be doing is deciding the venue or the where, so what committee, and then whether or not it's on for discussion, introduction and action. I just want to be very clear on that. That's what the referrals committee current responsibility is. Now, what's confusing for me is I always thought that this committee would tackle the where, because that's what's complex. In fact, if you read what Council Cummings said, where is it at? Hold on, excuse me. Let me. Where is the complex? I'm sorry. Hold on.
The memo starts on page
Okay, here we go.
99.
The discussion of when an item may appear on any given agenda is complex, right? So why would the thing that's most complex we give to one person, which currently I should say that is the chair of the committee. So the most complex part of this process, we're giving the chair the complete authority over and discretion to determine how it's decided. And then something that's really not that complicated, which is determining the where and if it's on for intro and action, is what we give a committee. That just seems backwards to me. And so, if anybody has any questions on that, but I just want to be clear, like the only thing this referrals committee will be doing is deciding where, so the venue, and if it's on for intro and action. And we've put requirements that is transparent and that we establish a set of criteria. I push for that, thinking that requirement would apply to, again, the most complex part of this process and not arguably something that's not as complex.
Councilmember Reed and Councilmember Fleming. And Mayor Biss, did you want to chime in on this?
Well,
Okay. Well, why don't we hear from Councilmember Reed and then Councilmember Fleming?
Yeah, again, that's something I noted the last meeting when we adopted this, and why I believe I voted against this proposal, or I voted against part of it. And as a council member, I think we all have the expertise to know where a certain item should go, or the knowledge to know, or an ability to work with our colleagues to figure out what is the proper venue for an item. And there was already a mechanism in the rules that would allow us to do that, which was referring it to the Rules Committee if there is a jurisdictional issue about whether, allowing food trucks at the beach is a human services item, or if it's a, economic development committee item. The Rules Committee was the venue to decide what the proper venue was. So it, again, just really seems like the only thing that this committee is doing is it's not solving the complex issue, and it's really just delaying things getting on the agenda by creating another meeting where folks have to meet to decide something that can easily be decided by a council member.
Councilmember Fleming?
I would just tell you my vision for the referrals committee, and, full disclosure and quite honesty, if we don't have it, that's fine. That's just another hour I get back in my own life. So, the referral committee, in my opinion, would do all of those things. If I'm remembering correctly, which maybe I'm not, there was some discussion and disagreement in terms of if this committee need to exist, and if they need to do all the things, or if the city manager should continue to do all the things. My personal rationale for wanting this committee is because I have been in city council where I feel like my referrals have not been tended to. And I don't know exactly why that happens. And so I thought having, a group of my peers where I could kind of follow a process where things are written down, where things are documented in a spreadsheet or database, or however we're going to do them, makes more sense. Now, we have, not met as we've had a conversation as the supposed committee. And part of what my vision was that this committee does the whole shebang. So you need to write out a referral, or you need to type it, or, there's some kind of track record of it that goes to the clerk. That's a, another step in the process that you then know someone has it. The clerk then refers it. So all these things are trackable in some kind of way for very transparent reasons. And then this committee meets to say, hey, maybe I forgot to put on my referral goes to APNW. That's an honest mistake, or maybe whatever. And so, this committee not only puts it there, but also sees what's coming up in the APNW and can say, hey, this is a really easy one. There's no notes. It's just discussion. It's, a one pager, or whatever the case is. I'm looking at the APW schedule because, this committee should have everyone's schedule already, including bills, lists, and all that stuff that we know is kind of just goes on every week anyway. Say, okay, this should be able to squeeze in on the July 15th docket, right? And so then they are putting that, this is my vision, they are giving that to the rules, or to the chair, in some kind of fashion, saying, hey, this should fit on July 15th. I can tell you, I don't love the idea of committee chairs having control of the agendas, because that is how I feel like stuff doesn't make it to the agenda item. And again, in my personal experience. So I don't like that mechanism. So in my mind, this committee would, we still have that rule, but this committee would be able to kind of push that to say, okay, Cicely, how come this can't go on human services? Looking at your agenda, there's room for this to go on there. And that would hold us, ideally each accountable as chairs to say, I don't want to get it on there because I don't like the topic, right? We'd have to be very honest about why something's not going on the agenda if this committee is looking at your agenda, or at least what's coming up in, the future of your committee, to see that there should be time and space to get this done. I also see the referrals committee as being the one to go back and say, okay, Cicely, your item's not going to go up until August 3rd for this reason. Or we need some more information on this referral so we can make sure when it does come up, it, makes sense, and all the information you're looking for is on there or whatever, right? So this serves as kind of I don't want to say go-between, but this committee, in my mind, does more than just say, okay, shuffle the cards, APW, this, and that. It would actually make sure that committee chairs are not holding things off of agenda items. And if the committee chairs are really trying to do that, they're going to have to vocalize why that is. It also then serves the purpose of coming back to make sure memos, have the referrals have all the information needed to produce a good memo for a good discussion. And that's why I don't like special orders of business, because I think everything should go through one process so everyone has fair access and equal access to the agendas. So, I don't think that this part should be left off. I also think that the clerk should be the staff of the committee, because the clerk is going to be, if this rolls out as my mind envisions, the one who takes these referrals and kind of is keeping track in some kind of Legistar or iCompass or whatever system we use. And so it makes sense that the clerk is also the one that handling these referrals and making sure things are on the docket and kind of helping us keep control of, what's forecasted to come down the line. So, I don't think that, in my mind, it is not so complex, the agenda. The agenda management, I think it's just a matter of making sure we don't have 25 really heavy items so the meetings are super long versus, people being able to be kind of roadblocks. And so to wrap all this up, I don't see this committee as being one that should stall things. I think, again, my very personal experience is that things are already stalled. And so this committee should be one in which things are not stalled, because it's a very clear process as things come in and as things go out. It's not just like, hey, I remember I made a referral 3 months ago, where is it? And then you're arguing with the committee chair, you're asking the city manager. This is a very clear process with 3 people who need to have very clear meetings, who would need to come up with very clear criteria that they bring back to their peers to explain and have dialogue on. And it's not just kind of going out willy-nilly and, who likes who makes it on the agenda.
Can I respond?
Yeah, go ahead.
So I just want to be clear that currently the chair doesn't have to listen to any of what comes out of the referrals committee. So that's one. And if people are okay with that, I just want to be very clear. The chair can, after you do all the work, well, let's start with this. Right now, as it's currently written, it's not clear that this committee is going to determine where. It's not written. I don't see it. So one, we'd have to put that in there. And then and make sure that it's clear that we're applying the established set of our criteria to the where, to all of it. But the where needs to be in it.
You
It's
mean
not
when?
the when. I'm sorry. Yeah, that the when needs to be in, and that we need to understand that the established set of criteria is for the when, for all of it, but definitely for the when. And then something. I'm just trying to. If the chair can ultimately decide has the discretion to go against the opinion of the referrals committee, although it may not happen often, do we want to have that conflict, or do we want to just say the referrals committee determines where?
So,
especially if it's
Councilmember
complex.
Wynn, can I respond?
Yes, go right ahead.
Or when, I'm sorry.
What I'm hearing from the members of the committee is that the intent of the referrals committee was to essentially alter the form of government that we have in the city of Evanston, which is something that we cannot do, which is why I pointed that information out in the memo. The dictation of when is sort of resolved if the city manager's office staffs this committee. The clerk can't necessarily staff a committee because the clerk is not staff. The clerk can actually be present, obviously, because the clerk is the one that accepts and transmits all of the referrals. But it's really, it really is sort of resolved if, whether it be City Manager Storley, Deputy City Manager Richardson, or Gendersky, or any of the city manager's office staff, like Emma Carter, working with the 3 members of the referrals committee to identify when something can go on any particular agenda. The where is sort of spelled out with how the committee has suggested that the referrals committee be structured, but the when is an administrative function, which is reserved for the city manager's office under our current form of government. And so that's sort of resolved if the city manager works with the referrals committee.
It's not, because the chair currently has that responsibility of each committee.
So
we're already not.
Even under the city council rules 9.10.1, and I don't know if that's actually been renumbered now, the chair of a committee has to work with the city manager in order to structure a committee agenda. So none of this can happen without the city manager's office. If the city manager is working with the referrals committee, by the time it gets to a committee chair, the city manager has already made it clear that it can go on a particular committee agenda.
So why not just cut off the chair then, is what I'm saying.
Well, I think can I just, I'm just going to jump in as having been chair many times. And there are certain things that just by operation of the government, like for instance, if we'll have a development come into the city, it'll go through DAPR, it'll go through the Plan Commission for whatever number of hearings, and sometimes it's uncertain. You know, some things will stay at Plan Commission for several meetings, and then it will be coming towards planning and development. Now, there are times where it might be a very big, development, very controversial, and that might be the only item that we have, or one of maybe 2 or 3 items we have on P&D. But there have been times where we have 2 of those very controversial developments coming up. We know we're going to have a lot of citizen comment. You want time for the committee, P&D committee, to really deliberate, not rush. So as chair, I'll work with, this has happened before, I'll work with the staff to say, how do we determine which of these to go forward with on this P&D meeting? We should not have them both the same night. Let's figure out which should go forward first and then which goes second. That's the extent, and we'll, if there's something that's coming out of the Plan Commission to possibly, change a zoning ordinance, that isn't as timely as an appeal from the ZBA or a development that's moving through the process where you don't want to delay the development too long, because delay for anyone is not a good idea. But so the chair is basically a traffic cop as chair, trying to manage the schedule so that everything gets addressed with the appropriate amount of time, and you aren't packing an agenda so tightly that everything gets short shrift. So, it is complex in the sense, I don't necessarily agree that it's complex as in the memo, but think of the chair as the traffic cop who's trying to manage the traffic flow and make sure that we have plenty of time for the citizens to come and participate, that the committee has plenty of time to deliberate, because these committees, AMPW and P&D, meet before the city council. And I mean, that's the other aspect of the timeliness. Like, how do you fit this in the time that we have for P&D and not push council back?
And I'm just saying, I think 3 people, 4 now, if we're adding the city manager, could do a better job of that than one individual chair, is what I'm saying. Because that's what, from Councilmember Fleming is telling us, she is under the belief that the referrals committee is going to determine the win. That's what you said, right?
Yeah, I mean, when I've been chair, and again, this is how things get murky. When I've been chair, depending on who the staff is, sometimes I've gotten the agenda like, hey, this is what's coming up on the agenda next month, and sometimes I've gotten the agenda when it's come out with everybody else in America. It's not been like, hey, council, member Fleming, here's the agenda for the committee you're chairing. What do you think about this? It's been, whatever staff send out the agenda and lets me know the agenda's online. So it does not always operate the same for every person. And we can, have that discussion another time, but the win, and let me just back up real quick, because I can just envision Evanston Now's headline's going to be, changing the form of government, right? We're going to go back to Cicero flyers and the whole shindig. So, Mr. Cummins, I'm not exactly sure where you were going with that comment, but I think that's a very touchy comment to put out there. I don't think that, at least by me trying to get the rules or referrals committee going, I'm not trying to change the form of government. I think that having city council members say, hey, referrals need to come in a systematic way and go out and be assigned in a systematic way is not changing the form of government. We're not hiring or firing and doing all the other things the city manager does. So I want to be super clear that I don't think that's anybody's, that's not our ploy in the referrals committee. But again, it's just to make things very systematic. And I think having people say the win makes sense. Again, it might not be in the next 2 weeks because the committee is full. It might be in a month. It might be in 3 weeks. It might be whenever it is, but I think that would be on the referral committee to make that determination based on the agendas they see in front of them, and then communicate that to communicating that to the person who made the referral, right? And so that there's no confusion.
But y'all just described the same activity. Like, that's,
Well, I think I mean, my understanding, okay, perhaps we're getting confused here. My understanding is the referral committee is going to take referrals, determine, flesh them out, determine what, as Councilmember Fleming was described, how much staff time this is going to take, work with the staff to figure out how much have they got on their plates on any given time? So when can this, is the referral developed enough for the staff to work on? Do they need to get more information from the staff member? All of the things that Councilmember Fleming was saying. So, but also then turning it over to the chair. I think the chair still has a role because the chair has to chair the meeting. So if the referral committee says, okay, it has to go on the second meeting of September, and the chair needs to be able to say, because the chair is the one who's running the meeting and is facing the public, who's saying, how did you let this agenda get so packed? So it's
right. I mean, there's not a dictatorship, right? If I say this goes on,
right,
May 2nd, and you say as the chair, hey, we've had 3 items that are continuing that I brought out big crowds. Can this go on May 15th? I mean, I think there is some give and take. I don't think any chair or the referrals committee should be a dictatorship, but all of that needs to also be a communication that the referrals committee, in my mind, would be having with the person who made the referral so that they know where their item is, so that they know their item's not lost, it's not being thwarted by some evil plan, right? I think, again, this is all communication.
And I think it's all a collaborative process with the referrals committee and whoever.
Right, and the referrals committee that does not exist yet also needs to get together and make all this stuff and come back to you, all our peers, to say,
right,
this is the process we come up with. Does it make sense for you all?
Need to add that then, that this committee will be making recommendations as to when into the rules.
Yeah, that's fine with me.
Yeah, that's all I'm saying.
Yeah.
However y'all want to work it.
And not that
I'm
we're
just saying
changing the form of
We
government.
should add that into
I think
the rules.
reasonably when, because as Councilmember Fleming is saying, you can't necessarily say the referrals committee is saying, okay, it has to go first meeting in May, because the referrals committee may not know that at the last committee meeting in April, there was a whole host of other questions that were raised on a whole bunch of issues that were held at the committee. So it's going to be a collaboration in the sense of this item, as I see it, referrals committee is saying, this item is ready to go. Where do you have room on your agenda for it? And they work with whoever's chair to fit it onto the latest agenda.
I think in very few cases, and to me this should be spelled out in the criteria, should a chair say, no, I'm not going to listen to that. Because the bulk of the work they can do. Like, we can have chairs at some point speak to the referrals committee to give them an idea of what's happening on the floor. So that's what I mean, is that the criteria really should spell out how this process should work in terms of determining the when, because that's the most complicated part of this. If we're comparing it in comparison to deciding whether it's for intro and action or discussion, like, that's clearly more complex than that. And so
would you be okay with the referrals committee gathering to start laying that out and bringing it? Because again, this is all hypothetical because we haven't even done anything.
Just again, as I said, can we please, and this is to Council Cummings, and we can have this discussion in the Rules Committee, just add that this committee is going to recommend the when. That's all. I need that, and that in understanding that the criteria that will be developed will be applied to determining the when, at least for the referrals committee, and then if the chair still has the authority to make another determination, that's fine, but that's not clear right now in the rules. So that's all I'm saying. Let's just make sure that's in the rules.
And I will accept that, but I don't know that I can recommend it as your corporation counsel because of, as Councilmember Fleming pointed out, my irresponsible comment about the fact that such a rule would threaten to usurp the current form of government, with which this being an administrative function, it's within the powers of the city manager's office.
But you just said staffing the referrals committee with the city manager would alleviate that.
And I still hold to that. And I think that if we leave it as is.
Okay. I'm sorry. You're saying we should add that. We should add that. Yeah. Okay. Yeah. We can add that. That makes sense. I'm sorry. Yeah. Well, can
I'm
we
saying
add-
leave it as is, and the city manager staff the committee, and it resolves the issue.
Yeah, okay, so I agree
The city
with both
manager
of
staff
those.
can't staff the committee and then tell the committee that they can't do their job. I mean, so again, this is part of, we have to bring this together to see how it's going to
That's
work.
my- yeah, yeah.
But if the city manager's committee, if the city manager's staffing thought is, we're going to be down here just kind of giving suggestions, but they are the city manager and they run the agenda, then we're going to have a conflict.
Well, Council Cummings says that the city manager has to be a part of the process, I think is the language that was used, or something like that, or consulted, or part of the process, so I don't think we'll have.
I
didn't hear
don't
that.
think that it'll be as to Councilmember Fleming's point. I don't think it'll be to the point where the city manager's office is going to say no. It's just the city manager will be there to say, based upon the current workload and the current agenda items that we have forecast, without knowing what's going to get held at any particular committee meeting, it may not be available to come up until the September meeting or the October meeting, et cetera, et cetera, et cetera. Because that's the administrative part of the city manager's job when it comes to the agenda. So yes, the referrals committee can tell what, and the city manager's office can inform as to when, and then so working in conjunction, I think, is what will solve the rules committee's concerns about the question about when.
And it's not like they'd have a vote, to your point, so I think it'd be fine, yeah.
Okay.
So can we, I don't know how to get that worked on, and I know Mayor Biss has wanted to say something for quite a bit, so I don't know if you want to add anything.
Did you want to, I have Councilmember Reed and then Mayor Biss, would you, because I think this is your brainchild, right? I'm sorry.
Yeah, I mean, I'm hard pressed to see how we can make this conversation productive. I think the concerns from all sides are important and they're useful. I think any place we land, any kind of wordsmithing we do, there's going to be a certain amount of give and take. And I think the rubber meets the road when the committee sits down, writes guidelines, shares guidelines with the rules committee, gets feedback, and actually starts doing the work. The guiding principle that has governed my recommended changes, which has, I think, gotten me in trouble with folks a couple of times, is always just try the smallest step that feels meaningful first. I think Councilmember Burns' concerns are totally legitimate. It might be the case that this is not a big enough step. We'll find that out. And if so, I think we can make tweaks as we move forward. But I think Councilmember Fleming really articulated with a lot of clarity what my vision is, which is, no, this body won't have the power to force something onto an agenda at a specific time. On the other hand, this body's culture is going to be, we're going to parcel things out at the pace that they can be absorbed, with therefore the expectation that they're going to go on agendas immediately. And that's going to have to there's going to be flexibility around that and some play. And if that winds up being radically different than how it plays out, then we probably have to go back to the drawing board and amend things. But I'm a little leery of getting too far into the kind of textual semantic analysis before we have a thing that we're watching play out.
And just please a quick response to that. Because this is not that deep. It's really not. If this referrals committee will determine a date, then I want to make sure that's clear in the rules. If they're not going to work on that, then I'm fine with that. But it's not clear right now. So
yeah, I think they would not determine a date, and I think that's
date.
consistent with Councilmember Fleming.
I did not hear that,
Did I understand? Am I?
Will they recommend a date? I'm sorry.
A range.
We can't hear Councilmember Fleming. Her mic's not on.
I'm sorry, if it's decriminalizing drugs, that's not going to go on the next agenda because that's a big item. We need lots of research, X, Y, and Z, right? So I think given the substance of the referral and the calendar or the projected calendar of whatever committee, the referral committee should be able to say, hey, this should be able to squeeze on this date. Right? Now, again, there would be some flexibility that maybe the
But we
chair
can write
would.
the flexibility
Yeah.
into this by just saying recommending,
Yeah,
range is
recommending-
fine. I'm just saying it should be written into the rules. That's all I'm saying. So it's clear.
Recommending when things would come before would be placed on agendas, I think is clear enough language.
I'm fine with
with
that.
everyone understanding there's going to be some hit or misses.
Right.
But our responsibility as the committee being to speak to the referrer so that they know where their item is.
I want the committee to do this work. I'm just saying, let's make it clear in the rules so that they're doing it with authority of this body here, is all I'm saying. So if and I'm fine with working on that offline, but I just want to be clear, this is not deep to me. It's just, let's write in there, they will have the authority to recommend a range of when it will appear on the agenda, however we want to say it, but let's just be clear.
Projected agenda dates.
Okay.
Is that
So
good?
we can talk about that off.
And then when the committee
just
actually
discuss.
meets to get some meat on the bones, we are planning to come back to you all to say, this is what we think, what do you think, before we move forward with doing anything.
Yeah, okay. I'm good.
Okay, Councilmember Reed?
Yeah, again, I'll note it. Everyone who just spoke, except for Mayor Biss, went over 5 minutes, including the chair. So we should really think about whether or not 5 minutes is enough time for folks to have a meaningful discussion. But
Public enough to me.
Well, actually, given the discussion, I withdraw my comments on this. Yeah, I withdraw my light.
Okay, thank you. All right, I think we have concluded our agenda. Well, okay, and seeing.
I would ask that that someone who voted on the prevailing side reconsider the 10-minute allotment for someone to speak. If we're not going to enforce that rule, and if we're going to selectively enforce it, we should give folks 10 minutes. That should include the question period with staff. And you just have, I mean.
No.
Or then not reconsider, I'm sorry.
Right.
Then I
Can I-
make a motion that we amend rule, Jesus Christ. Sure, whatever that rule was. The rule was 2.3, I don't know, 2.1, whatever the rule was. Can someone tell me the rule?
12.1.
Say it again?
It was Rule 12.1.
All right, I move that we adopt an amendment to Rule 12.1 that will allow a council member 10 minutes on any given agenda item to speak, and that would include their question period of staff. You got 10 minutes to speak on it and nothing more.
Councilmember Reed, hold on, everyone.
That's been
That
moved and
rule
seconded.
applies to the city council. It doesn't apply to the rules committee.
Well,
It applies to the city council.
I'm still
So,
making.
and I don't think we should take it up. We have two members of the council who are not here, and
We can still vote. We have a quorum.
okay,
The law.
all right. Then we can change it back.
All right, so I second.
I'm sorry, you have to turn your mic.
I second. I second it because, not that I want to
Wait,
late
so
meeting.
you're seconding
For
what
10 minutes, including your back and forth with staff.
Oh,
and-
you have to, first it's the motion to reconsider.
No, there was no
No,
motion.
because
so
there
it's-
was no motion
yeah,
to
it's
reconsider.
just
First
straight
place.
up, yeah.
So, all right, we'll call the roll.
So Chair Nguyen, if I may, the way that the proposed rule and the way that the rule is written currently allows for some flexibility to go beyond the 5 minutes, because if no one enforces it, or if there is consent by silence, then you have more than 5 minutes, which has been exercised several times at the Rules Committee this evening. The same is going to happen if it's 10 minutes. So you're still going to have the way that it's drafted. You're going to have 10 minutes, but unless it's enforced, you could talk for 20 minutes. So I think that there's flexibility already built into the way that the rule is already currently drafted.
Say it again. I will note that, it's the rule, so if we don't adopt it, no, you got 5 minutes to speak, and you will have no more, because I'm telling you now, if we want to move and be efficient, and that's the goal of this 5 minutes, then either we stick to the 5-minute rule, or we give a reasonable amount of time for folks to have back and forth. If a resident gets 3 minutes.
Councilmember Reed.
I'm sorry.
I'm just saying, I'm happy to stick to the 5-minute rule. My understanding is the mayor has a timing device up here somewhere, and if I had known about it, I would have been timing every single one. If I'd known how to operate it, I would have been timing every single one of us, including myself. And I'm very happy to set a timer on myself every time I talk.
Well, the timer would be that Okay, if we want to do the 5 minutes, the motion has been made and seconded. I'm also curious, does this, so staff can speak for 10 minutes, but a council member can only speak for 5?
We're discussing the rules on how long a council member could speak. We're not talking about how long. There are many times where we have the staff speak because they're giving us a presentation or they're being asked numerous questions.
So further, Councilmember Nguyen, I'm sorry, you did mention before that there needs to be a motion to reconsider, and that's because the committee has already adopted the slate of rules. So if you are going to reopen the book, it may be possible that you do need to reconsider in order to amend this 12.1.
We're not reopening the book. We never, this was not, there wasn't a motion made on this. We're not reconsidering anything. This is the motion is being made.
The agenda has already moved forward, actually, so R4 has already been done. It's old business at this point. But my point is that the committee has already voted to adopt all of the other changes that were previously adopted. There was actually a motion to adopt everything except specific ones. The committee went through and debated all of the specific ones. And so.
But there's no motion on this specific.
The book is now done. So I just wanted to point that out to the chair. There is a motion on the floor. If the committee wants to entertain it, but I just want to give that information to the chair.
And the motion is?
That we allow, that each council member has 10 minutes to get everything out on each agenda item. So if whatever the agenda item is, no matter how many motions, as it's written now, we only have 5 minutes on the item. So whether there are new motions made that would amend it, you get 5 minutes to speak on any agenda item.
Subject to the consent of the majority of the council.
Well,
so
all right,
a majority of the council would have to, if there's an objection, the majority of the council would have to vote to limit you to the 5 minutes.
Okay. Let's take a vote. I would recommend that we adhere to 5 minutes, and if people feel like they need more than 5 minutes, we can always change the rule then. But I like, as the mayor said, not making large changes, and doubling the amount of time is, in my mind, will lengthen our meetings and be inefficient for our discussion. Ms. Francelno, would you call the roll?
If I can make one last response to that, is that it.
Councilmember Reed, I asked Ms. Francelno to call the roll.
And she hasn't started calling the roll yet. All right.
Councilmember Kelly?
So we're voting on the motion to move it to 10 minutes?
Yeah.
Aye.
Councilmember Brayton, he's gone.
He's not here.
Councilmember Nguyen?
No.
Councilmember Burns?
No.
Councilmember Safferton?
No.
Councilmember Ravel?
No.
Councilmember Reed?
Aye.
Councilmember Fleming? Mayor Biss?
No.
I move for adjournment.
I'm sorry. Councilmember Nusma?
No.
No? Okay. Thank you. I didn't realize he was up there. Okay.
So what, can I move adjournment? No.
Would you like to move adjournment?
Yes, I would like to move adjournment.
Yes, second. We're going to let Dar call the roll. Do we move over? Yes. Dar is going to. Dar needs to call a roll for adjournment.
Councilmember Kelly?
Aye.
Councilmember Nguyen?
Aye.
Councilmember Nusma?
Aye.
Councilmember Burns? Councilmember Sufferton?
Aye.
Councilmember Ravel?
Aye.
Councilmember Reed?
Aye.
Councilmember Fleming? No. Mayor Biss?
Aye.
We are adjourned. Thank you, everyone. Thank you. Good night, staff.